Recording in progress.
Batiri batwa.
Good morning, commissioners. Oh, he's here. Oh, yeah. I was thinking they were going to look for you outside. Good morning, everybody. Good morning, everybody. Good morning. Good morning to the commissioners who are attending virtually. I understand the Premier of Northwest is also attending virtually. Premier, are you there?
Good morning, Justice Zondo. Good morning, other members of the Judicial Service Commission.
Good morning, Premier. Good morning. Welcome. Welcome.
He must switch on his video. We want to see his face.
Sorry?
He must switch on his video. We want to see the face of the Premier of the Northwest Province.
Well, somehow when you were speaking, I don't know, there was some interference. I couldn't hear everything you said.
I was saying he must switch on his video. We want to see his face.
Okay. Other commissioners who are attending virtually, are they there already?
Morning, CJ.
Morning. Good morning, Commissioner Malema. Good morning.
Commissioner Dodo.
Morning, Chief Justice. Morning, everybody.
Good morning, Commissioner Breitenbach.
Good morning, Chief Justice and colleagues.
Good morning, Commissioner Barnard. I'm told that Commissioner Shabangu Mdawe might still be driving to the place where she will connect online, but she will speak if she's already there and she can hear me. She's not responding. Probably she's not connected yet. I think she should be able to join us anytime. I think we should be able to start. From what I have been told, she should be able to join us anytime. Before the candidate is brought in, I just want to alert commissioners that after the adjournment last night, the Secretariat brought to my attention the fact that there is some complaint that is pending in the Judicial Conduct Committee against Judge Rogers and 9 other judges of the Western Cape Division of the High Court. That may have been what somebody was asking yesterday. I think the Secretariat wasn't aware of that, or they thought it had been dismissed. I think that what we'll do is the Secretariat would have prepared, or if they haven't prepared, they will prepare just a summary that tells us exactly what the state of affairs is, as well as what the allegations are. And then at some stage today, when everybody has had a look at that document, maybe we can have some discussion. Okay, thank you. You may bring in the candidate. Good morning, Deputy Judge President.
Good morning, Chief Justice.
How are you this morning?
I'm fine, thank you very much.
Thank you. I see you have no interest in knowing how I am.
I was about to ask. See,
No, that's all right.
yeah, but I can see that you are well, Chief Justice. I can see.
Before we start, let me just welcome the Judge President of the Northwest Division of the High Court, Justice Liu. She has joined us as she is required to. Welcome, JP.
Thank you, Chief Justice. Good morning to you.
Thank you. May I take this opportunity to do something that I should have done yesterday morning? Advocate Mpofu SC and Advocate Madonsela SC, who have been members of the JSC, are no longer members of the JSC. And I take this opportunity on behalf of all the commissioners to thank them for their service to the commission and their service to the nation. I thought I must just place on record that we thank them for their service. They have been replaced by Advocate Baloi SC and Advocate Pillay SC, both of whom we welcome. Thank you very much. Okay. Let's start. DJP, I see that in terms of your qualifications, you obtained a BLC degree in 1988 from the University, is it University of Pretoria?
University of Pretoria, that's correct, Chief Justice.
Yes, and in 1990, you then obtained your LLB from the same university.
That is indeed correct, Chief Justice.
Yes, and after that, you worked as a regional court prosecutor in 1990. In 1991, up to 1993, you worked as a state advocate, is that right?
That's correct.
And then you did your pupillage in 1993 from February to July. Is that right?
That is correct, Chief Justice.
And you started practicing as an advocate in July 1993, and you continued practicing as an advocate for 10 years up to April 2003.
That is also correct, Chief Justice.
Yes. After which you had about 2 terms of acting stints as a judge, and you were appointed as a judge with effect from the 1st of November 2003.
That is indeed correct, Chief Justice.
And that is in the same division where you are.
Yes, Chief Justice.
Yes. And you acted as judge president. I see here it says 1 June 2012 to 30 June 2012. So that was a month.
That was for 1 month.
Yes.
By then in our division, we did not have the post of a deputy judge president.
Yes. And then again in 2014, this time it was for a longer period, from 1 August 2014 to the 31st of December 2014.
That is indeed correct, Chief Justice.
And then also you acted as judge president from 25 July 2016 to 26 August 2016, and from 1 June 2017 to 29 September 2017, and from 18 April 2018 to 30 June 2018, and from 4 March 2019 to 14 April 2019. And you were appointed as Deputy Judge President with effect from 1 December 2019, and you continue to occupy that position. Is all of this correct?
That's correct. Only for one correction, I was acting Deputy Judge President for the period 1 June 2017 to 29 September 2017 and 18 April 2018 to 30 April 2018. Not acting Judge President, but
Yes.
acting Deputy Judge President.
Yes, no, thank you for that correction.
Yes, Chief Justice.
Thank you. So you have been a judge now for what, 18 years?
18 years.
Yes, in the same division.
Yes, yes, Chief Justice.
Yes. And you have been Deputy Judge President for about what, 3 years, 2 years?
For 2 years and 4 months,
Yeah.
permanently appointed, but there was also the 2 periods that I acted as Deputy Judge President for
Yes.
5 months.
Yes. Okay. And the division, Northwest Division, how is the mix of cases that it deals with, generally speaking, in terms of different branches, how much commercial law, more or less, there is, how much of other types of law do judges who are in that division get exposed to?
Yeah, because we are a small division, we do the whole range of cases that comes before court. There is no specialization. We do criminal as well as civil. There's motion, unopposed, as well as opposed motion, road accident fund cases, and civil trials.
And does the division have quite a lot of motion court?
Yes, with the increase in the jurisdiction of the division, with the adding of the other areas that were previously excluded, the workload increased. On average, the motion court roll per week is in the vicinity of ranging between 60 and 70.
Yes.
There were cases that it even exceeded and went over 100 for that specific week.
And at the moment, how many judges does the division have? Permanent judges?
With the creation of the post of Deputy Judge President, we are a complement of 7 judges.
Yes.
There are now 6 permanent judges and there's 1 vacancy.
Yes. And in terms of the responsibilities of a judge president outside of his or her division, are you familiar with those responsibilities insofar as they may relate to the rest of the judiciary in the province?
Chief Justice, the Judge President is not only the Judge President of the High Court, but the head of the Judiciary of the province. As such, even the lower courts, that is the regional and district courts in the province, resort under the authority of the Judge President.
Yes, and what does that authority entail?
The Judge President must oversee and monitor the performance of the lower courts, for example, and if there's any challenges, even attend to that, because as head of the judiciary, Any challenges may well be addressed to the Judge President. There is what we have in our province, and I think in other provinces as well, the PEEC, the Provincial Efficiency Enhancement Committee, where all role players come together in an attempt to resolve any challenges that may be experienced, especially even in lower courts. There may be challenges with regard to infrastructure and performance. There is, for the magistracy, there is a chief magistrate who is the head of the magistracy. For the regional court, there is a president for the regional court, but the judge president is the overall person responsible for the judiciary in the province.
The PEEC in Northwest, how is it functioning? Is it functioning well? How regularly does it have meetings?
Yes, it is functional. There was a period when during, was it a strict lockdown, that we did not meet, but after that, on 2 occasions now already, in December, that was the 4th of December, and the 3rd of December and the 4th of March, respectively. The PEEC met. I chaired that meeting, and I was deputized by the Judge President to be chairing the PEEC meetings.
The JP asked you to chair that meeting?
Yes, that's correct, Chief Justice.
Okay, all right. Now, the magistrates' courts and regional courts that are there in Northwest, that as Judge President, if you were appointed, you would oversee, how many magistrates' courts are there? How big is the job? How big is the judiciary in the province, more or less?
I don't have the specific number of magistrate courts and regional courts, but it's throughout the province, and the province is well accessible. These courts are well accessible throughout the province. I don't have the specific number, unfortunately not.
Yes. Apart from the PEEC, that I take it you would continue to lead in the province relating to the performance of all the courts in the province. Do you have any plans also of interacting with the various leaders of the district courts and the regional court to see what's going on in those courts? Do you have any plans, or will you be relying on reports that will be made to the PEEC?
No, I can't solely rely on reports being made to the PEEC, Chief Justice. I will endeavor to at least once a term visit these courts in order to establish firsthand what is going on. You can't just rely on statistics. You have to go and visit and see what is actually happening in these courts. So I intend to do the visits, but I have also a very good working relationship with the Chief Magistrate, Ms. Ikaneng. There is now an acting regional court president, Ms. Winnie Malani. I have also a good working relationship with her. And if there are challenges, I can be contacted and I can contact them.
Now, what are the current challenges in the division that you have identified, and what are the potential challenges that might arise in the future that will need to be tackled by by yourself if you are appointed as judge president in the division?
Chief Justice, in the High Court itself, we encounter a problem with space for filing. The records office have too many files, and a plan needed to be devised what to do with these files and how to store them. I engaged with the chief registrar, and he wrote a letter to the provincial archives, which is diagonally back opposite the High Court, for the storage of some of these old files. And one may ask, why are we keeping these files for so long? But some of the people, maybe they're convicted in criminal cases, may apply for leave to appeal after a considerable period of time. And then you still need the files. So that is in process. But in the interim, at the back of each courtroom, there is a consulting room, which can be under lock and key. What I asked the chief registrar and the court manager to do is that some of the files be stored there in order to create space in the records office where the clerks are working, because there are too many files. If we go on with modernization of the system and go to case line management, surely it will enhance, it will help with the problem that is currently facing, that we are currently facing in the High Court. There are also other structural problems like the air cons, water, and there is a problem with the generator at present. The generator is not working. I've asked the court manager what the problem is. They are waiting for a part from Germany. We have now in the last PEEC meeting discussed it, and it was decided that Public Works should look into it to replace the generator rather than wait for a part from Germany, and which may in any event be a costly exercise. So that is an ongoing process. It's on the log sheet of the PEEC, and I will get feedback with regard to that in due course.
And does the division have any challenges in terms of backlog of cases?
In terms of the norms and standards, if one strictly goes according to the time period set out, there are cases that are backdating to 2015, 2016, although they are not a lot. But these cases are given preference. When I do the pre-trial and come across a case such as that, I judicial case manage that case in order to get it ready, trial ready, as soon as possible. Now, what I plan to do in the future is, currently we have a system where myself are doing the pre-trials on a Monday, Tuesday, Wednesday. And in future, I want the 5 permanent judges to each one do not only pre-trials but case manage. And when a case is allocated to a judge, that judge is seized with that case. It must be on his separate role, if I may call it a separate role, so that he can case manage that case in order to get it trial ready. And only when it is certified trial ready, then it will come back on the mainstream, if I may call it that, back to the office of the judge president, where a date will be allocated. The judge that are seized with a matter, that are judicial case managing that matter, must also indicate how long will that matter take to be case ready, and that it must be constantly monitored. Furthermore, in the certificate, it must indicate how many dates or days should be allocated for the hearing of such a matter?
Now, cases that might have been pending since 2015, which is about, what, 6 years ago, 7
Yes.
years ago, are you going to make sure that those are all identified and something is done to make sure that they are finalized without delay?
Yes, those cases are prioritized, Chief Justice. I prioritize them. Allocate dates for hearing as soon as possible. I even do it in conjunction with the Judge President.
Do you know how it came about that they have been pending for so long? Is it because lawyers were not taking the steps necessary to ripen the cases, or why? Why did they
They are very,
take so long?
sorry, Chief Justice, yes, there are very different contributory factors. But the lawyers are, to a large extent, to blame. Because if you take, for example, the road accident fund matters, usually the reports are outstanding. That is the expert reports. And it takes time to get those reports. In some matters, the plaintiff will definitely comply, whereas the road accident fund will have a problem to appoint experts. Now, these cause the delays in the matter, in finalizing the matter, or even getting the matter trial ready.
Thank you, DJP. I'm now going to allow the Judge President to put questions to you. I think in terms of what has happened, or what happened in October, my impression is that the Judge President would be given more time to put questions to the witness, because obviously the Judge President knows a lot about the division. That's my recollection. I don't know whether anybody thinks differently. I think there is nodding. So, Judge President, let me give you the opportunity.
Yes, thank you, Chief Justice. Most of the questions have been covered by you as you interacting with DJP Hendricks. Good morning.
Good morning, Chief Judge President.
I'll get it difficult to call you DJP because I call you Ron all the time.
Yes.
Thank you. Already the Chief Justice has touched on your knowledge about our division.
Yes.
And it is correct that you have been, or for almost maybe the past 3-4 PEEC meetings,
Yes.
I requested you to go and sit. Initially, I was sitting with you at the
Yes.
PEEC, so you had to take over now.
That's correct.
Yes. Now, what are the challenges, main challenges that you identified with the, let me not talk much about the High Court itself, about some of the magistrates' courts in the province, especially if you look at areas like Garangua and maybe even Klerksdorp.
Yeah. Thank you, JP. JP, the most recent problem experienced, for example, in Rustenburg was infrastructural. There was a period when the contractor was appointed to remove the asbestos. Now, again, there was, the contractor did not do a proper job, if I may call it that. Then there was a health hazard, and the court was closed. Thereafter, the department approached the High Court to reopen. I could not, because this matter served before me. I was aware of it. It was in the PEC meeting. I then gave it to a colleague of mine to oversee. Now, the court was closed, but it was now, certain portions thereof was reopened. Now, there are structural problems that are experienced in courts like Rustenburg. The same applies to Garankuwa. Garankuwa has a problem with accommodation. There is not enough office space for the people to work in Garankuwa. There are also other problems like in Tlabani. There's a water problem from time to time. In Klerksdorp, I'm speaking under correction, but there is a process underway with the Department of Public Works to see to it whether they can renovate the building in Klerksdorp. There was talk in the past about alternative accommodation. Like in Rustenburg, for instance, there was talk about an old justice building that is now occupied by the police, but up to now it hasn't materialized. So most of the challenges, if I may call it that, are structural and to accommodate the staff.
Yes, if I may follow up on that, how are you going to address this problem which I couldn't address in my time related to our dependence on the Department of Public Works to do things for us? For instance, you remember for 3 days in the High Court, we did not have lights because they had not paid the account.
Oh.
So how do you hope to succeed in that field?
Judge President, the positive thing is that the latest PEEC meeting was attended by representatives from Public Works. Now, in the past, that was a challenge, as you know. Sometimes they would not attend. So these problems could not be addressed or properly addressed. I intend, and that is my plan, to not only deal with it in the PEEC, but to escalate our challenges through the correct channels to the higher authorities in order for them to comply with what they are required to do, even if one needs to write to the minister about it.
Last question will be, with the increase in the jurisdiction of the Northwest High Court, but with the number of judges not being increased, and with the policy that we have adopted of every judge doing, in other words, in a week, a judge would be doing motion court, a judge would be doing civil matters, even a criminal matter. In other words, we all share
Yes.
our work. Do you find that system preferable or workable?
Judge President, as you know, that it is very challenging because the workload is indeed at times overwhelming. It's not preferable that it work that way. It would be ideal if more judges can be appointed, seeing that the jurisdiction has increased. As you are well aware, pardon, ever since the dawn of our democracy, pardon, we have been 6 judges, a complement of 6 judges, from the old Bophuthatswana era. That is not, the number of judges hasn't increased, but the area of jurisdiction has increased now to include the whole province. So it is not ideal that we work on the system as we currently do. If we can have more posts, more appointments, it will indeed help and alleviate the problem. But I must say that, I admire the way that you keep the balls in the air, proverbially speaking, by rotating the judges. If there is but one good thing that came out of this pandemic, COVID-19 pandemic, it is the fact that we can do cases virtually. So if a judge is going on circuit, and it happened that the judge went on circuit to do criminal work, that judge don't only do criminal work, but if need be, that judge can, through virtual connection, also sit in opposed motions or appeals and reviews or admissions on Friday, and doesn't have to travel back all the way to come and sit in the main seat. What I plan to do is, with a place like Klerksdorp, in Klerksdorp, the workload has increased. With Klerksdorp being added, the workload has increased. Now, for the past few years, as you know, in Mokwasi, we have a motion court every second week on a Friday. That enhances access to justice. I intend to do the same in Klerksdorp. The judge going on circuit, it's not only going to do the criminal work, but also the unopposed motions every second Friday. The same can also apply to Vryburg, which is far-flung areas and far away from the main seat in Mabatu. So, yeah, that is my plans for the future.
Yes, thank you.
Thank you, JP.
Thank you, Chief Justice.
Thank you, JP. I will now allow members of the commission who wish to put questions to the candidates to do so. We continue to bear in mind the criteria, but we also need to acknowledge that the position is that of leadership. So I will now allow commissioners who, I'm sorry.
The Premier, Chief Justice.
Yes, I'm going to come to him, yeah.
CJ?
So, oh, I'm sorry, oh, the
The
Premier.
Premier first, yes.
Yes, no, I'm sorry. Premier, I momentarily forgot about you. Premier, you are still there?
Thank you very much, Chief Justice, and good morning.
Yes.
I have one question I want to put to Judge Hendricks.
Yes.
One is in the Northwest, how is he going to ensure that he nurtures and prepare for promotion, designated groups? Thank you.
Good morning, Premier, and thank you for the question. Premier, for the past 3 years or more, of the 15 candidates, the 15 acting judges that were invited, 8 of them were women. And I intend to build on this pool of women, in particular black women, being given an opportunity to act and to be exposed to and maybe take up later appointment. I've been involved in mentoring acting judges for the past 17 years, most of them women. Some of them are even permanently appointed. So I intend to build onto and expand the calling of women, because in terms of the criteria and the guidelines, not only the racial component but also the gender need to be promoted. So I intend to call more black women to come and act.
I know, Premier, you
Thank
said you had one question.
Yeah,
Is
thank
that
you,
it?
Chief Justice.
Or?
Yeah, that's it, Chief Justice. Thank you very much.
Okay, thank you. Minister?
Yeah, thank you very much, CJ, and good morning, Deputy Judge President.
Good morning, Mr. Minister.
Yeah, my question relates to what is your leadership philosophy?
Yeah. I have taken an oath of office to dispense justice without fear, favor, or prejudice. There's a constitution, we are in a constitutional democracy that guides us. There's also the Superior Court Act, and there are the norms and standards. My philosophy is to dispense justice without fear, favor, or prejudice.
And what will be your view on controversial and sometimes high-profile matters that will obviously come before the division? As the leader of the division, will you lead from the front, or you will just leave them to whoever is available on the roll?
Certainly not, Mr. Minister. In the past already, there were controversial or very important matters that came before court. I was assigned to do it, and as a team player, I will definitely play my part and also take on these very controversial and very complex matters.
Yeah, and last one is with regards to the point you responded to the Chief Justice on modernization.
Yes.
And case line, where you said that if case line could come, it could really help. So I want to know what then will be your role to ensure that you do at some point implement this case line and also modernize the platforms that you use to enable you to administer or dispense justice effectively. And what has been your role all along to bring this case line to the PA? Because if my memory serves me well, the pilot project that was in Gauteng was also supposed to be in the Northwest. So what has been your role in this modernization project?
Thank you, Mr. Minister. The pilot project was supposed to be rolled out also in the Northwest. The help desk, if you can remember, during my interview for the position of DJP, I was asked specifically this question. The help desk has been set up there, and it was supposed to be rolled out, but it never came, to fruition. I intend to implement it, to get it from the ground. What happened is not only myself, but all the other judges attended the case line program that was offered in Gauteng. So I intend to implement it and to have it up and running. But there are certain challenges. We need the infrastructure. We need to have the computers. We need to put up what is necessary in order for the program to run. So perhaps with assistance from the Office of the OCJ, the IT department, it can be implemented.
Thank you, CJ.
Thank you, Minister. Commissioner Nyambi.
Thank you, CJ. Morning, DJP Hendricks.
Good morning.
I'm on your right.
On the right.
Right close to
you. Sorry. Good morning, Commissioner. And how are you?
No, I'm fine.
Thank you.
I remember you for your involvement in the groundbreaking finalization of the case involving the murder of Francis Rasool.
Yes.
we're still experiencing that problem. That's the unfortunate part as a country today, the killing of beautiful women and children. How will you describe the experience of having been involved in such a high-profile case and its relevance to the administration of justice?
Thank you, Commissioner. Commissioner, gender-based violence is a reality and something that we are faced with and need to deal with decisively through the criminal justice system. Yeah, my personal experience, if that is the question with regard to the case, it was, and I still regard it as a groundbreaking case. It was different from your ordinary, if I may call a murder case ordinary, but was not a straightforward case. Was the first case of its kind where a person, the policewoman, was murdered and the remains could not be found. And fortunately, but years afterwards, the remains were discovered. So yes, the feeling was I contributed to the jurisprudence, especially as far as that is concerned, because it was one of its kind where a conviction was based on circumstantial evidence alone. And there is no word what happened to the deceased at the time when the trial was still running.
Thank you. My last question. The GCP knows that during your acting stint as a judge president, you were able to reduce the lifespan of cases on the roll through innovative measures. If you can share with us how you were able to do that.
Yes, thank you, Commissioner. In 2014, there was a backlog with regard to appeal matters. Now, we were a complement of 6 judges. I constituted every Friday 3 appeal courts of 2 judges each. And if it's a full court, as it is now called, of 3 judges, then I constitute 2. And I increase the number of appeals so that it could be finalized more expeditiously. That can be taken as a yardstick, as a measure, how to deal with cases and to deal effectively with them in order to finalize them as expeditiously as possible. It is unfortunate that I have to refer back to one of the previous letters of support by one of the acting judges then, Matlapeng. He specifically wrote and said that it is then that he observed the traits of me being a true leader because of the working down of the backlog. We worked very hard because we are a small division, but we worked very smart in order to achieve our goal.
Thank you, DJP Hendricks. Thank you, CJ.
Thank you, Commissioner. Justice Betzer.
Thank you, Chief Justice. Good morning, Deputy Judge President Hendricks.
Good morning.
I only have 2 questions for you. The one relates to the nature of the work that judges in your divisions do. Do you also have any company-related cases, such as liquidations and business rescue cases?
Yes, is it Deputy President? No? Betsy?
Yes, it is.
Yes. Yes, thank you, Deputy President. We do have liquidations and sequestrations on a weekly basis. Some are unopposed, some are opposed. So we do have commercial matters, yes.
Thank you. Then the second question relates to, case management, which would be one of your focal points if you were to be appointed as judge president. You did say earlier on that you have devised a system whereby you allocate cases to each judge for case management to ripen them for trial and eventually disposal. As the head of the court, would you accept that you would then bear the final responsibility to see to it that things go the way they should?
Yes.
That is, you would monitor the progress of the cases that you allocate to your colleagues for case management.
Yes, yes, definitely. If I may just repeat myself and make myself a bit clearer. Over and above the allocation of these matters to each and every judge for not only pre-trial but case manage it and get it trial ready, it comes back into what I call the mainstream, back to me, back to the office of the judge president, in order for it to be allocated a date for trial and to manage it. Yes, it is at the final analysis. At the final instance, it is my responsibility to ensure, as judge president, that cases run smoothly in the division.
Thank you, Deputy Judge President.
Thank you,
Thank you, Chief Justice.
Deputy President.
Thank you, Commissioner Makwanishe.
Thank you very much, Chief Justice. Good morning, DJP Hendricks.
Good morning, Commissioner.
There is this challenge of prisons that are overcrowded.
Yes.
And part of the problem is that people who cannot afford a bail of 1,000 rands and less. And we do think that the judiciary has a role to play. What do you think would be the role that you would play as the judge president if appointed?
Thank you, Commissioner. One needs to look into why the accused person can't afford bail and whether such a person cannot be released either on warning in order to alleviate the overcrowding of the prisons, especially for your minor crimes, your not so serious crimes. The magistrate can look into it. That is an issue that can be taken up with the magistracy.
Will you have a program around it?
Yes, it can be one of the items that can be addressed with the magistracy, because I'm also invited from time to time to what is called a district efficiency enhancement committee as well as the regional efficiency enhancement committee. These are the committees of the district and regional courts dealing with challenges. And that can be one of the items that can be addressed in that specific forum.
You said in your response to the Chief Justice that since 1994 or even before 1994, you only had 6 judges in your division.
Yes.
And the workload has increased considerably since then.
That's correct.
And I would suspect that part of the challenge would be the wellness of judges, because
Yes.
if they are working under tremendous stress.
Yes.
What is your vision around it? How are you going to ensure that the wellness of your judges is taken into consideration?
I know from the past that through the office of the Chief Justice, and I think Judge President Musi was tasked with it, with a wellness program for judges. And I would conscientize the judges about this program. And because we are so few, we see each other on a daily basis. And if a judge is not well, that judge will definitely inform me what is his or her condition, and something can be done about it. One can work around a workload even to be allocated. It happened in the past when judges were not well, that we work something out around to get around a problem.
Two quick last questions, Chief Justice. As a DJP or as a judge, have you ever visited any of the prisons in your division?
Yes, I visited the Rooigrond prison. There's also a prison in Mafikeng.
Are you going to encourage other colleagues, even the magistrates, to do the same?
There was a system in place years ago where judges would go on, that goes on circuit, would visit the prisons in the area. For instance, in Rustenburg, if you have a circuit in Rustenburg, Mokwasi, then you visit Mokwasi prison. But somehow that has died down. But that can be revoked and be re-implemented in order to visit. I know there is a judge appointed as a judge of inspector of prisons that goes around prisons and so on. But we can assist in that regard if there are challenges, to bring it to that judge's attention and also to the minister if need be.
The last question, do you have any outstanding judgments?
No. Outstanding judgments that was reserved when I have filled in the application, that is the 29. Those two has been handed down. But yes, there is one matter, which is a very involved matter, consisting of over 4,000 pages. It has to do with expropriation. That judgment was reserved and heads of argument had been forwarded. That is the only outstanding reserved judgment that I have and that I'm busy with.
Thank you very much, Judge Hendricks. Thank you, Chief Justice.
Thank you, Commissioner.
Thank you, Commissioner. Commissioner Dodovu.
Thank you very much, CJ. Good morning, Justice Hendricks.
Good morning, Commissioner.
Just few questions. The first one relating to the objection against your appointment.
Yes.
It will seem that this objector has objected all along throughout when you applied to the JSC.
Yes.
Is that correct?
That is correct, Commissioner.
Yes. These allegations that he's putting forward here, are they the same allegations that he put in the past? If not, if they are new, can you respond to them, please?
Yeah. They are not what the previous objections was. If you can remember, during my interview in 2019, it had everything to do with a meeting that was held by the judge president in my absence with his former principal about his conduct. And that was what was the gist of the complaint at that stage. Now it has changed. You have, I'm sure that you have read through what his complaints are. In the main, he complains that there's a matter that was on the unopposed row. And because, pardon me, because there was a notice of intention to oppose. Pardon me, there's something wrong with my throat.
Take it easy.
Yeah. Because there was a notice of intention to oppose, I postponed the matter to allow the other side the opportunity to file an answering affidavit as well as the applicant to file a replying affidavit and heads of argument. That is the normal course of how it happened when a matter becomes opposed. Now he complains that I was deliberately postponing this matter when it was trial ready. When in that matter, it was done virtually. The counsel who appeared, Leshilo, he did not file what we have in our division, a practice note, so that the virtual link could be sent out. Now, if you look at the order that was granted, there's no prejudice whatsoever that was suffered. The matter was postponed to the opposed row, and there was no adverse cost order made.
Okay, thank you. The next question, you applied for a leadership position as the head of Judiciary in the Northwest.
Yes.
Let me tell you what people think about the judiciary, especially the high courts. That matters get delayed, the quality of judgments are not okay. You sometimes judges use combative language when they in their judgments, and the problems that you mentioned about infrastructure and modernization of the courts. What could be your specific contribution in helping to resolve some of these challenges?
Thank you, Commissioner. Commissioner, if you look at the nomination letter, the nomination by my fellow judges, they defer to the managerial skills as well as the leadership qualities. And they specifically mentioned not only that I mentor the acting judges, but when they write judgments, they come to me for guidance as a senior judge. And I invariably supply them with advice on how to go about without imposing my view on it. The independence of the judge needs to be respected. But when it comes to maybe the tone or the language that are used, one can, as the judge president, point out to the acting judge or judge that this is not how we write judgments, and that is where the mentoring came in. That is what I've been doing for so many years now.
Thank you. Just the last one, CJ. Northwest is a traditionally entrenched province where traditional leadership is very, very strong. And I'm aware that there are lots of cases pertaining to the disputes around the traditional leadership. How can you enhance your court in terms of its capacity to deal with such cases?
First of all, to have, and now I'm going to say something a bit controversial, to have competent judges who to deal with these matters and understand them. You must have some knowledge about it and some exposure to it in order to deal with it. Going back a bit, I mentioned specifically that I intend to have a pool of women judges, but mostly black women judges. And if they can understand the tradition and how these courts function and work, and it will definitely enhance.
Well, thank you very much, CJ.
Thank you, Commissioner. Commissioner Singh.
Thank you very much, Chief Justice, and good morning, Judge.
Good morning.
Good to see you again.
Good morning. Thank you, Commissioner.
Just as a follow-up to Commissioner Dodovu, you spoke about tone and language, and yes. I can remember in one of the interviews, you said that one of your potential weaknesses could be lack of patience. You said it yourself. Yeah. How has that developed now over the last 5 years?
Thank you very much, Commissioner. You are absolutely right. Once again, one have to look at not only what you say about yourself, but what other people say about you. And if you look at the GCB, the General Council of the Bars, their comment, and they even address the fact that I may well be firm, but I have the necessary respect and patience, and I have developed and improved the patience over these years.
No, thank you for that. Then on the question of traditional leadership, there have been comments in the past by certain academics who write about land matters and traditional leadership, that perhaps, and I'm not using the exact words, that you are a bit soft on traditional leadership when it comes to adjudicating matters where they are involved in, against communities who have rights. I think you remember those articles written in the past?
Yes.
Yeah. What can you say to that aspect?
No. To be quite honest, Commissioner, I with regard to the articles itself, I said it categorically because there were some innuendos, if you can remember correctly. I said it categorically, there is no innuendos to be drawn. And it specifically relate to a specific tribe and specific persons involved. And I vehemently disagreed with that.
And you still disagree?
I still disagree.
Okay, thank you. Then the last question is on judgments, reserved judgments, and I note that the two that you listed here have been delivered.
Yes.
But one relates to medical negligence.
Yes.
What are the incidences of medical negligence cases that come before your courts there? And what is your view, and I think the Minister and the President recently had a conference about this, what is your view about these trials that go on and on and on, and after years and lots of money, which costs the state and the litigants, then the matter is settled out of court? What advice can you offer on cases of medical negligence? Because I think one of the biggest contingent liabilities that the state has is medical negligence cases, like land claims cases and probably RAF cases. So what advice and views can you offer in that regard?
All depends on the expert reports and joint minutes that are filed by the experts. Perhaps in the joint minutes, if the issues are so narrow, the settlement may well come at a much earlier state, which will be much more cost effective at the end of the day. So that is one of the aspects to be looked into. Rather than to drag out this case and let it run for a considerable period of time, and at the end of the day, it is settled in any event. The basis for settling these medical negligence cases is based on what is the evidence, the expert evidence that are before court. And if there are joint minutes by the experts on certain of these aspects, surely that the settlement should be looked into much earlier.
This just to follow up, this particular case that was cited here as reserved judgment, would you have any idea of how long it took for the matter from the time it started until judgment was delivered?
The period that it was reserved?
No, we see the period it was reserved for, but from the time the matters came before court until a final judgment.
I'm speaking under correction, but it lasted more than 3 years.
Yeah, see, that's my point, Chief Justice, that these medical negligence cases just drag on and on at great cost to South African taxpayers and to the state. And I think the initiative by the Minister and the President to look at these matters of how you deal with medical negligence was a wise one. But thank you for
I
that.
agree. Thank you.
Thank you, Chief Justice.
Thank you, Commissioner Singh. Commissioner Matolo Lebu.
Thank you, Chief Justice, and good morning, DJP.
Good morning, Commissioner.
Thank you. Mine is just an inquiry.
Yes.
The issue of Rustenburg Court.
Yes.
a lot of practitioners actually complain to the LPC about the issue of access to justice for ordinary men in the street. If the Rustenburg court is closed,
Yes.
what I want to know from you is how do you intend preventing such a thing or making the public aware if such an incident happens? Okay.
Yes. Thank you. Commissioner, what happened in the Rustenburg, with the Rustenburg court is, after its closure, there was notification sent out. There was, the public was notified that the court is closed. It wasn't closed for a very long time though, but it was at a great inconvenience to the public. There were attempts made for alternatives, either at the Rustenburg Traffic Court or at Labani Court or even the Civic Center that was also proposed. Now, these are structural problems. And fortunately, we could work around it so that the court could be reopened, although certain portions thereof were closed to the public for safety reasons. This is within the domain of public works, if it relates to the previous questions posed by the Judge President. Public works bears the responsibility to ensure that these courts are properly maintained. And if they are not doing their work, as I said previously, we need to address the challenges as and when they arrive.
Okay, thank you. Another question from you is that the last time we interviewed for Northwest positions, I remember the JP complained about lack of pool of black women coming to act. And I heard you saying to the Premier, one of your plans is to have a lot of black women acting. Where are you going to get the pool? And is there enough pool that you have already earmarked?
Thank you, Commissioner. First of all, yeah, there is a local bar, and there are members at the local bar. And already 2 members, black women, were given an acting opportunity. The invitation was extended to another one, but she was unfortunately not available. The Judge President then went outside to look for women. Now there are women that acted, black women, and currently still act. We sourced them, if I may use that word, from the Pretoria area. Now, there is Advocates for Transformation, and there is other bodies like the General Council of the Bar that can be approached to ask them to make available black women to come and act, and to have a pool from which we can source women, in particular black women, to come and act.
Okay, thank you, CJP. Chief Justice.
Thank you, Commissioner. Judge President Lehori.
DJP, good morning.
Good morning, JP.
I must blame you for causing me to be here, because if you are not here, your Judge President would be sitting here. And I would be in Bombela, perhaps busy with my reserve judgments.
Yes.
A good interpersonal and collegial relationship is actually everything in any leadership position. Would you agree?
I do.
Yeah. And you are a small family of about 7 judges. I take it you interact with each other quite very often, and probably you are holding meetings as colleagues and workshopping each other from time to time. Is that what is happening there?
That is correct. We even meet on a daily basis, except for when some of us are out on circuit court.
But we should also accept, especially when you are in a leadership position, that you need supporting staff, and many of the supporting staffs are appointed in consultation with the head of court in terms of Section 11 of the Superior Courts Act. And for a proper function institution, you need to have good officials. And as a leader, sometimes you need to know your officials, and not only to know them, they need to know that you care about them. What role do you play in actual fact to encourage officials to understand that without them we are nothing?
Well, I do have good interpersonal relationship with the staff. Not only the court manager, the chief registrar, but all the staff members. And that is indeed one of my strong points, to have good interpersonal relationship. We need it in order to work together for the good of the division. And one can, from time to time, especially with the leadership of the support staff, have regular meetings in order to address challenges. Now, if we have challenges, the court manager is called upon, and we have a good working relationship. Let me make an example. When we were busy with the revamping of the High Court, we worked together, because the judge president then asked me to oversee and be part of the team that works with to revamp the High Court. So we have a good working relationship, JP.
And I take it that caring spirit, to a certain extent, is extended to those who open windows for us in the morning for fresh air, and those who are cleaning the surrounding for us to have the place more accessible and look better.
You have my word on it, JP.
You have always struck me as a modest and humble person, and I envy you, and I wish I was just like you. Thanks, Chair. Thank you.
Thank you very much for a compliment, JP.
Thank you, Commissioner Moimang.
Thank you, Chief Justice. Good morning, DJP.
Good morning, Commissioner.
Just two questions from my side. The first one is just building on the issue of traditional courts that was raised by Honorable Commissioner Dodovu. Northwest is unlike how it has the dominance of traditional leaders. It has a traditional house.
Yes.
And the discussion on the passing of the Traditional Courts Bill, he hit a snag at the National Assembly last year because there was an issue around its constitutionality. So while that matter is still being processed, I'm more interested in terms of whether, in terms of your plans, has there been any judge assigned to specifically interact with the traditional courts, so that in preparation for the passing of the Traditional Courts Bill? That's the first one. Now, the second one relates to the the method that you dealt with the Nakamudri Mulema district versus the chairperson of the Northwest Provincial Executive Council. I'm more interested in terms of in exercising your discretion, what grounds or what factors did you take into account to refuse to grant the interdict by the Nakamudri Mulema? I think key to my point is that there are three spheres of government: national, provincial, and local, that are separate, distinct, but interdependent. So in a situation where those powers are usurped, the only recourse that the municipality will have, particularly when there's a suggestion or a case to suggest that the act on the part of the provincial government was unconstitutional, was not in line with the values that's enshrined in the Constitution around accountability, oversight, and also the rule of law. What would be your guiding factor in that kind of situation? Thank you, Chief Justice. Thank you, DJP.
Thank you. With regard to the first question, Commissioner, whether a specific judge is assigned, no. The answer is no. There is no specific judge assigned as yet. I plan, if the Act comes into operation, that a specific judge can be assigned. I don't foresee any problem with that. With regard to the second question, with the Nyaka Mudiri Mulema, what happened in that case is the councillors, there was a decision that the councillors, that an administrator be appointed, and the administrator should take over. And the councillors came to court to oppose the appointment of the administrator. Now, that is the crux of the case, whether they had grounds, justifiable grounds, to oppose the appointment of the administrator, which I found they did not. But at the end of the day, it was not only, as they put it, that they will suffer prejudice because they won't earn a salary. What was more important was the delivery of service to the people. And the appointment of the administrator was justified.
So just a follow up on the first one. There was a matter between the Bakata Bakafela and the Communal Property Association around a land that was restituted to the Communal Property Association. I don't know whether does that ring anything to your mind? The reason why I'm raising it is in line with the point that I raised earlier on, to say it is important that attention is paid to the role of traditional courts. Because in that matter, the traditional leaders thought that they have a free ride in terms of land that are restituted to the communities because they are traditional leaders.
I speak under correction, but subject to correction. I think that matter is still pending. It's not yet finalized.
No, it was finalized. The Court has pronounced on that matter.
Oh, okay.
Thank you.
And I'm not aware. Thank you,
Thank you.
Commissioner.
Thank you, Chief Justice.
Thank you, Commissioner. At this stage, I would like to go to the commissioners who are attending virtually. Commissioners, is there anyone who wishes to put questions to the candidate?
No question from me, Chief Justice. Julius.
Thank you, Commissioner Malema.
Morning, Chief Justice. Yes, it's Glynis Bradenbach. I have questions, please.
Yes, thank you. Go ahead.
Thank you. I must declare upfront that I do know DJP Hendricks, and good morning, DJP Hendricks. How are you?
Good morning, Ms. Breitenbach. I'm fine. Thank you for asking. And how are you?
I'm fine, thank you very much.
Yeah.
I've known,
So I see you ask her how she is.
Yeah. I mean no offense, CJ.
Please go ahead, Commissioner Breitenbach.
thank you, Chief Justice. Judge Hendricks, you have suggested that to broaden the pool of prospective female judges, provincial workshops for lawyers and legal academics should be held, where attendees would be informed of what the work of a judge entails, and practical experience and guidance could be shared. Have such workshops been held to your knowledge, and if so, how many and when?
No, the workshops haven't been held, but I intend to hold such workshops and invite role players to come and attend and to assist.
Okay, and then my final question is, under what circumstances or what are the factors that you think a judge should consider when deciding whether or not he is conflicted and whether or not to recuse himself in a matter? Thank you.
Yeah, it all depends on whether the judge has, first of all, personal knowledge of the matter beforehand, and whether if he is conflicted, then in such a case, the judge must recuse himself.
Thank you, Chief Justice.
Thank you, Commissioner. As Commissioner Shabangu Mdawe joined us virtually, I was told earlier on she was on her way.
Morning, CJ. I'm here. I think I'll ask my question after Commissioner Barnett.
Okay. Commissioner Barnett, why do I think you had indicated you had no question?
In fact, my hand has been up, Chief Justice.
Oh, okay. I'm sorry. Please go ahead.
Thank you. Thank you. DJP, good morning.
Good morning, Commissioner.
Yes, I'd like to ask you, let me make a statement. Leadership is to create a inspiring vision of the future, to motivate and inspire people to engage with that vision. So my first question is to ask you to inspire the Commission. I mean, bearing in mind Rustenburg, the problems have been mentioned there about the court and the challenges you've spent. So I'd ask you to inspire the JSC that in future under your leadership, Northwest justice will shine. That's the first question, please.
Yes. Thank you, Commissioner. Once again, I need to refer to the comment that were made. First of all, by the GCB with regard to my skills and ability, my leadership qualities, but also my colleagues. And I think that perhaps you were furnished with a copy of what was written by my colleagues. And I do have the support, and they even defer to my leadership. That being the case, it means that there is unity in our division. And with unity and collegiality, working together, we can achieve much more. I visualize a situation where, as a team, we work together to enhance the access to justice and the speedy resolution of disputes, and that we as a division will grow and will deliver justice to all our people.
Thank you. And then also on the digitization and just the use of modernization technology, you mentioned two specific areas or challenges. The one is that, or one thing that you said you could do monthly visits or at least per term, you could do a visit to the various jurisdictions. And I just want to ask, it's a two components to the question. So first, just as far as the court visits are concerned, do you think there's a role to play for, keeping virtual contact as well? So having maybe more frequent discussions with local courts or personnel at the local courts or presiding officers, etc., by way of the virtual platform, other than just once a term? And then secondly, as far as the storage problems are concerned, and you mentioned that you've actually taken some initiative as far as setting in place the arrangements with the archives. But once again, is digitizing the storage process not a possible answer for the future? I mean, case lines will sort out future, but we're talking now about the storage of the historical documents. Thank you.
The answer is definitely yes, Commissioner. Virtual, we can have more often meetings and discuss any challenges that may arise, and we can do it more often. The same applies to the digital storage and the modernization of the courts. If we go digital with this case line, we will definitely have a positive outcome. And that may happen sooner than what we anticipate.
But the digitizing of documents that are already existing, pre-case lines, there is a possibility to perhaps scan and store documents on that basis. It makes them easier accessible as well to practitioners or litigants and so on.
That can happen. It is not impossible. It's though it may well be a tedious exercise and it may well be expensive, but it can happen. It's possible.
Thank you very much. And in closing, I just want to say that I, for one, I'm glad to hear that the remains in the Nkuna matter were found, in the sense that, I was wondering whether you ever had any doubts during that trial before doing a very well-written judgment on and the finding there. But that's not a question, it's just a comment. Thank you.
If I may react.
Yes, you may.
I also receive calls from people who ask me, what will happen if she appears, if she resurfaces? And I was so convinced that having regard to the circumstances, surrounding circumstances, that she was no longer with us. She was no longer alive.
I must say, at the end of your judgment, I was convinced as well. So,
thank you very much, Commissioner.
Thank you, Commissioner Shabangu Mdawe.
Thank you, CJ. Good morning, DJP.
Good morning.
DJP, we are applying for a leadership position, and during the February interviews, it transpired that the judiciary does not have harassment policy, sexual harassment policy. I'm wondering if your division does have something to deal with sexual harassment. If not, how are you intending to deal with this problem?
Thank you, Commissioner. Sexual harassment, there must be a policy in place as far as sexual harassment is concerned. But we don't even need to have a policy in place as such. That is a criminal complaint at the end of the day. But if there is sexual harassment brought to my attention, I will definitely deal with it. I will attend to it and deal decisively with it. There is no room for sexual harassment in a workplace, especially in the judiciary itself.
Have you perhaps ever come across to such complaint in your division?
No, fortunately not.
Okay, thank you. My second question, DJP, I don't get you clear regarding the creation of the pool of women where you will get maybe acting judges. When you responded to Commissioner Breitenbach regarding the workshop that you planned. You said it hasn't taken place, and you did not indicate as to how soon are you intending to have it. And you also mentioned that you are mentoring acting judges. My question to you is, do you perhaps have any program that you are participating where you are mentoring young women who are intending to enter judiciary, who are not yet in the judiciary?
There is a work in progress with regard to the universities, the Northwest University, where the mentoring and especially of young students, women students, are happening. One of my colleagues is involved there, and I intend also to participate. I don't have a problem to convene a workshop as soon as possible in order to groom and to help with the mentoring of especially Black women. There is a number of bodies out there that can be approached to make members available for such a workshop. And if I am appointed, I will definitely prioritize such a conference.
Thank you, DJP, and thank you, CJ.
Thank you, Commissioner.
Thank you, Commissioner. Commissioner Lucas.
Chief Justice, I'm terribly sorry, it's Clarence Breitenbach. May I have a follow-up on that question, please?
You wish to do a follow-up question?
Please, on the...
Okay, all right. Please go ahead.
Thank you. DJP Hendricks, you say you have no problem in arranging this workshop as quickly as possible. The first time you discussed this issue was at your interview in 2017. Could you be a little more specific about precisely when they're going to take place?
I think the question relates to after my appointment as a judge president.
Well, I understand the question to be, and Commissioner Breitenbach will tell me if I misunderstood her question. It seems that there was a discussion in 2017, and it seems to be implied that at that stage, the contemplation may have been that the workshop was going to happen, and she seems to be saying, well, it's taken long, so when is it going to happen if it has taken so long? But my understanding may be wrong.
Yeah.
No, you're perfectly correct. Thank you, Chief Justice.
Yes. I don't foresee any difficulty in having this conference constituted, Commissioner. It is the prerogative of the judge president still to have such, to convene such a conference. And I will definitely take it up with the judge president. And I thought that you want to know when I become the judge president.
No, that's what part of what she wanted to know. I think the follow-up was simply that it hasn't taken place over the time.
Yes.
But obviously, you were not judge president. But
yes.
The discussion, what she said, seemed to imply that based on that discussion in 2017, she expected that it would have happened. But I guess you have explained.
Yes. Thank you, CJ.
Okay, Commissioner Breitenbach, are you covered?
Yes, thank you, Chief Justice.
Okay, thank you. Commissioner Lucas?
Thank you, Chief Justice. I've been covered in many of the issues, about 2-3 that I wanted to ask, but there is one that is outstanding. Good morning, TGP.
Good morning, Commissioner.
I've been deployed to Northwest in another capacity, and I've noticed that Northwest is a very vast province.
Yes.
Might wish to raise your voice a little bit,
Yes,
Commissioner.
So, what I'm saying is that I've noticed that Northwest is a very vast province, particularly since the time that I've been working there.
That is correct.
So I was just interested because the region that I am deployed to is Ruth Segomotse Mempate,
Yes.
and it's stretching from Kagisano Molopo in the almost southwest up to Lake Watimana.
Yes.
That is totally more to the east. I was just wondering, with regards to court services, how are, particularly because we only have Vryburg as a seat, and I don't know how you are stretching yourself across that area. So I was just interested to know how, in the circumstances that is prevailing, you are making sure that all people, particularly the rural people, have access to court services. Thank you.
Thank you, Commissioner. Yeah, the main seat of the district court for that area is Vryburg, and that serves that area. There can be in future, and that may well be one of the plans, to have periodical courts in the more far-flung areas. That will help and assist with access to justice. But on the point that I made earlier, now that we are almost used to, after this pandemic, to do things virtually, it may well be of assistance that we can have a place identified where the litigants can go to and connect virtually and be assisted and have access to justice, rather than to travel long distances to where the seat of the court is. That possibility can be explored. There is also the possibility that in some of the areas there are what you call the word escaped me now, but there may be a possibility to create a place where we can do it virtually.
Yeah, Khanyesa, for instance,
Yeah.
you've got almost 20,000 inhabitants in that specific area, but then you also have Bray.
Yes.
That is almost more than, I think, 80 or more than 100 kilos from Khanyesa. It's exactly the reason why I'm bringing it to your attention if you haven't yet thought about it, but there is definitely a potential, but there is also a challenge. Thank you.
Thank you, Commissioner.
Thank you, Commissioner Schlemmer.
Thank you, Chief Justice. Good morning.
Good morning.
DJP.
Good morning,
I
Commissioner.
would just like to know from you, it seems like some of the things that you said indicates that there are budgetary challenges as well.
Yes.
To what extent do you think that the Superior Courts Act, specifically section, I think it's 54, let me just double check, section 54, can assist you in looking into the budgetary challenges and lobbying, if I can use that word, the CJ and the Minister in doing something about it?
Yeah, I think when faced with all these challenges, there are budgetary constraints. You are perfectly correct, Commissioner. And to approach the Minister to assist, and also the CJ, to make funds available in order to enhance access to justice.
In general, financial accountability is kind of also part of the role of the JP in a division. So to what extent are you planning to look at where the problems are and to determine what sums of money you would need so that you have something to talk to the CJ about?
There is the regional office that is responsible for the support that is lent to the judiciary. And there is a budget, I'm aware that there is a budget. And if need be, there can be submissions made in order to increase it.
Thank you, sir. I do think that the Superior Courts Act makes it more possible nowadays for the leadership of the courts through the Office of the Chief Justice to do something about the budgets. So I would really urge you to make sure that you do.
Yes, I will endeavor to do so, especially in this trying economic times that we are experiencing in the country.
Thank you, sir.
Thank you, Commissioner. Commissioner Tsepe.
Thank you, Chief Justice. I think I should listen to Commissioner Matolo Dlepu, and tomorrow I'm going to wear a bright red dress, Chief Justice, so you can see me.
Well, she's not wearing the white. She promised to wear it.
Good morning, DJP.
Good morning, Commissioner.
DJP, I have a follow-up in respect of a question that was asked by Commissioner Shabangumdawe, but then I have another question. And it relates to, my follow-up relates to your answer on sexual harassment policy. You said something that concerned me a bit, that we don't need a sexual harassment policy, if I did not understand you. And I just wanted us to be clear, because a sexual harassment policy is not just, it's also for possible victims to know how they deal with sexual harassment cases when they have experienced them. And that part of the problem with not having them may be why you don't receive complaints, because people don't know how to deal with them. I just wanted us to be, if I misunderstood you, for you to clarify that.
Let me be emphatic. I said you don't need to have such a policy in order to do something about it. I did not say that such a policy is not necessary. It is indeed necessary. But it is the sexual harassment, in my view, is of such a serious nature that it should be followed up, and something need to be done about it.
Thank you, DJP. I just want us to be clear that it is, we do need it.
Yes.
So that a commitment on your part, were you to be appointed, that in your division, or at least in the Northwest, we will have a policy of that nature. I think that's
Definitely, definitely, you can rest assured.
Thank you. Thank you, DJP. My question relates also to the issue of acting appointments, and in your interview in 2019 for the position as DJP, and you've repeated here that it is a prerogative of the JP how to appoint acting judges. During the interview process of the Chief Justice, we received feedback from law bodies, and one of the concerns they raised with appointment of acting judges was transparency of the process, and in some instances, criteria. And I just wanted to find out from you what your view is on that, and whether the process that is used in the Northwest, whether it's a transparent process, and whether there is a criteria, or whether you think the judiciary as a whole should actually have a more transparent process and a transparent criteria in respect of appointment of acting judges, because we create a pool of judges from this process. Thank you, Deputy Judge President.
Thank you, Commissioner. Yes, most definitely there must be criteria and for the appointment. However, much depends on the experience and the exposure of some of the aspirant acting judges. You may find that the briefing pattern is still a problem, And some of the council are not yet briefed, don't get briefs and doesn't appear quite often in your court so that you can assess and even invite such a person to come and act. And it creates a challenge at the end of the day, not because of the making of the person, but because of the circumstances. So people need to be exposed to more work of substance. And in that regard, it will enhance even the appointment of specific people to the bench in specific fields of law.
Thank you, DJP. For me, I take the point you're raising, but if we have transparent processes and transparent criteria, it helps you to deal with some of the underlying issues that you're raising, which are genuine issues. But thank you for your response, and hopefully that process will start being underway. This process of acting judges, in my view, doesn't require you to be appointed as a JP. You are already in a leadership position as a DJP and could be assisting whoever the JP is in doing this, if you agree with it, I would imagine.
Yes, I do.
Thank you.
Thank you,
Thank you,
Commissioner.
DJP. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Baloyi.
Thank you, CJ. My questions have been taken care of. Thank you.
Thank you. Thank you. Commissioner Pillay.
Thank you, Chief Justice. Good morning, DJP.
Good morning, Commissioner.
DJP, just to tag on to a question that was put to you by Commissioner Tsepe about transparent processes in the appointment of acting judges. I think the one issue you haven't dealt with in response to the complaint by Mr. Monchiwa is around the question of whether or not there's, in a sense, patronage and favoritism in how acting judges are selected, firstly, and that there's lack of opportunity to people at the Mahikeng Bar and local attorneys in terms of being selected for acting appointments.
Commissioner, no, that is not correct. I pointed out earlier that three of the local bar people, women, were invited to come and act. 2 of them being black female persons. So that is not correct. And with regard to the transparency, there should be transparency in the appointment of acting judges. But the criteria need to be looked at. You need to look at the person that are to apply for the position and the exposure. It's not easy to get a person to come and act when that person doesn't have the necessary experience and exposure, or are very, very recently, have taken chambers. To call such a person and expose such a person to the bench without the necessary experience. We need to have a criteria in place and invite people that had the necessary exposure and experience to come and act.
And then in your previous interview, one of the specific issues you mentioned is that you're actively involved in the mentoring of acting judges, and specifically women acting judges.
Yes.
Can I just understand, how does that mentoring take place? What is it that you're doing specifically in order to mentor aspiring acting judges?
Yeah. What happens is it's more on a personal basis, where the judge will be allocated a matter. He or she will write a judgment. I will discuss the judgment. We will go through the judgment, the content thereof. And if there is a contentious issue, to debate with the judge, the contentious issue, without necessarily dictating what the judgment should look like. And those judgments are kept so that at the end of the day, the acting judge can see the progress that he or she has made from the inception up until the end of acting. It's more on a personal basis. It's not a question of lecturing, but it's a question of mentoring the acting judge concerned.
So that relates to once an acting judge has been identified and
Yes.
appointed, that you assist in how he or she performs their duties.
Yes.
And in terms of identifying suitable people, either from the ranks of the bar or the local attorneys, do you envisage any programs to mentor potential acting judges?
I think there must be a program developed but it will be parallel to what is already with Sajid, because Sajid has the aspirant judges training course, where people that are identified are invited to attend in order for them to be trained. Now, after they have been identified, then they are given an acting stint, and that is where the mentoring takes place. So it's not necessary to have a parallel system with what Sajay is in actual fact doing.
And then lastly, just like Commissioner Tsepe, I was a bit alarmed at your answer to the question about whether or not there are any complaints of sexual harassment flowing through. And your response was fortunately not.
Yeah.
I think that's a concerning response, because it might well be that because there is no firm policy in place, that the complaints are not finding its way through. But more importantly, from your answer, I put together that you're in a sense acting as the recipient or the potential recipient of sexual harassment complaints.
Because of my interpersonal relationship with not only my colleagues but also the support staff, if it happened, I would have known. There are none to my knowledge. Not that I am against a policy that need to be implemented.
But I think, DJP, what would be more important is that if you see yourself playing that role of the let's call it the recipient of potential complaints, that you undergo the necessary training in order to play that role, because it's quite a sensitive role, particularly in a structured environment like a court, where it's not easy for women to come forward with potential complaints. That the person who is identified as the core person to whom you would go to if you have a complaint, that person is properly trained in order to play that role.
I agree.
Thank you. Thank you, Chief Justice.
Thank you, Commissioner.
Follow
there
up,
are no
Justice?
further. Oh.
Sorry, a follow-up, Justice?
Okay, I'm sorry. Let me go to Commissioner Nochesi before I go to, I think there's somebody else on the attending virtual who wants to say something. Yes.
Sorry, Chief Justice, it's a follow-up on what has just been said now. Could I perhaps go before Commissioner Nochesi?
Okay, all right. Go ahead.
Thank you, JP. If there were to be a complainant that wanted to lodge a complaint against yourself, who would they go to?
At the present moment, that person would go to the judge president or any other judge.
Thank you very much. Now, I think I just want to underline the problem with just referring to yourself, and then maybe connected to that, is there not perhaps a good idea to have someone else in place to fulfill that role in terms of the sexual harassment policy?
It is possible, yes, Commissioner.
Thank you.
Thank you, Commissioner Barnett. Commissioner Nochesi.
Thank you, Jay. DJP, two quick questions.
Yes.
They arise from the questions relating to acting appointments.
Yeah.
What is your view
about this perceived regionalization of courts. Let me explain, make it simple.
Yes.
A tendency or a practice has been developed that for the Northwest, you will appoint acting judges in Northwest. For Free State, you appoint people from Free State. For all these divisions, and I call it regionalization, which is a step back from what we have achieved as a country.
Yeah.
What is your view on that?
No, I don't support it because you inevitably find yourself in a situation where you can't just source from this your region, if I may call it that. And that is why it happened in the past that we even went as far as Gauteng to ask possible candidates and to identify suitable candidates to come and act. So it cannot be only regionally bound. What if you don't find a suitable person?
Yeah.
Then you will be hamstrung. But in the same breath, look at your local people and develop them. I said earlier, much depends on the exposure that such a person had in the past and how frequent they appear. It may well be that council does not get enough briefs to appear very regularly before you in order for you to invite such a person or make an informed decision about that person's capability.
I'm asking you this because
Yeah.
we have 9 provincial divisions that have various seats.
Yes.
If there was commitment on this aspect, particularly with regard to appointment of women judges, there's nothing to stop you to phone Judge President in the Eastern Cape. Do you have, because there are people appearing in that court in the Western, but even yourself, throughout as I listen, the only court to keep on referring us to is what Pretoria, which is just next to you. This is the regionalization that I'm talking about.
Oh. Yeah, I didn't understand the question in that context, Commissioner. But there is nothing that stops a judge president from calling any other colleague and to identify a person. I would not have a problem to get somebody to come and act from any part of the country.
Yeah. Look, I just, because of time, I would debate this one day.
Yeah.
The point I want to make to you is, if you have a plan, or a judge's president were committed.
Come again?
If you had a plan,
yes,
or judge's president were committed,
yeah,
in addressing the specific issue of bringing more women to the bench or more black candidates to the bench, that should not have a problem.
No.
I will make an example for you. Judge Ponan, he acted in Mthatha.
Yeah.
Judge Theron, all those. But in current years, it's very rare, even myself, to come to act your division because you want people from the Western, from the Northwest, and that's wrong. Thank you.
Let me just respond. You know, we did not only have people in a specific region that are targeted. We have had one of the acting judges from the Northern Cape who is a female. She came and acted in our division. So I don't think that is quite correct, Commissioner. That regionalization of your, it's not in the Northwest.
Thank you, CJ.
Thank you, Commissioner Baloyi.
Thank you, CJ. Perhaps it's
Good morning, DJP.
Good morning, good morning.
Yes, it's more a follow-up on this conversation about the transparency
Yes.
of identifying or finding acting judges. And perhaps it's just to put to you a possibility that you might want to consider,
Okay.
and which I've seen practiced in at least our division, where the DJP at certain intervals sends out correspondence to the...
What is that?
Is Honorable Dennis Stokes.
Please. Okay, Commissioner Baloyi, continue.
Yes. What I was putting to you that
Yes.
perhaps you might want to consider
Yes.
is what happens, for example, in my division, and I suspect other divisions are doing that,
Yes.
is that the JP sends out a request to the various bodies, professional
Yes.
bodies, and indicates periods for which he requires acting judges, but also it has I call it age, number of years at the bar, and whether bar, attorney's profession, and other areas, academia. So perhaps you might want to consider that, because I know from experience that
Yes.
we do have people from Johannesburg who act in the Northwest
Yes.
from time to time. And the question that other colleagues have asked is, how do I get to act in the Northwest? Because I know so-and-so is always acting in that division. So I think if you opened yourself up to these wide invitations, and perhaps it also is a way of addressing Commissioner Nojes's valid issue that he raises, that if you spread this, then you will get better responses, and perhaps also then address your problem that in the Northwest you don't have people who have the necessary years and the necessary experience, because you will have a wider reach with
Yes.
with your invitation to come and act. That's the one. The second is more a question on the same issue. How much, if you do you draw from the pool of magistrates? Because other divisions do that.
Yeah.
Do you use that as a source?
Yes.
Thank you, CJ.
First of all, as far as the first one is concerned, I take note of what you said, Commissioner. As far as the question with regard to the magistrate is concerned, yes, we do draw from the pool of magistrates. There are 3 of the permanent judges now that are appointed in the Northwest were magistrates before. 1 from a district court and 2 from the regional court. So yes, we do draw from all different sectors of legally trained persons.
DJP,
Thank you.
Thank you, Commissioner.
CJ, may I make a follow-up on this issue?
Yes, JP?
Because it would seem there is a concern about criteria and invitation.
Yes, JP.
And I should think JP Lohodi can confirm that a criterion is there.
Yes.
It was agreed upon by the heads of court as to who should be appointed. And secondly, with regard to sourcing acting judges from outside the Northwest, we do get judges acting from there. But there's a problem. You cannot compare us with Gauteng. Most judges who act in Gauteng do that pro bono. Now, if I were to invite someone to come to Mafikeng for free, they won't come, and that is why they are not coming. And Gauteng takes them for a short period, 2 weeks, 3 weeks, 1 month. We ask them to come and act maybe for a term or so. No one will come there for free. And the challenge with women judges, in most cases, they will say, leaving your family. For instance, even yesterday, one said, no, I can't come. My husband, I have a 9-year-old child. You know, things like that. There are quite a number of problems with judges who come from outside. Maybe the DJP may not be aware of that. of some of them.
Yes.
Thank you.
Well,
Thank
maybe
you.
I can add this. I also don't understand there to be any rigid decision or policy in any division not to appoint acting judges from outside the divisions or the provinces. But I do know that generally the JP would, among other things, consider the questions of costs if you are looking at somebody who is outside of the province, because normally that person would need accommodation, there would be S&T. So I don't think there is a rigid no, but that is something that I think is sometimes taken into account. But I think there are cases where acting judges are secured from outside.
Yes.
I know that, for example, I think Shopper JP at some stage shared with me an arrangement where he, if I'm not mistaken, secured somebody from outside the Western Cape, I think from KwaZulu-Natal, on the understanding that that person would not claim S&T or something like that. So I just mentioned that I'm aware that is sometimes taken into account. Okay, I think we have come to the end of this interview. Thank you very much, DJP. Have you got one or two points that you want to emphasize to the commissioners to take into account when they consider your candidature before you leave?
Thank you, CJ. No, I'm covered. I think what needed to be said was said and was written, and
Yes.
I want to thank you as Chief Justice and also the commissioners for the opportunity inviting me to this interview and to give me the opportunity to attend. I thank you.
Thank you very much, DJP. You are now excused.
Thank you.
Should we take the tea break and come back to deliberate? Okay, let's take a tea break, 15 minutes. That will take us to 25 to 12, and then we can come back and deliberate. Thank you. Division. Judge President Benenge, welcome.
Good morning, CJ. Good morning, commissioners. Thank you.
Thank you very much for coming. May I also take this opportunity to welcome the Premier of the Eastern Cape. I understand, I haven't seen him here. I think he's, oh, is he there? Okay. Welcome, Premier. Welcome.
Thank you very much, SJ. Good morning to you and good morning to all honorable commissioners. Thank you very much.
Thank you. Good morning. We are going to start now. We had a discussion earlier on aimed at making sure that we use our time optimally and do not take too long with these interviews. In each case, the arrangement is basically that commissioners will try and only ask when it's really important to ask questions, and when they do, they will limit themselves to 2 questions, unless it's really something exceptional, in which case they will ask me if they can go beyond that. We normally would give the JP a little bit of more leeway because he knows the division, he knows the challenges, he knows what he needs in the division, and he knows the candidates usually as well. So that will not apply to the JP, but nevertheless, the JP, I have no doubt, will seek to limit himself to really what is important. Thank you. Okay, all right. I think that you can bring in the candidate, the first candidate. Good morning, Professor. I don't know whether to say Kruger because sometimes I understand Kruger is pronounced as Gruyere or something. I'm not sure. Is it Kruger? Good afternoon to you.
Thank you, Chief Justice. Good afternoon.
Yes. Thank you very much for availing yourself for consideration for appointment as a judge of the Eastern Cape Division. I will ask you some basic questions, and after that, I will allow the JP to ask you whatever questions he has, and then the Premier, and then commissioners after that also will get a chance to ask you questions.
Thank you.
Now, Professor Kruger, I see here on your questionnaire that you have a string of qualifications. What degrees have you got?
I have a BA degree and an honours degree in political science, and then thereafter I completed an LLB degree. I did a certificate in labour law. I did a ABET qualification in isiXhosa. I did a PGDHE, postgraduate diploma in higher education, and a Doctor of Philosophy in law.
Yes. And you got your PhD in 2009, is that right?
That is correct.
Yes, and your first degree BA you got in 1996.
Correct.
And your honors in 1997. And then the postgraduate diploma, is it in higher education?
Yes.
Yes, and then you got your PhD. You got your LLB there as well.
Yes.
And you started working at the Center for Community Law and Development in Potchefstroom.
Yes. Chief
Yes,
Justice.
how long did you work there?
I completed my articles, and thereafter I moved back to the Eastern Cape to join
Yes.
Rhodes University as an
Yes.
academic.
After your articles, did you get yourself admitted as an attorney?
I was admitted as an attorney in 2001.
Yes. In terms of actual practicing,
As an attorney, I haven't practiced. For about a period of 3 months, I worked as a professional assistant
yes.
on a part-time basis. But by that time, I was trying to find my feet in the academy, and I decided to focus on one thing at the time. So I have completed my articles. I was admitted. And then subsequent to that, I have, when I joined Rhodes University, I've presided in student disciplinary matters, and I've also, in 2013, started working as a commissioner of the CCMA. So those are, and that's the extent of my practical experience in addition to acting as a judge.
Yes. So how long did you, for how long were you a commissioner at the CCMA?
I was appointed in 2011, and then there was some administrative glitch, and I only completed the training course in 2012, and I started hearing cases in 2013. And I'm still under contract with the Commission.
Yes. Were you part-time or full-time?
Part-time.
Part-time. And being part-time, were you doing both mediations, mediations and arbitrations?
Both of those, on a limited basis, given my full-time employment at the university.
Yes. What were you doing more? Is it mediations or arbitrations, or you can't tell?
One would say, a matter would start out as a conciliation / arbitration, and then in those instances where the conciliation fails, you would immediately proceed to an arbitration. I would imagine that the bulk of the matters would settle at conciliation, but I most certainly have a number of matters that I've presented awards or written awards in mediations.
Are you able to say on average how many matters you think you would arbitrate in a year?
Chief Justice, that would be really very difficult for me to give a number on it. I would say not very many.
Yes.
From 2014 until 2020, I was the Dean of the Faculty of Law, and during that time in particular, I had very limited involvement with the CCMA, given my responsibility to the university community. So while I held the position, I would be lying if I tell you that it was 20. I don't think, definitely not 20. I would say more in the region of 5 or 6, if that.
Is that in a year?
Yes, in a year, if that.
Yes.
But as I pointed out, I also dealt with student discipline, which is a quasi-judicial discipline, a quasi-judicial body within the university, and that I continue to do.
Yes. When you have done arbitrations, has there been legal representation for the parties, generally speaking, or not? I know that the CCMA, I think most of the time there is no legal representation in arbitrations and mediations, but I think there are circumstances where there is legal representation.
Yes.
But what normally happens when you do arbitrations in terms of legal representation?
often it would be a trade union representative on behalf of the employee, and then someone from HR on behalf of the employer. But as I've said, I haven't in recent years done many of those. I can decidedly remember that I had a matter involving constructive dismissal in which there was legal representation on both sides. But I cannot tell you when that was. It was a couple of years ago.
So if you look at the number of arbitrations you have done at the CCMA, and I'm focusing on arbitrations because I think that's the only thing that I can think of that comes close to what you do as a trial judge, as a judge. Are you able to say, well, over the years I've done maybe it's about 20 arbitrations over all these years at the CCMA, or maybe 10, or maybe 50? Are you able to give us an estimate just to give us a picture of how much exposure you have had to something that comes close to a trial?
I would say roughly 10 to 15.
Roughly about 15?
Yeah. I could count them, but I unfortunately don't have that information at my fingertips at the moment.
Yes. And of those, were there some that had lawyers involved representing the parties?
Yes.
Yeah, there were those that had lawyers. Only a few, or a substantial number of the 15 or so?
I would say in the majority of instances, not.
Yes.
It would be an experienced trade union representative and a HR practitioner.
Yes. In the arbitrations in which you have been involved, have there been issues of the admissibility of evidence that you have had to deal with or not?
Yes.
There have been such issues?
I'm saying admissibility of evidence, but I'm actually thinking particularly more of student discipline, because in student disciplinary matters, that was very often an
I'm
issue.
sorry, can you pull the mic closer to you?
Sorry, just hang on. It would possibly be something like hearsay, I would imagine. But since I don't have that information at my fingertips, I would imagine yes, but I can decidedly remember student disciplinary matters more that had evidentiary issues that had to be decided on the basis of inferential reasoning rather than concrete evidence of someone seeing the student engaging in the particular behavior. So in those instances, most certainly, the decisions provided would have set those, would have dealt with the admissibility of evidence.
Yes.
And the chain of...
how long have you acted as a judge?
I have a total of 25 weeks that I was appointed, and then I had 2 criminal matters that both took me beyond term time. And so I would say 25 weeks of term time that I was appointed, and then beyond that, 2 or 3 weeks of finalizing my criminal matters.
Yes. And in terms of arbitrations that you have done, have you been taken on review? And if so, are you able to share with the commissioners what the outcome was of such reviews?
Not that I'm aware of.
Not that you are aware of. And in terms of decisions or judgments you have given as an acting judge, have some been taken on appeal?
I have granted leave to appeal in a number of matters, but insofar as my knowledge goes, that those appeals have not been heard.
Yes.
I have, let me just make sure here, I've got the statistics here. I've got 5 applications for leave to appeal, of which I granted 4.
Yes. And you have done motion court, you have done trial matters as well.
Yes, I did.
Yes. And in terms of full bench appeals, have you participated in full bench appeals?
I was set down. I have definitely participated in full bench appeals in the first or the second week of the 4th term. I was set down for appeals in Mthatha with Acting Judge Baileyfeld and Judge Tokota. And from that week, most certainly, we've participated and heard 2 matters that went on appeal, full bench appeal.
Yes. When you sit on appeals, dealing with a judgment coming from the magistrate's court or coming from a single judge when you are sitting on full bench appeals, and you are dealing with a decision made by the magistrate or judge in exercising a discretion, what do you look for in order to see whether you may change that decision or not?
Insofar as a criminal matter is concerned, it depends on whether it involves the sentence or the conviction. And if it is in relation to the sentence, it would be if it is startling or inappropriate that the appeal court may substitute the decision of the trial court. And insofar as the guilt of the accused is concerned, it would be that one would have to dispassionately look at the reasons provided by the applicant for leave to appeal and consider whether there is a prospect of success, which is not far-fetched, but that is based on the facts. And in those instances, one would then interfere and change to reflect the correct position insofar as the finding is concerned.
If it's a civil matter or a motion matter, the decision that you are supposed to, that you are considering whether to uphold or set aside was a decision made in the exercise of a discretion.
Yes.
What would you look for in deciding?
Apologies. One would consider the standard that is set out in the Supreme Court Act, which one would then consider whether there are reasonable prospects of success. And if those prospects are, not the prospects, if the findings are based in fact that are inappropriate, the exercise of discretion by the judge was incorrect, then in those instances, based on the evidence that was presented and the legal principles applicable, one may interfere in those instances.
Just repeat, I want to make sure I don't misunderstand you. Under what circumstances would you interfere?
With a decision, say, for example, by a judge in a matter, a civil matter, or
a civil matter, but the decision that is on appeal was the result of an exercise of a discretion.
One would consider the evidence and whether the evidence supports the exercise of the discretion, and whether the law, the exercise of the discretion is within the bounds of the law. Because the exercise of discretion is not unfettered, and one would consider that within the context of the facts of the particular case.
If you are dealing with factual findings made by a trial court and you are sitting on appeal, are you familiar with the approach that a judge sitting on appeal is supposed to follow?
It would be, unless the finding of fact is so startlingly inappropriate, one would not lightly interfere with the findings of a judge made in a trial court.
Yes. What can you share with the commissioners in terms of the experience you have had in motion court?
I have had the opportunity to deal with quite a number of opposed motions, 22 opposed motions, and that was ranging from a wide variety of matters, from the purely procedural to matters of substance. And then in relation to the unopposed matters, I have had duty for about 4 weeks.
Yes. Well, I guess that after the October interviews, every candidate who comes here for for consideration for appointment as a judge for the first time would make sure they know the plus con evens rule.
Yes.
You know that rule.
Yes, I do.
Yes.
Yes.
I'm going to hand over to the Judge President who will ask you questions. Okay. Judge President.
Good morning, Professor Kruger.
Good morning, JP.
What is the test in civil cases? Maybe to be fair to you, in criminal cases, proof must be beyond a reasonable doubt. What is the test in civil cases?
On a balance of probabilities.
Concern has been expressed that you lack practical exposure. Would you say that comment is fair, or how would you deal with that comment?
JP, I think obviously that I'm very aware of the fact that my candidature is not one that follows the normal route, in the sense that I've been a practitioner for an extensive period of time. However, I would say that it's not a question of having no practical experience, as I have some practical experience. And then very pertinently, I think post-1994, there was a deliberate move when this body was established to broaden the pool of potential candidates for judicial appointment. And in acknowledgement of the rich, relevant experience that come from different areas. And I think in particular from the academy, what I found quite useful is I've never had concern post articles to consider the law in a partisan fashion. I've never had to shape a case for a client. I've always considered the law dispassionately and considered both sides in the application thereof. So I would say that my extensive research and analytical skills empower me to deal with also issues of practice.
Yeah. Let's get rid of this notion about plus-con events. What do you know about that?
Thank you. If there's a dispute of facts that applicant in motion proceedings ought to have foreseen, the matter is decided, or when a dispute of facts arises, then the matter is decided on the basis of the common cause facts, in other words, the facts of the applicant which have been acknowledged, admitted by the respondent, and the facts of the respondent.
Yeah.
So it's basically a warning rule to an applicant to make sure that motion proceedings are appropriate, and there's no dispute of fact.
Thank you. One of the judgments referred to by the GCB
yes,
in their commentary relates to civil contempt of court proceedings.
Yes.
In that context, what is the test for establishing the guilt of the respondent in civil contempt proceedings?
There must be a court order which has been willfully and deliberately
Sorry,
disobeyed.
I'm asking you the test.
The test.
Yes, remember, it's either on a balance
On
of
a
it's either on a
Yes,
balance of
okay.
probability or beyond reasonable doubt. What is the test?
Yes, there has been a number of cases, and in the course of the judgment, I traversed those cases. So there was Farki, then there was, and Farki was distinct, or there was the majority and the minority judgment, and then there was the CC judgment of Judge Nkabinde, and I'm going to get the name wrong. I think the second judgment in any case was Machabeng. And in Machabeng, Judge Nkabinde endorsed the distinction between civil contempt, where you have to establish on a balance of probabilities, where the only thing that you want to get is compliance with a court order, and where you have to establish non-compliance on beyond a reasonable doubt, where you want to ensure that there's the further possible criminal consequence that may follow from that. And that was endorsed by the majority of the Constitutional Court in Machabeng.
Yes. From the list of judgments that you finished the commission with, I see you penned 22 opposed application judgments.
Yes.
And 2 criminal trials were run by you. You penned judgments there.
Yes.
You ran 3 civil trials,
Mhm.
2 criminal appeals, 5 applications for leave to appeal, as you have alluded to.
Mhm.
And then on another occasion, you must have issued an order with reasons to follow,
Mhm.
which you did once in a while. So my last question is this. Which of the judgments that you penned do you believe demonstrates your knowledge of commercial law?
Of commercial law.
Yes.
If you give me a second here. I think Echo Bow versus City of Cape Town.
City of Cape Town.
Yeah, it's a matter involving a procurement, but it's a matter that essentially is about money.
At which page is it?
On my list, it's on page 3.
Yes. All right. Is that the only judgment you can refer to?
No, if you give me a... There's Headbush versus Office Automation on the first page, which is also about the contract.
Yes.
And Express Petroleum is the one about the commercial, but that's about contempt of court.
Yes.
I would say Nalitemba was an application for summary judgment. That's on the top of page 2, which also involved significant dispute of fact between the parties.
All right. If you can indulge me, Chief Justice, just one last question.
Yes, okay.
In fact, just one point that I want to make. The DJP at Gqeberha has commented that you were able to cope with the workload presented by a busy motion court and presided over a long-running criminal trial that presented itself with the challenges associated with a child rape matter.
Yes.
Will you confirm that?
That is correct.
Thank you, CJ.
Thank you, JP. Premier.
Thank you very much, CJ, for the opportunity, and greetings once again to all members of the JSC. I suspect JP has largely covered me on a number of questions he has asked. I just have one question that I'm interested on. Prof, good morning also.
Good morning, Premier.
Do you find the move from academia to the bench interesting or challenging? Why are you?
I find it interesting and challenging. I don't think that a challenge is something to be running away from. I really enjoyed the opportunity that was given to me as a result of broadening the pool of possible candidates. I enjoyed the opportunity. I found it interesting. I found it rewarding. And I found it to be a lot of work. And I'm always up for a challenge. I relished it.
Thank you, CJ. I'm fine.
Thank you, Premier. I now will allow commissioners who wish to put questions. Professor Kruger,
yes.
The commissioners will put questions to you, and they will do so largely to try and see how your appointment would meet the selection criteria that have been approved by this body, and they include whether or not you are a person of integrity and whether or not you have the necessary energy and motivation, and whether you are competent, technically competent, and whether you have a capacity to give expression to the values of the Constitution, and whether you are an experienced person, technically experienced, and experience in regard to the values and needs of the community. They will also look at, or they include, the question whether you have appropriate potential and what message your appointment would send to the community. Of course, the question of the diversity of the court, and the question whether you are a fit and proper person, whether you are duly qualified. They'll ask you questions aimed at satisfying themselves how your appointment would meet those criteria.
Thank you, Chief Justice.
Thank you. I'm sorry, Judge President Lehodi helps me sometimes with the list, but I couldn't read his handwriting. But now he tells me what I see is supposed to be speaker. So, but now that he has said it, I can see. Commissioner Mapisa Nakula.
Thank you very much, CJ. Good morning, Prof.
Good morning.
How are you?
Fine. You?
Good. Prof, you've just said you've acted for a total of 25 weeks.
Yes.
All in all. And not only that, before then, you practiced as an attorney from July 2001 to the 30th of September. Whilst appreciating your academic achievements, and I'm sure all of us do, I would like to, what do you think you will be able, what impact do you think you'll be able to make in a court as now a full-time, permanently appointed judge?
Thank you.
Yes.
I think to some extent I want to hook this on what I've said earlier, and this has been my philosophy in terms of teaching students as well, is what students are facing and what I think practitioners are facing and what judges are facing is to solve legal problems. And I'm of the view that my research skills, my analytical skills, my commitment to the Constitution enables me to, whatever I don't know, and I'm not sure that there's anyone who knows all of the law and understands all of the principles, I am able to I understand the method of coming to the correct answer. And I believe that through the constitutional perspective that I bring, and with my relevant experience in legal research and engaging with the law, that I will bring a person to the bench who is not someone who has walked the traditional route, because it's not my understanding that a judge's position is as that of an ultimate practitioner. The role of the judge is not that of an ultimate practitioner, but rather someone who dispassionately has to analyze the facts and the law and come to a conclusion with the aid of practitioners to a just result within the framework of the applicable law.
If I may, I'll follow CJ. Thank you. Thank you very much, CJ.
Thank you.
I understand and I accept that. The issue on my side is, whereas you meet the basic criteria for appointment,
yes,
but you definitely lack the necessary experience of practicing as an attorney, but also of being a judge. And I'm asking now because we are now considering your appointment to a high court.
I hear you. I take it from your question, Commissioner, that the 25 weeks that you regard that to be insufficient as demonstrating my ability to perform the work. I think, yeah, to the best of my knowledge, I have performed the duties of a judge in accordance with the law and the Constitution. And as I said, my understanding is not that practical experience is the only or the largely relevant criterion. It's a whole host of other things that go into it, unless my understanding is incorrect.
I'm sorry, CJ, but it's just my last follow-up. Prof, are you certain that you do not need to be given more time to act in order for you to gain the necessary expertise which are required for you to lead a collective in a high court as a judge? And that will be my last question. Thank you.
I do not think that I mean, obviously, acting more would add to my experience, but I do not think that my candidature is without merit on the basis of the fact that I've only acted for two-thirds of a term, if that is the question.
I will go to the next commissioner, but I just want to say this, which flows from Commissioner Mapisa-Ngakula's question. You accept, do you not, that if you talk about 25 weeks of doing trials and say that's what you are talking about, that amounts to, is it something like 7 months?
It's half a year, more or less.
It's about half a year.
Yeah.
I guess that you would say that if an attorney or advocate practiced for about that, or maybe a year, did that in a year, they should be ready to present themselves and be considered. Would you say that? Or would you say they would need more time?
Chief Justice, my understanding is then that, yeah, the other relevant experience that I have is...
Yeah, nobody says that there can't be other things, but when you are a judge in the High Court, your core function is to judge, and your core function involves trials, motion court to a very large extent. So, and you would be presiding in trials where there are experienced attorneys and advocates who are appearing before you, and you need to handle all the challenges that arise with that. You believe that the period that you have had of trials is sufficient to equip you?
I believe so.
Okay, all right. Commissioner Makwanishe.
Thank you very much, CJ. Good afternoon, Prof.
Good afternoon.
There is something that I would like you to clarify. The General Counsel of the Bar says that they are not happy with how you conduct, some practitioners are not happy with how you conduct trials. You seem to be, you stray from the facts presented, in fact from the evidence presented, and you're easily distracted by irrelevant issues. What is your comment?
It is impossible for me to comment without a practical or concrete example. I am not able to respond to that. I can simply say that I can't think from the top of my head. If there was an example given, I would have been able to respond, but I cannot respond in the abstract.
Okay, thank you. And then the last one, CJ. Do you have any outstanding judgments, and how long are they?
I do not have any outstanding judgments as to date.
Thank you very much.
Thank you, Commissioner. Commissioner Klaba.
Thank you very much, Just Jay. Good afternoon, Prof.
Good afternoon.
Thanks. I just want to, in passing, CJ, I see that in the CV, she doesn't indicate her state of health.
Oh, yes.
That is considered disclosable. And is there a reason why you decided you would not comment on this item?
I apologize, I didn't hear what you said earlier.
No, on page, I'm looking at your application form.
Yes.
On page 4, is item number 11. It's asking you if there is anything about the state of your health which should be disclosed before the commission, and you decided not to comment. Is there any reason why you...
That is an oversight.
That was an oversight.
That is an oversight. I apologize.
All right. Having cleared that, Prof, during the period you were acting on the bench, have you presided over matters that implicate socio-economic rights?
No, I haven't.
You haven't?
No.
Okay. I mean, tapping into your experience as a professor, do you think we have succeeded in having more of these matters coming before the courts as part of expanding justice to our people? If not, what do you think is the reason why we're not getting so many of these matters that implicate socio-economic rights coming before our courts? Thanks.
I think to some extent it may be a question of awareness on the part of litigants or potential litigants, and also access to justice, to have legal representation. Because socio-economic rights cases are typically brought by institutions like the Legal Resources Centre or CALS or one of these institutes, and they have limited capacity. I do think where there has been litigation, for example, in the Eastern Cape, there's been a lot of litigation on basic education, and that has made a positive difference in the lives of learners in the province. But I do think, obviously, what one should do is, within all the arms of government, there should be a explicit effort to comply with the legislative and constitutional standard, and to ensure that the socio-economic goods, whether that is access to social security or whether that is a question of education, basic education, that those are delivered to the people entitled to them.
Thank you, CJ. Thank you, Prof.
Thank you, Commissioner. Justice Betzer.
Thank you, Chief Justice. Good afternoon, Professor Kruger.
Good afternoon, Judge.
What you said earlier on reminded me about my old days at the University of Fort Hare. One of the professors there used to say that as a lawyer, you must either know the law or know where to find it.
Mm-hmm.
I've got two double-barrel questions for you. The first one, you appear to adopt a somewhat liberal approach in granting leave to appeal. You said you had 5 applications. In 4 of them, you granted leave to appeal. Mm-hmm. Would you care to enlighten this commission as to what the test is for grant of leave to appeal?
All right. It is whether another court reasonably could come to a different conclusion. Section 17 of the Superior Courts Act seems to up the ante quite a bit in respect of what a party should put before the court. And in particularly the matter that the JP referred to, the express ROPACs, there was a reference to a judgment of Judge Smith in the Eastern Cape High Court, where he made a very useful comment, in my view, on considerations for leave to appeal, in which he says it is indeed so that the addition of the word in the section seems to up the ante dramatically. However, it cannot be that one almost has to go above and beyond to get leave to appeal. If there are reasonable prospects of success made out in the application for leave to appeal and in the submissions made by the parties, then that is appropriate for leave to be granted. I'm not entirely sure what the reference to that judgment is, but I found that particular passage of Judge Smith clarifying the standard to be particularly helpful, rather than taking the view that it is only in exceptional circumstances, because it is not what the statute requires, that one has to go above and beyond to obtain leave to appeal.
Thank you, Professor. Allied to that, under what circumstances would it be appropriate to grant leave to appeal to the Supreme Court of Appeal?
That would be if the question is of such importance and complexity that it requires the attention of the Supreme Court of Appeal. Alternatively, it would be where there are conflicting judgments of the High Court.
And lastly, with your leave, Chief Justice, in relation to the exercise of discretion, as an appellate court, where the outcome of the appeal hinges on the exercise of a discretion by the court of first instance, what would be the antecedent question that you would have to decide before you proceed to consider the merits of the appeal?
In relation to the exercise of the discretion?
That is correct.
Whether that was appropriately exercised, given what the circumstances. So in other words, if it is, whether the court granted relief that was based on the discretion that it could exercise, whether that indeed was appropriately exercised.
Yes, but would the court not have to determine first and foremost the nature of the discretion which was exercised by the court of first instance?
Absolutely, because in some...
Wide or narrow discretion?
Absolutely. No, absolutely. I think I've misunderstood your question. I apologize.
Thank you, Professor. Thank you, Chief Justice.
We have taken about 35 minutes already. Commissioner Nochesi.
Thank you, Sir. Quick two questions. I mean, they relate to the comments by the GCP.
Yes.
Do you not find these comments rather confusing and internally contradicting? Because at paragraph 11.1, the
Thank you for pointing that out. I mean, when I read through these comments, obviously perhaps strayed, but then was particularly more appreciative of the candidates' judgments are well-researched and impartial, because I think that, for me, is the proof of the pudding.
Yeah. And then the second question, which is related to this again, if there is a complaint or somebody says you lack experience because of the time, Have you been told how long one must act? He can be appointed or he can apply. Do you know how when, by what time? Should it be 6 months, 2 years, 10 years? Do you know where is that?
I do not know. I would appreciate some clarity, if there is such clarity.
Okay. The last question. Out of all the judgments that I've written, your judgments, these judgments, is there any judgment that has brought or has been pointed out as embarrassingly written or incompetently reflecting law badly? Is there any judgment that is something to talk about from these judgments? Is there been such?
Appointment, do you think we would be living up to that criteria of ensuring that we help reflect the racial and gender composition of South Africa, in particular to that bench of 8 people? Thank you.
My understanding is that these 2 positions relate to the imminent retirement of two of the females who happen to be white, which would then mean that the remaining only female member of the bench in Gqeberha and the remaining members of the bench would be male. So in that sense, I do think that there will be a female composition, but I absolutely admit that what I will bring is another white person to the bench, and I leave that up to the Commission to determine whether that is what that court needs at the moment.
Thank you, Chief Justice. I saw the JP nodding his head when Professor said that there were 2 white females that are going to be vacating the offices. And JP, I would think that is correct. Thank you. Sorry, Chief Justice JP. I said you were nodding your head when Professor said that there were 2 white females who will be vacating and these vacancies will have to be filled.
Through you, Chairperson, that is indeed the position.
Okay, all right. Thank you. Commissioner Moimang.
Thank you, Chief Justice. Good afternoon, Prof.
Good afternoon.
Just one question from my side, prompted by the article that you wrote, the South African Constitutional Court and the Rule of Law, 10 years ago. You seem to have had a problem with how the former Deputy Chief Justice had a problem, had interpreted
who seem to accept that a very brief in-passing consultation, in inverted commas, met the requirements of procedural fairness. And the rule of law, most certainly in my understanding, can be either very thin or a very thick concept, and the court has sort of pitched it somewhere in between. And that is my understanding, where it has, for the greater part, always acknowledged that it has a procedural aspect too.
Thank you, Chief Justice. Thank you, Prof.
Thank you. I'm going to go to the commissioners who are attending virtually before I proceed to Commissioner Pillay. Commissioners attending virtually, is there anyone who has a question?
Thank you, Chief Justice. Commissioner Bonner.
Yes, you may go ahead.
Good afternoon, Prof. I'd like to ask you about the, just before I do that, have you sat in any urgent applications?
I did.
Okay, thanks. As referring to the Yellowstone, Caravan Park, Leppen and versus King, I think, matter. The question I have about that is a practical enforceability of the order, and it goes to the technicality of it. If one looks at paragraph C, so the order in this Yellowstone matter is set out on, I think it's page 64 of the bundle. It seems to be marked with a stamped mark. And paragraph C specifically deals with if the respondent doesn't carry out the order, what then should happen. Now, in practice, normally it's the person who wants the order enforced, which in this case would have been the applicant, that then asks the would instruct the sheriff, and then it would be that party. Would you agree that it would then be that party that would receive the account from the sheriff? Would you agree with that?
If you will just indulge me for a moment, you say page 63. I'm still finding my way here. I do remember, but I can't recall exactly what the agreement between the parties was at the time, or what the... I do seem to have the wrong book here. It's not this one.
If it would assist, I could, to save time, I could just take you through it and then...
I found it, sorry, apologies. Yes.
So it's at the top of page 64.
Yes.
There's paragraph C of your order. So the concern is that ordinarily it would be the applicant in this instance that would be instructing the sheriff and that would be receiving the bill. The problem with this paragraph that we come across in practice from time to time is that where you've ordered here, where courts would order that the respondent should carry the cost. So the order here says, should the respondent fail to remove, then the sheriff may remove and store the chalet and other removed structures at the cost of the respondent. The point is it's going to be the applicant that's giving the sheriff instructions here, but the applicant never has to pay because the court order says the respondent must pay. Can you see the practical problem that this type of order can hold for the sheriff, for example?
I hear what you're saying, but if I'm not mistaken, that was the request that was requested, the relief that was requested. I stand to be corrected, but that was the requested relief.
I accept
but
that.
I hear what you're saying, absolutely, because in this instance, what would happen is that the applicant, or rather the applicant would give the instruction, but the bill would be made out, or the bill, while it has to be paid by the respondent, it would go to the applicant. That is the issue.
So you see, the practical problem is in practice, we've come across these instances where the respondent then disappears or absconds and never pays, and the sheriff's bill just mounts and mounts and mounts, and no one accepts responsibility. That's the one question. My second question goes to the ad alteram principle, and that is, was the sheriff, I mean, before making this order, which clearly affects the sheriff, was the sheriff asked for representations? I think ordinarily the court wouldn't do that. And I'm wondering if it's such an order which departs from the norm shouldn't have given the sheriff an opportunity to do so.
Yes, I imagine that it could be, it would be appropriate to ask the sheriff. But as I say, that the terms on the basis on which the order was granted for the greater part was in accordance with the requested relief by the party. But I take your point most certainly that it should be a question of a formulation to ensure that the that the respondent takes responsibility for the costs that are incurred as a result of his non-compliance with the order.
Thank you. My last aspect on this specific thing, once again, it goes as to the the law that was applied, here you have a situation where for years, according to your finding, there was a contravention of the legislation applicable. And yet for years, the applicant had held out to the respondent that that was a valid lease agreement. Now the court now the applicant approaches the court for eviction, and now all of a sudden wants to rely on the contravention of some other legislation. So my question is, isn't this a situation where the applicant should have been stopped from relying on that sort of thing to the detriment of the respondent?
That was not what the applicant relied on. The applicant very particularly did not rely on this. I raised this point miro moto, and I can refer you to paragraph 8 and 9 of the judgment, where I raised this with counsel. That was not the case of the applicant. The case of the applicant was everything but relying on the illegality of the contract. Because if they were to rely on the illegality of the contract, they would have had to admit that in their founding affidavit. And they particularly steered clear of that, and relied on all sorts of other fringe issues, but it goes to the root of the agreement between the parties. And in paragraph 9 of the judgment, I referred to Yanako versus Apollo Club and City Power versus Combined Private Investigation, CC, which is a fairly recent judgment, if I'm not mistaken.
It just seems to me that it's a pretty unfair situation where an applicant now wants an eviction after years and then gets assisted in a sense, but I'll leave that for argument. I don't know if you want to comment on that, and that concludes my questions.
Just very briefly, I dealt with that very pertinently in the judgment. And let me just see now, where did I do that?
Sorry, Chief Justice, I took an argument, but I mean for deliberations.
Yeah, sorry, but I apologize. But I comment on that paragraph 30 to 32 of the judgment.
Okay, all right. We are on overtime in regard to these candidate commissioners. So those who have raised their hands, only if you really want to, you insist, I will allow you, but if you think you can do without the question, it would help. Okay, Commissioner Pillay.
Thank you, Chief Justice. It is quite an important point, and I will try and keep it short.
That's fine.
Good morning, Prof. May I ask you to turn to your Babalwa Madikizela case, if you don't mind?
Yes.
Babalo Madikizela.
If you can get me a page number.
I think it's at paginated page 42.
Okay, it's just one back then. Okay, thank you.
So this was an urgent application in which the applicant sought to suspend and interdict the remedial action of the public protector. You recall that?
Yes, but they didn't seek to suspend the interdict. They just sought an interim relief.
Well, your order ultimately suspended the remedial action, and then you interdicted it.
That was the relief that was sought.
Yes, but that's the relief you granted.
Let me just go, I can't from the top of my head.
If you look at page 51.
50 and 51. Let's see. Yeah.
You'll see in prayer C that the remedial order is suspended.
Yes.
Do you see that? And then in prayer D that the public protector is interdicted from enforcing a remedial order.
Yes.
Do you see that?
Yes.
Now, if you can just go to the test that you apply, and you'll see that at page 46 of the judgment, where you're going into the test for interim relief. Do you see that?
Yes.
And you refer expressly in paragraph 15 to the decision of Justice Khampepe in the Godan matter. Do you see that?
Yes.
And in that matter, Justice Khampepe expressly states that the appropriate test to be applied is the outer test.
Yes.
Right? And which you properly recognize in that paragraph. My difficulty comes from what happens in the following paragraphs. If you look at the next paragraph where you refer to the outer case, what you do is you extract a portion of the outer judgment that just merely restates the Setlogelo test, right? And you then say that you have to now nuance it in light of the values of the Constitution. What you do is you miss the thrust of the outer case, which is that in order to interdict the performance of a statutory or constitutional function, you need to demonstrate that it's a strong case and it's the clearest of cases. So in other words, you have to make out that it's an exceptional case in order to get such drastic relief. Now that portion of outer, which is really what we as practitioners know and love as the outer test, that portion is not applied in your judgment. And so ultimately you go through the remaining Setlogelo requirements and you come to the conclusion that it's appropriate to grant the relief. And we know that this is relief granted on a default basis.
Yes.
So in other words, there was no respondent in court that could have argued or demonstrated that the test that you were aiming to apply was the incorrect test. And you'll appreciate that a judge sitting in on a default basis has to exercise extra caution.
Absolutely.
All right? And what you see in this judgment is that, firstly, outer is misapplied. And the result is that you do grant quite far-reaching relief on a default basis. So I just want to put that concern to you.
Yeah.
And get a response to that.
I would refer you to paragraph 24 of the judgment. I don't, respectfully do not think that there was a misunderstanding of the test, because, I mean, obviously it is the circumstances to the greatest extent mirrors that of EFF versus Gordon. And in my view, on the basis of what was presented to me by both applicants in that matter, that they have made out the case. I do not think that the outer case uses the terms necessarily exceptional circumstances. Because, I stand corrected, it may or may not, but exceptional circumstances would then take it somewhat further.
Can I say to you, and you know, one of the benefits of being a practitioner
Yes.
is that this is our bread and butter.
Yes.
So we know these tests very well. I can read to you what outer says. It says, except when a proper and strong case has been made
Yes.
out for the relief, and even so, only in the clearest of cases.
Yes.
So that's the stern language used in outer. The paragraph that you've referred me to, I've read, and that's a paragraph dealing with balance of convenience.
And it deals with harm, yeah.
Not really what outer was about, because outer imposed an additional requirement, which is this strong and clearest of cases. And that was my concern with your judgment.
Thank you.
Thank you. Let me go back to the commissioners who are attending virtually. Is there any other commissioner attending virtually who has a question that they consider quite important in the light of time?
No questions, thank you.
Not from you. It looks like there's no question from that side. Then it will be Commissioner Kane. I assume your question is important? Yes.
Good afternoon, Ms. Kruger. I represent the GCB, and so I just want to take up the concern, in fairness to you, that they express, which is that you wouldn't have sufficient practical working knowledge of the law in order to yet enjoy the appointment as a judge. Now, earlier you've been questioned by the Chief Justice and other senior judges on your approach to various issues, including discretionary findings, appeals, Plascon Evans, and so on. The run-of-the-mill case that comes before you every day may involve questions like the granting of postponements, exceptions to pleadings, whether a discretion is a wide or a narrow discretion. You may be faced with rules as to whether everything must be in a founding affidavit, how you deal with new issues in reply. Now, tell me what approach you take when those issues arise in court, assuming that this hasn't been your bread and butter for the majority of your professional life. Where are you going to go to get the necessary assistance quickly so that you can efficiently deal with these kind of things in court?
Erasmus, in short. And then following from that, my general approach.
I'm sorry, Professor Kruger.
Yes.
You said something before you said in short, and it may have been part of the answer, but I didn't hear what it was.
Erasmus.
Erasmus, oh,
Yes.
okay.
I would start with Erasmus, but I wouldn't leave it at Erasmus. But that gives you a very clear indication of, because it's quite an extensive commentary on the rules of court, and if it's not in the rules, there's also commentary on the Act. So I would start there, and I've had to deal with exceptions. I've had to deal with a variety of these practical matters, and what I can assure you is that the one thing that I will definitely do is I will research it to the nth, so that for the greater part, and I admit that it's possible that I've made mistakes, and I think everyone will make this mistake, and that's why we have processes in place. I may have made mistakes, but for the greater part, I will go to the ends to try and wrap my head around it, because that's been my bread and butter, to wrap my head around it and make it accessible to other people, students.
Thank you, Chief Justice.
Thank you. There are no further questions. JP?
Thank you for indulging me, CJ. Just one aspect relative to the concern that you acted for 25 weeks. I just want to place it on record that as soon as there were vacancies in Makhanda,
Yes.
I approached you on the basis that you had acted during the first term, 2021, and you were going to act during the second term, July to September. I informed you of the vacancies, but you then said to me you would like to get more exposure. Can that go on record?
Yes, that is indeed the truth.
Thank you.
JP, was that before the 25 weeks of acting or after?
It was actually before the expiry of the 25-week period. In other words...
It was during?
Yeah, it was during.
Oh.
In other words, she had acted during the first term, and the positions had been advertised for Makhanda.
Yeah.
And based on the fact that I was constantly supervising her by reason of her background and my impression of she was developing, I then indicated to her that it was available to her to avail herself for the Makhanda vacancies. But she adopted the stance that she thought she would need further exposure, hence she did not avail herself at that particular point in time, and acted further. In other words, from the 4th of October to the 12th of November.
Yes.
I just thought I should place that on record.
Okay, all right.
Thank you.
Thank you. We have come to the end of your interview, Professor Kruger. Do you have 2 or 3 points that you want to emphasize that we must consider? I'm giving you 2 minutes to say if there are any points, or if you are satisfied that all the points have been dealt with that needed to be dealt with, that would be fine too.
No, I would like to thank the Commission for the time, and I would like to thank the JP for the opportunity, because I know it's not the ordinary path, but I believe that people in my position have a contribution to make, as Judges Mokoro, Reagan, and several other academics have made huge contributions to the jurisprudence in this country. Thank you very much.
Okay, thank you very much. You are now excused.
Thanks so much.
Thank you. We are at 1:45, and I think that we should take the lunch break and then come back. Can we take a shorter lunch break than we did in the past 2 days? Can we take 45 minutes, and so we return at 2:30, or should it be shorter than that? 2:30 is fine. Okay, all right. We'll return at 2:30. Thank you. We adjourn.
Chief Justice. Chief Justice.
I'm sorry. I'm
I just
sorry.
think, yes, Chief Justice, before we have the conversation, I'm sure we need to clear the room and
Yes, I'm sorry. There is something that we should discuss before we go to lunch. If the media can excuse themselves. The speaker is not, or is he? I think you can, Commissioner Tsepe must be on her way, I guess. Yes. Okay, I think you can bring the candidate. Okay, no problem. We know that you are not late because of your own things. You are late because you are doing work for us. Thank you. The commissioners who are attending virtually, are you all there?
We are. Thank you, Chief Justice.
Thank you, Commissioner.
Yeah.
Commissioner Malema is there. Commissioner Barnett, are you there?
Yeah, Chief Justice.
Okay. Commissioner Shabangu Mdawe is there too?
I'm here.
Okay,
Sujay.
thank you very much. Thank you. Let's start. Good afternoon, Ms. Fenyana. Please switch on the mic. How are you this afternoon?
I'm well, thank you, Chief Justice. How are you?
I'm all right, thank you. I've greeted you on behalf of all the commissioners, and when I asked you how are you, I was doing so on behalf of all of them. So nobody will ask you how are you.
Thank you. I hope the commissioners are well as well.
Let me thank you for availing yourself for consideration for appointment as a judge of the Eastern Cape Division. I'm going to ask you certain questions, whereafter I will allow the judge president to put his questions to you, and thereafter the premier, and thereafter any other commissioners who might wish to put questions to you. You possess, as I see it here, 3 degrees, B. Juris, LLB, and LLM, is that right?
That is correct, Chief Justice.
When did you get them, and from which universities?
The BURIS and the LLB I got from the University of Durban, Westville. That should have been 1993.
Please speak up a bit. Maybe bring the mic closer if necessary.
Is that better, Chief Justice?
Yeah, I think raise your voice a little bit. Yeah.
Oh, okay. The BURIS and the LLB I got from the University of Durban, Westville.
Yes.
And that should have been in 1993 and 1996, I think. I'll just have to refresh my memory. It was many moons ago.
Oh. I thought when you got your degrees, it's like when you got married, you would not forget.
1993.
But anyway,
1996, and then the LLM from the University of Pretoria. It was in 2007.
Yes. And which year were you admitted as an attorney?
In 1998.
And you have been practicing as an attorney for about, what, 14 of the years that since you were admitted?
That is correct. This would be my 15th, though, Chief Justice.
The other years when you were not practicing as an attorney, were you in the corporate private sector?
I have the parastatals. I was with the Law Society, which is now called the LPC.
Yeah.
I was with the Human Rights Commission.
Yes.
And I was in intelligence as well.
Yes. So when exactly did you start practicing as an attorney?
So I started immediately after my admission in 1998. And then I practiced for about a year until I took up a position with the Human Rights Commission. And I was then out of practice until 2009, when I then started a practice.
You went back to practice?
I went back to practice, yes, that's correct, Chief Justice.
And you have been practicing since then, and you continue to practice?
I've been practicing continuously since then.
Yes. And your practice, what are the main branches of law that your practice deals with?
It's mainly commercial work, but it's a blend of areas. Contractual work, we do opinions for our corporate clients, interpretation of contracts, and all the work that would be involved in a contract, up to even litigation. So litigation as well, civil and commercial, is one of our biggest practices. We do get, a few aviation matters from one of my clients, because I do have a qualification in aviation law, energy. Used to do some work from the energy regulator, and we do also forensic investigations and collections. And
when you say connections, what do you mean?
Collections.
Oh, collections.
Yeah, debt collections.
Okay,
yes.
all right.
And there's a bit and growing work in administrative law, purely out of passion, really. It is a field of law that I'm not that knowledgeable in, but that interests me quite a bit.
Yes. Do you do trials yourself as such, or do you brief counsel when there are trials?
It's a combination of both. I mean, court work is something that I enjoyed for some time, but I must say that when I started acting, I had to phase that out a little bit, because it becomes very difficult to sustain a litigation matter if you are not going to be there, because when you get a date allocated, it's very difficult to get dates, especially in Gauteng. And once you've got a date, it's like gold. So you have to be available. You have to make sure that you're available on the date that the trial is set down for. So the short answer is that yes, I do trials myself.
Yes, and is that both in the Match Court and in the High Court?
Both, Chief Justice.
Yes. So in some cases you brief counsel, in other cases you do the trials yourself?
Indeed.
Okay, all right. And does your practice have a lot of motion court work?
Yes, that's predominantly the court that I have appeared in the most over the years.
And your motion work would involve what types of cases? Liquidations, matrimonial matters, other matters, or what types of matters would fall under your motion court in your practice?
We're a combination of matters, matrimonial matters like Rule 43s, summary judgment applications, I think other interlocutory applications that you could think of, exceptions, any interlocutory application that could be involved in the course of a trial.
And you said you have acted as well, is that correct?
I have indeed acted, Chief
In
Justice.
the High Court?
Yes, Chief Justice.
Okay. Are you able to indicate for what period you have acted? And when I say for what period, I'm looking at the aggregate terms or months that you have acted. If you put all of them together, even if they are not, they are not sequential.
I think the last time I counted, I was at 38 weeks.
38 weeks.
Yes, Chief Justice, I have since acted for another 10 weeks. So I would measure it at about 48 weeks to date.
Oh, okay. Excuse me. And when you have acted in the High Court, have you done trials as well as motion court?
Yes, I have.
Do you have a recollection maybe of about how many judgments you have handed down during the 38 weeks, more or less?
I think in the 48 weeks, I think I can calculate it to the 48 weeks. I have counted a total of 71 judgments that I was involved in. But of the 71, I scribed 64.
I'm sorry, you what, 54?
I wrote
54.
64.
64, yes.
Yes. So the other 7, I was part of the panel, but I was not the scribe on 7 of those 71.
Okay. So you have been able to write at least 64 judgments during your acting stints, different acting stints.
Yes, Chief Justice.
Yes. And the branches of law covered by the judgments that you have written, are you able to indicate what branches of law, roughly speaking, they cover?
They varied from criminal matters, civil matters involved insolvency matters, matters relating to trust law, and your usual procedural issues that would ordinarily come before courts, like your exceptions. I think if I look at the grid, I would be able to look at a matter and be able to know what it was about. If
I
you would allow
I don't
me.
need you to be exact. I just wanted you to give the commissioners just an idea.
A broad idea.
Even if it's not precise.
Matrimonial matters as well. There were matters involving immigration law. There were administrative reviews. There were commercial matters involving, I think I had one tax law matter, and I did attract, I think, about 2 matters involving construction work. And yes, and I think energy law as well.
Yes.
Yes.
How have you found presiding in trials in the High Court?
Look, it's a daunting task, Chief Justice. It's something very different from being in practice. For starters, you have to switch your mind from being involved in the matter. You're not one of the litigants, because naturally, as a practitioner, when you are faced with a matter, you can already see where this matter should go. But when you sit as a judge, that is not your task. In fact, I think I dare say that you should try and avoid making a decision before you've had the matter fully ventilated before you. So that was the first challenge for me, that I had to switch and listen and read the papers and make perhaps a prima facie view before my view is settled, because your prima facie view changes a couple of times during the course of the hearing of the matter. So that is one aspect I would like to mention. The other issue is the learning that you get from presiding over matters. It's priceless. It doesn't come easy. It comes at a cost of changed sleeping patterns, if any. It comes at a cost of what people call not having a life. I don't quite know what that means, but your work is your life. You read, you write. You read, you write. That includes the research as well. That is your life.
Yes.
Yes.
And have you sat in full bench appeals during your acting stints?
I have sat in very few.
Yes.
That I have.
Yes. Are you able to share with the commissioners under what circumstances, if you are sitting on appeal, you would interfere with factual findings made by the lower court?
It's, I think to sum it up, I would say if there's a clear misdirection. Otherwise, I think it goes without saying that as an appeal court, you are not privy to the witnesses. The witnesses are not before you. You simply adjudicating the matter on the record, and you do not have the advantage or the privilege of seeing the witnesses and making factual findings about this and that, about the witnesses, about their demeanor and all related matters. So unless there is a clear misdirection that would lead to a conclusion that no court should have or could have reached the decision that the lower court did, then you may in those instances interfere in that decision.
And if you are sitting on appeal and what's before you that is being appealed against is a decision taken in the exercise of a discretion by a lower court, under what circumstances could you interfere with the exercise of the discretion?
I think once again, the issue of misdirection is a catch-all. But I would say that in addition, where there's been an exercise of a discretion, if the discretion has not been exercised judicially, which in itself is a misdirection, then you may interfere as the Court of Appeal.
I will now allow the Judge President to ask you questions. Judge President.
Thank you, Chief Justice. For the sake of completeness, good afternoon, Ms. Mfanyana.
Good afternoon, JP.
For record purposes, you sat together with me and Judge Skuman in a full court matter, which is a reported judgment on socio-economic rights.
That
Education.
is correct. That's correct, yes.
Center for Child Law versus Minister of Basic Education.
Yes, that is so.
Yes. And in that matter, the full court sat as a court of first instance, isn't it? What is the difference when a full court sits as a court of first instance and when a full court sits as a court of appeal? Is there any difference when it comes to taking the matter on appeal further?
I hope I'm understanding the question
Maybe let me
correctly.
simplify it. Do you need the leave of the full court when it sits as a court of appeal? It sits as a court of appeal, the full
Yes.
court, and it decides in a particular way, and somebody is thereby aggrieved, and they want to take the matter up with the SCA.
I'm saying, Judge President, I would assume that in that case, litigants would then have to petition the Supreme Court of Appeal, which would be the next level. It sort of seems to be the logical, thing to do for me, as opposed to when you were the court of evidence, in which case you would have to seek the leave to appeal from, that court of first instance first.
The full court
Yeah,
itself.
The full court itself.
Yes, thank you. And then on the questionnaire, you mentioned that your litigation proportion when it comes to criminal law is 0%, and then when it comes to constitutional law is 0%, according to the questionnaire. Remember?
According to the reality
Yes,
as well.
Come again.
According to reality as well.
All right.
Yes.
Anyway, would you say your acting stints have served to equip you in those areas where you've been lacking experience in?
Greatly.
Yes. Then 11 of your judgments attracted applications for leave to appeal, you remember?
Yes, I do.
Yes. 6 of those have been confirmed on appeal. Confirm that.
Yes, I do.
And
confirm.
3 were overturned on appeal, and 2 have yet to be heard by the full court and the SCA respectively. You also confirm that.
I would confirm that, JP, and I think to my advantage for the time being, I must say, I must add that of the 3 that were overturned on appeal, there is one that has attracted a further appeal. In other words, my application for leave to appeal was, my judgment was overturned, but the losing party on appeal is now challenging the decision of the appeal court. So I think the jury is still out on that.
Yes. Which one is that, Ms. Mfanya?
Let me just.
If you can remember offhand, I wouldn't love to detain you on that.
I have noted it. I think that is that matter of. It's not Malabo. 1, 2, 3. I think it's the matter of. Yeah, it's the matter of Nondonga. Nondonga versus MEC for.
Please
for
pull
health.
the mic closer to you. Your
I
voice is very
apologize.
soft.
I
So
apologize.
we need to hear you.
I apologize. The matter of Nondonga versus MEC for health is the last one on the grid
Yes.
that was sent to me.
No, the SCA there, if I may help you, dismissed the application for leave to appeal with costs on the grounds that there was no reasonable prospects of success. So in other words, the full court's judgment still stands.
Okay.
Yes. Anyway.
All right.
In its commentary, the GCB has referred to, among others, Chile versus MEC for Health, a judgment that makes mention of case flow management. Now, here is my question. In your view, is judicial case flow management beneficial to our civil procedure system?
It is.
How so?
Over the years, I think we all know that the country has become quite litigious.
Yes.
The courts are flooded with matters, and the finalization rate of the matters is being affected day by day. Now, case flow management, contrary to some belief, is not a matter where judges necessarily get involved in the merits of the matter, but the necessity of directing the litigation and keeping a view on a matter as a judicial officer. I think it's something that can't be, overstated, because it gives a judge the opportunity to direct the proceedings. Look, as a practitioner, I know there are very many factors at play in the course of litigation. A matter may be delayed because parties are trying to sort something out. In the meantime, the court roll is clocked. That matter has perhaps been set down, it's been allocated a trial date. Other matters can't, get through. And on the doorstep of the court, on the day of the hearing of the matter, one or other issue is outstanding, and the matter, cannot be heard. So I think case flow management then is useful. I would like to believe in all matters as a matter of fact. Not only, I think there's a case to be made for its introduction in other areas of the law.
Yes. And would you say the Chile matter upholds case flow management, or it simply says it's not necessary? If you've not read the judgment, you may say so, because you penned it a long time ago. I'm just harping on it because it happens to be a judgment referred to by the GCB.
Judge President, I want to make sure that I understand you correctly here. When you say, do I think that the Chile matter upholds case flow management, you mean my judgment
Your
in
judgment
that matter?
in Chile, yes.
My response to that is not going to be very direct for this reason. The Chile matter in itself and that judgment was not per se on case flow management.
Well,
the judgment...
there will never be, sorry to interrupt so that I help you. I'm not envisaging a situation where there will necessarily be a judgment dealing with or enunciating a principle about case flow management. All I'm checking with you is whether on reflection, the Chile judgment upholds or doesn't uphold case flow management. That's all I want to know.
Mm-hmm. Excuse me. I think to the extent that there was an opportunity that was missed by the parties during the case flow management conference, that it didn't uphold it there. However, I think I would like to add that I think for the benefit of the commissioners, what had happened is that the matter had served before me on a condonation application for ILPA COSA, what is it, in institution of legal proceedings against state organs. And the matter had appeared before a colleague, and it was unopposed, and the matter was referred back to case flow management without that court dealing with the issue, with the condonation application. So it went to case flow management, and the parties were then summoned or directed to appear at a case flow management conference before a different judge. So the judge at the case flow management hearing, seeing that the parties are not settling, they just were, worlds apart, referred the matter back to motion court, and that's when it appeared before me. So at that stage, at case flow management, then that opportunity to perhaps bring the parties closer together was indeed missed.
Yes. And then lastly, which of the judgments you penned demonstrates exposure on your part in commercial work? Can you think of any one of the judgments listed?
I think there's a few. I just don't remember the names, but I just remember the issues in the matters, JP. I think I won't waste your time. I'll just go quickly through them. I think the SARS matter, the total human resources versus the Commissioner of SARS, that did. I think Arsenio versus Berry Dust, because that was also a commercial matter. I think Diacher versus Koken, that also was a matter which I think it was the insolvency, like a disposition without value matter. I think Herting versus Summermania also did. Price versus Chantilly Trading did that as well. And.
And so on.
Yes, Jamie.
Could you please indulge me, CJ, one last question?
All right.
Since being interviewed last year, you've acted in the Gauteng High Court, Pretoria.
Yes, JP, I have.
And did that acting stint serve to hone your skills further?
It did.
Yes.
It certainly did.
Thank you, CJ.
Thank you, JP. Premier.
Thank you very much, Chief Justice, and good afternoon to commissioners, and good afternoon to Ms. Mfenyana.
Good afternoon, Premier.
Thank you very much. Don't have much, but I just wanted to check from where you are, is there any area of law in which you regard yourself as requiring further exposure? If any, can you specify? That will be the first question.
Yes, yes. There's always opportunity for learning. I am still at baby level. Criminal matters, I've sort of become comfortable in criminal matters. But I think I still need further exposure. I would like further exposure in criminal matters, both criminal trials and criminal appeals. There are matters which, although they form part of the civil litigation sphere, I would like more exposure to, that being medical negligence matters. Because I think, and I think road accident fund matters alike. These being matters that I did not practice in, or I do not practice in to date in my practice. So I would like to have more exposure to those matters as well.
Thank you, CJ. Once again, do you regard yourself as an activist or a conservative in the sector where you are, one, but also in the Eastern Cape, not necessarily in the Eastern Cape, I think just in the country, there's a currently ongoing rationalizations of judicial areas, etc. Do you think this is a process that has taken so long? Is it long overdue from where you are?
But Premier, I would also like to make sure that I understood the question with regards to activism. You mean activism as an individual or as a judge? From a judicial point of view, rather. Okay. I think from a legal point of view, as a professional, I do regard myself as an activist in my sphere of work as an attorney. Why do I say that? I have a vested interest in the development of younger, particularly female lawyers. And although I have not done enough, because I believe in working maybe one or two young lawyers and female lawyers at a time, and then it carries on and on and on and on. So that is as far as I have been active in that sphere. But as a judge, I do not regard myself as as a judge that subscribes to judicial activism. And the reason for that for me is simple, that the judiciary itself, I mean, in our country, if you look at the rules that govern and the code of conduct of judges, it has not been developed enough yet to allow judges to be so involved, so actively involved. And also, it would encroach on the other arms of government if it goes unattended or unmonitored. So as a judge and an acting judge at that, I think it would be very daring of me to just dive into this environment that I am put in, that I'm being tested in, and I change everything contrary to what the laws of the country say. So no, I am not an activist as a judge.
The other part of the rationalization?
May I ask the Premier to repeat the last part of the question?
The current ongoing the rationalization of our judicial areas. Case in point, where I'm seated, I'm just thinking about what's going on in the Eastern Cape, where someone in King Williamstown can only apply in Grahamstown, whilst there's a 5-kilometer high court just adjacent to that person because of the old order system.
Yes, and you...
your view, I just wanted to get your view.
It's a very unfortunate situation, and I think the reason for it is historic. And unfortunate on the basis that the Eastern Cape is predominantly rural. And it being rural, we know what goes with the rural population, that people are indigent in those areas. And the expectation that, for example, a litigant in, let me say, Buckley East, where I was born, has to travel all the way to Grahamstown to be heard. It's unfortunate, and I understand that there may have been reasons for it at the time, but I would like to believe that we have evolved. The law has got a need, and the judiciary as well has got a need to evolve with the evolution that has taken, place post-democracy. So I do believe that there is a case to be made for that.
Thank you, Premier. Commissioner Nochesi.
Thank you, CJ. The CJ greeted you on my behalf as well. So,
Yes, Mr. Recuse.
look, I was part of your interview on the last occasion, and I was happy. I just have had an interest on these cases, the one that we've just discussed with the JP, for instance, because it is listed here by the GCP as one of those cases, as one of your cases. This is Vechile versus MEC for Health.
Yes, sir.
I'm sorry, before you answer, Ms. Fenyana, I just want to tell commissioners we have gone beyond 35 minutes, so just be aware of time. Continue, and then you can answer the question.
Thank you. No, I will try. I have a few questions. Now, my question relates to that judgment. It seems to me that the judgment involves a declaration that the plaintiff's claim, one, is not prescribed, two, the plaintiff seeking condonation for the late execution. And when I read the judgment, you granted the order declaring prescription, and that the matter is not prescribed purely on the papers, that is on the motion proceedings, in circumstances where there was a dispute of fact, because the defendant is saying the matter is prescribed, plaintiff is saying it is not prescribed. There's a dispute, but you decided to grant that order, one. Secondly, you made no separation, because you have to separate the issue of prescription, as it requires a factual inquiry. Can you reflect on that judgment?
Yes, listening to you now, Mr. Recuse, I'm thinking on my feet that the declaration of whether the matter had prescribed indeed was a matter that was contested by was it the respondent?
Yes. Just 1 second, Ms. Fenyana. Can everyone hear the candidate, please? It's in your interest that they should all hear you. So speak aloud. They must hear you.
Yeah.
Chief, through you, Chief Justice, perhaps it might help if you could ask the candidate to speak directly to the microphone.
Yes.
Not keep on looking at
the people who are asking me questions.
In the direction from which the question came. Yes.
And also understand it's not a conversation between you and whoever is asking the question. You are addressing all of us. Yeah. Okay, please continue.
What I was saying, Chief Justice, very briefly, I think that Mr. Nokesi's question has caused me to reflect on the judgment. And for starters, the issue of the prescription, which I did not mention when I was responding to the judge president, is a matter indeed that came before me in circumstances where the respondent had contested the issue of prescription. In fact, they had alleged that the matter had prescribed, so the matter, that aspect was in dispute. However, the defendant, and I'm still thinking on my feet, and the respondent did not oppose the matter and was not, so when the matter appeared before me, the respondent was not in attendance. So it was basically uncontested. But if I fast forward to the question, I think then, in hindsight, it would have been one of those matters where I would perhaps have had to employ the famous Plaskon-Evans rule in the determination of that particular aspect of the matter.
No, perhaps maybe we don't understand each other.
Mm-hmm.
Let me try and explain. Pleadings have been filed in this matter. Summons, they pleaded. In their plea, they plead prescription of the matter.
Yes.
But because there was this issue of the condonation for the institution of proceedings, they bring the motion proceedings before you.
Yes.
The question is, was it competent? I mean, let me be direct. Was it competent to grant a declarator that the matter is not prescribed in instances where, first, there's no separation of issues? Secondly, this is a trial issue, the issue of prescription. Was it competent to grant that order? I must explain that I'm not reviewing that judgment, but I'm just checking on procedures.
Yes.
Because there are rules here, that must be followed. So when you reflect and look into this, was it competent to grant that order first without making an order of separation, which would, in these circumstances, have been on a notice to the defendant?
Indeed. I think, Mr. Nokesi, whether you intend to or not, I think you have probably made out a case for one to reflect and concede that in hindsight, perhaps there should have been a separation. I will add to that I think the fact that the respondent did not oppose the matter was perhaps a factor that played a part in the decision that was made ultimately.
My last question on this. I find it extremely difficult to understand when you say, because the matter is not opposed, therefore that takes away the duties of the presiding judge. Is it not that the order itself is finally the order of the court? Doesn't matter if the matter is opposed or not opposed. Is it not that it is the duty of the presiding officer to ensure that the rules, the law, there's compliance, complete compliance? So that my worry is when you say one of the things that influenced your decision is simply because it was not opposed. I would accept if you simply say, well, on a reflection, this was simply a mistake, but to take it further and say it is because it was not opposed, that's where my problem is.
No, Mr. Nokesi, my answer to that question was the fact that it was not opposed may have played a role in the decision that was made, in the oversight.
Thank you, CJ.
Thank you. Commissioner Matolo Sepu.
Thank you, CJ. I have to declare that I know Ms. Fenyana, which is part of the South African Women Lawyers Association and very active. I'm not sure why you are so slow or are you afraid today? I know you to be very, very active. Or maybe because you are sitting next to the Premier, I don't know. But she is a very active, she's an activist, by the way. And you should have stated that you are not a mere one trainer. You train a lot of women, especially in fields like energy and all those, like civil aviation, you do that. I think that you must talk and say, this is what I do. But what I wanted to find out, since you have been you appeared the last time here, and now, how do you think you have improved? Not to say the last time you're not bad, but how do you think you have learned from the last appearance up to now?
I think that I have certainly gained much more exposure. I wouldn't say in different aspects of the law, but I think in the adjudication process itself. Having acted back in the Eastern Cape and in Gauteng, which is a totally different kettle of fish altogether, I must say. I have lost more sleep than before, and that as difficult as one may say that is, it goes to building the character and the determination or the necessary skills that are needed for a judge. So it was a boiling pot, which I sort of not necessarily sailed through, but managed to pull through. So that is something that I think I take away from that experience, from the time that I was here the last time in October.
Thank you, CJ.
Thank you. Commissioner Totovo.
Thank you very much, CJ. Good afternoon, ma'am.
Good afternoon, Commissioner.
Are you okay?
Hiya, I am okay.
Okay. I learned that you have an interest in commercial law. But before I traverse my question, I want to ask you a key question. Do you know the Zondo Commission of Inquiry?
Yes, I do know the Zondo Commission of Inquiry.
Yes, as I understand, it's a commission that deals with or investigates allegations on corruption, state capture, and all of that. And one of the key issues that is emerging out of the commission is the fact that there are violations in terms of Section 217 of the Constitution. It deals with tendering processes that when the state procures services and goods, it must be fair, equitable. I'm sure you are familiar with that.
Yes, to some extent, Commissioner, I am.
Yes. Now, it is quite clear that there are these violations that are perpetuated. In your view, are there any defects that you can identify in relation to that provision of the Constitution, the 217?
Chair, with your permission, before she responds, I think perhaps we should check the extent to which the question in itself is relevant to our own criteria. Unless if it is in terms, because if it is in terms of the general knowledge of the law, but you then refer to a specific section, it has to be somehow relevant to the criteria.
No, I will allow it. I'm watching. I want to hear the answer. I think there was a reference to a judgment, if I'm not mistaken, that related to tenders that the candidate dealt with.
I was going to exactly say that.
Yeah.
Yes. My question, if I want me to repeat it, is to determine whether Section 217 of the Constitution as it stands, do you think that it has some defects that needs to be repaired or not?
The Section 217 is the section of the Constitution that deals with the procurement of goods, the transparency and the equitability and fairness. Is that the one? I don't know off the cuff, unless you want to clarify the question, even further. Commissioner, I'm
Yes.
not sure. I'm not sure.
I'll do that for your sake.
Yes.
I'm asking this question because what becomes apparent, especially in respect of commercial law, your area of interest, is that there are so many problems with regard to whether you say state capture, whether you say corruption, whether you say fraud in our country. And that provision of the Constitution tries to regulate how the state must procure goods and services. Yeah. Now, the fact of the matter is all of these things happen perpetually and they need to be arrested in one way or the other. Now, I just want to test your view in relation to whether do we need some improvements in that respect or not.
Allow me to respond to the question not necessarily in respect of the Zondo Commission of Inquiry, but in respect of the procurement of the procurement of goods as allowed in terms of that section, Commissioner. I think there is room for improvement. However, in my practice and experience, having dealt with procurement investigations, I am not certain that I am convinced that the issue is with the section itself, more than it is with the application and perhaps some, opportunism, or corruption, as it were, that parties would get involved in when it comes to issues of procurement. I may mention one aspect. For example, there's a clause that seems to appear in all bids that you do that says let's say company X reserves the right to cancel the bid at its own discretion at any time for whatever reason, and bidders are required to say yes to that, and they do, because if they don't, then the bid is going to be then they're going to be kicked out. So that, for me, on its own, before you even go to how the goods are procured, is a gap for me. It is a problematic area that could cause problems in the procurement of goods or services. So to answer your question in relation to improvements being made, yes, there is a wide scope for improvement. I'm just not certain that I'm able to put my head on the block and say that it requires a constitutional amendment as such.
Okay. No, sorry. No, it's okay. That response. Let me get to the second question, with your indulgence. CJ, as a woman who wants to ascend to the bench, what are those challenges, practical challenges, that you think women of your caliber confront as part of the transformation of the judiciary?
I think one that stares me directly in the face is an assumption that women are generally incapable and that they come second to men. Why am I saying this? I'm saying this because with all the good intentions that are there to develop women, trainings being provided and the like, I think we need to be careful that the starting point that we emanate from as a country is not a starting point that says, because you are a woman, therefore you need assistance. Assistance is always welcome, but the undertone that as a woman you are incapable sort of pushes women to a special category of the community, which is not necessarily the case. So you find yourself having to perpetually measure up to men, whereas the judiciary or any job for that matter is not a man's job. It is a job of a person who is capable, who is willing, who is teachable, who has the energy, the zeal, and the willingness to perform that function, whether man or woman. So that is the first challenge that I think women face. The second challenge, I think, would be women ascending to the bench. I've mentioned sleepless nights and sometimes no sleep at all, and that is not an exaggeration. And I assume that women with small children would find the bench unattractive. And I would like to dare say that if there were to be any kind of assistance, assistance provided to women because they are women, it needs to be on those aspects that make them different from men. That of caregiving and nurturing being one. So those are just a few of the challenges that I think women face.
All right, thank you. Thank you, CJ.
Thank you. I'm going to go to Commissioner Mapisa Ngula, and after that to the commissioners on the online, and it looks like there might be one more question after that. Commissioner Mapisa Ngula.
Thank you very much. Thank you, CJ. Thank you, Judge Fenyane, for availing yourself. Mine is just one quick question, and that is, in your own words, what would be the importance of judicial independence to you, in view of the fact that you come from another, okay, you have your practice, but before then, you've served in the other arm of the state, and a critical one for that matter. You get my point, no?
Yes, I believe I get your question, Commissioner. Commissioner, to me, independence as a judge is the most important aspect. There are many others, but I rank it quite high. For the very same reasons that you have mentioned, we come from different walks of life. And in all these walks of life, we work with people. It is expected that during the course of your performance of your judicial functions, a matter may come before you that you may not necessarily, having declared, because the declaration for me is the first thing that you need to do. You need to declare whatever interest or relationship you have in the matter. I'm sorry, not interest, because I think as a judge you shouldn't have any interest in any matter. But if you should declare whatever relationship you may have. But that does not mean that because you've worked with with all these people that are appearing before you, that you have to recuse yourself in all matters. You will take each case, on its own merit. I may mention, for example, that something that's not related to the arm of the state that you mentioned that I worked for. In my practice, I represent, certain clients. So a corporate client appears, a matter appears before me in the Eastern Cape, and the entity is a client that I had represented on a different matter. Naturally, I had to inform my judge president that this is the situation, and take it from the end the parties, and then the recusal application is something that would follow. It's not automatic as well, but you need to put the parties at ease. You need to be upfront about it. So, judicial independence is very important, but that does not mean that you're going to be recusing yourself in all matters, and then that's unfair to your colleagues, because as practitioners we work with people.
Thank you very much.
Thank you, Commissioner.
Thank you, Commissioner. Ms. Fenyana, may I ask you to try to shorten your answers, please? Sometimes they are quite long. I know it can be difficult, but try. Can I go to commissioners who are attending virtually? Is there any commissioner who has a question?
Commissioner Barnard.
Yes, Commissioner Barnard, go ahead.
Thank you. Ms. Mfanyana, afternoon. I just want to speak to you about the drafting eloquence matter, or just clarity of drafting, let's call it that. So the first question is, in this relation, is when there's parties to an agreement, what is the situation when one party is in breach? Let me put it to you, I put it to you that the other party basically then gives notice or demand for the for compliance, and if it's not complied with, then has the right to cancel. So my question to you in that situation is, who cancels the agreement? Is it the party or the court that cancels the agreement?
I'm not sure if I'm understanding the question, Mr. Barnard. Are you asking if parties enter into an agreement and
I think the question is whether when one party to an agreement has acted in breach of the agreement, who cancels the agreement when there's been a notice of compliance but still no compliance? Is it the court that cancels the agreement or one of the parties? I understood it to be that to be the question, Commissioner Barnard. Am I right?
That's correct.
Yes.
Chief Justice.
Well, if I'm understanding the question correctly, the other parties appearing the court before the court to request cancellation of the agreement. So that party would be the party that would be requesting the cancellation of the agreement, and then the court can either grant that agreement. If the court has granted that agreement has been cancelled by an order of court at the instance of the party that was seeking that order.
So if we can look at at the bundle, at the judgment of the Office of the Premier and the Director General of the Office of the Premier versus the South African Youth Council. So that would be on page 43 of the bundle. And one then goes to, do you have it?
I do, Commissioner.
All right, thanks. So if one then goes to clause 11 of the agreement, so I'll just read the extract that's relevant for me. As the respondent continued to be at war with itself, the applicant on 29 September 2017 served a notice of cancellation in accordance with clause 16 of the agreement. So my question is, was this a notice to cancel the agreement? Or was it a demand for compliance where after cancellation would follow?
Commissioner Barnett, you've referred me to page 43, which is where the judgment starts. Where were you reading from?
Sorry, I'm so sorry. It's paragraph 11, and specifically that's on page 46, although the numbering is a little bit unclear on that page. It's page 46, paragraph 11.
Yes, Commissioner Barnett, I've read that paragraph, yes.
So the question is that a notice of cancellation, or is it a notice of, or is it a demand to comply, failing which cancellation would follow?
They had served a notice of cancellation.
So that the agreement had in fact been cancelled?
No, they were notifying them of the intention to cancel the agreement. In terms of
Sorry, I didn't mean to interrupt.
Yes, in terms of the agreement that they had entered into.
So this is one would call this then the demand. Now my question is wouldn't it then be more give more clarity to the reader if you had drafted and said the notice of intended cancellation or a notice of demand to cancel or something to that effect? Because it is confusing to the reader. This seems like it's a notice that the agreement was already cancelled.
I think it will boil down to legal terminology then, because I am not aware of a notice of a demand to cancel, but a notice of cancellation is a notice of cancellation, but it would still need to be confirmed by the court, which is why the parties were before the court to seek an order that that agreement be cancelled.
Were they not seeking a declaration that the agreement had validly been cancelled instead of the court cancelling the agreement?
I would have to refer back to the judgment, Commissioner Barnett. I just don't see the end. It would appear to me that they were seeking cancellation of the agreement, which is the order that was then ultimately granted by the court on page 51.
See, if one looks on and I agree with that, but if one looks at paragraph 20, then the clause...
Commissioner Barnett, you do realize it's been more than 2 questions. Just finalize, please.
Thank you. Well, I'll put it to you then that in terms of clause 6, paragraph 20, which quotes clause 16, it's a standard breach of contract clause, and basically there should have been some other notice to or demand to cancel, and then a further notice that the agreement in fact had been cancelled. I don't think it's the clarity of the order seems to be that the court was stepping in and cancelling this agreement, whereas it seems like there should have been a declaration that the agreement had been validly cancelled. But I'll leave it at that, and then you can perhaps respond to that. Thank you, Chief Justice.
Thank you. Did you want to say anything in response to that, Ms. Fayana, or not really?
No, Chief Justice.
Okay, all right. Commissioners are attending virtually. Is there anyone else who had a question?
Thank you, CJ.
Yes.
Okay, I don't have a question for Ms. Fenyani, but I just want to declare that I know her. She's one of our leaders. And I also commend you, Ms. Fenyani, for what you are doing for young women legal practitioners. We need more women like yourself who can take young women under their wings and mentor them so we can accelerate the gender equality in the legal profession as well as in the judiciary. Thanks, CJ. Thanks, Ms. Penyan.
Thank you.
Thank you.
Thank you, Commissioner. Is that all from the commissioners attending virtually, or is there somebody else?
I have no questions. Thank you, Chief Justice.
Thank you, Commissioner Breitenbach. Commissioner Malema, are you fine? You have no questions? Okay, he is not there. Commissioner Baloy, did you have your hand up at some stage? Okay, all right. I think you are the last one.
I did. Thank you, Chief Justice. Good afternoon, Ms. Mfenyane.
Good afternoon, Commissioner.
You said that you acted for 48 weeks, a total of 48 weeks. Is that correct?
Yes, Commissioner.
And of that 48 weeks, how long of it was, maybe let me ask the question. In that 48 weeks, did you spend time in an opposed motion?
Unopposed?
Yes.
Yes, I did.
And do you remember offhand how long you would have spent in an opposed motion?
A total of 24 weeks.
Okay. In that 24 weeks, or coming out of that 24 weeks, what are your lessons in conducting unopposed motion court that you would list as the lessons that you learned?
I think the first is that before you deal with a matter, you need to ensure that you have read your papers. The reason for that is simply that when parties appear before you and they argue their matter, your view may go, in different ways. And the other lesson is that the parties are before the court to assist the court, so you have a duty to listen to the parties and hear the parties out. And what I also consider to be quite relevant is to engage the parties to some extent with the view to understanding whatever bottlenecks there may be or what the issues are about, so that in writing your judgment, you are not left with gaps.
Yes. You see, the reason that I'm asking the question is because of the discussion that you had with Mr. Nojesi. Yes. When he raised with you your decision on prescription, that you made a decision on prescription. And I am concerned when your answer is, well, the error crept in because there was no opposition, when you say that. Now, talking about my own experience, in fact, is that at the beginning of pupillage, or right at the beginning of your practice, you get told flippantly sometimes that there's nothing like an unopposed matter in court. Your opponent is the judge. When you're appearing without an opponent, in fact, your opponent is the judge, because the judge has read the papers through and through. The judge has looked up the law, has looked at what you are asking for, and the judge is going to debate with you and raise the difficult issues with you, which otherwise an opponent would have raised. Now, your answer to Mr. Nojesi suggests that there was a failing in this case, and I would have hoped that you would list among the things that you have learned in that 24 weeks, that in fact you have to be particularly careful when matters are unopposed, because attorneys and counsel will pass things through you. And I am concerned that that's not one of the things that you learned, especially in the light of your discussion with Mr. Nojesi. What do you say to that?
I think your analysis and I think Mr. Nokesi's engagement are fair. That was an oversight. And I don't think I should be justifying anything about it. I would like to say this, though, that not having listed that as one of the things that I learned in opposed motions does not mean that it is not something that I consider. I mean, you know, when you sitting where I'm sitting, I mean, a lot of things creep in, nerves and all of that. But it is true, and it is something that I am acutely aware of, that especially in unopposed matters, you need to be extremely careful. And I would like to believe that I am extremely careful. But that matter that Mr. Nokesi brought to my attention is just one of those unfortunate matters where I think I committed an oversight.
Thank you. Chief Justice, I have only one other question.
Okay.
This arises from one of your judgments, and it's a judgment of Van Schalkwyk. You'll find it at page 24. It's paginated, page 24.
Yes, Commissioner.
Yes, I mean, you probably do remember this case, but from how I understand it, this is a civil claim, a claim for damages arising from an accident in which the driver was deceased, having driven because of instructions from the employer. Does that ring a bell? You remember that?
Yes, I think that the facts, I remember the judgment, yeah, the facts I vaguely remember, but I do recall this matter.
Yeah. Now you summarize in the judgment that two special pleas were taken, basically being that the matter should not be before court because there's the COIDA, Compensation for Occupational Injuries and Diseases Act, Road Accident Fund. Those special pleas were taken and then pleaded over. And there's an application for absolution after evidence. You don't deal with the special pleas, the two special pleas. You instead go on to deal with the plea over, or the merits, in fact. You hear the case at the end, you grant absolution. Now, there are quite a few things that I would have loved to discuss, but I realize we don't have time. But at paragraph 13 of that judgment, you set out what you say an absolution from the instance engages. You say it follows from the above that the court in such an application, that is absolution, does not concern itself with the defendant's plea, but rather with whether the plaintiff has discharged the onus of showing the existence of a prima facie case. That's what you say at 13. But then at 24, you then say, no, not at 24, I do apply, at 14, in fact. At paragraph 14, Chief Justice, if you would just bear with me, I've lost my reference. In fact, it is paragraph 20. I do apologize for that. Under the heading causation, you then say, in view of my finding that there is no fault attributable to the defendant, and let me stop there. I'm struggling with how you've defined the test for absolution, and then here you now have concluded that the defendant is not at fault. You seem to have gone against what you set out as the test. Do you want to explain that?
I'm not sure if I'm understanding the question correctly, but you can stop me if I'm not answering you, Commissioner. My understanding is that both these paragraphs that you're referring to seem to highlight the fact that what the court confines itself in an instance where an absolution is sought is the plaintiff's case without, hearing the defendant's case. It seems to me that both these paragraphs would confirm that that test. I'm not sure
So
where there is a discord.
That's what I'm asking. That do you want to explain what it means? Because on my reading of it, it seems like you made a finding on the liability of that the employer is not liable.
I hear you.
Okay. Thank you, CJ.
Does that mean you have no recollection, or does that mean you accept the commissioner's understanding that you made a finding, that there was no fault?
Yes, I mean, if there is no other way to interpret paragraph 20, Chief Justice.
Yes.
Because it seems to talk to the issue of fault.
Yes.
Not being attributable to I wonder if it doesn't refer to the plaintiff, but it says to the defendant. I mean, that's the judgment as it stands. But it would seem to me that, I mean, the case of the defendant had not even been heard. I mean, in an absolution matter. But that's the judgment as it stands.
What do you want to say to the commissioners about it? Are you saying it was correct to do it that way? Are you saying you realize it was a mistake to do that?
Ordinarily, you wouldn't make a factual findings, and this is what it seems that the judge in the judgment, that is what I did. Having set the test for absolution, I then went to making a factual finding.
But are you able to explain how it came about, or are you not? Because I just want the commissioners to know whether this is a situation where you say, look, I realize I made a mistake, or you say, I can't explain, but I see it's a problem.
Okay, I can. I think if I remember now correctly, if you look at the judgment, the way it is crafted, that paragraph appears under the issue of causation. So the issue of causation was not dealt with at all, not even in the judgment. That is the only paragraph that would contain the issue of causation. That the matter having been, the court having accepted that absolution should have been granted on the basis that the plaintiff had not made out a case for the defendant to answer to. So I would like to believe that is what the judgment was referring to, that there was no a case for the defendant to answer on the basis of the case that had been presented by the plaintiff.
I think we've come to the end of the interview. Thank you very much, Ms. Mfenyana. I'll give you about 3 minutes if there are 2 or 3 points that you want to emphasize that the commissioners should take into account in addition to everything else when they consider your candidature. If they are, but you might say you have said everything that needed to be said and you have nothing to add.
No, Chief Justice, there aren't.
Sorry?
There are not.
They are not, okay. Thank you very much. Once again, we thank you for availing yourself. You are now excused.
Thank you. Thank you very much.
I want to say, commissioners, I think when I look at the number of commissioners who asked to ask questions to this witness, there is a substantial reduction in the number. But it's just that those who did ask questions, they took longer. So let us try the best we can without compromising the quality of the interview, to make sure that we don't finish too late.
You have depleted your airtime.
appreciating that I'm one of the short persons who
Yes. Thank you.
Maybe, CJ, let me mention that I will try and cover much scope as possible, making it easier for the commissioners to simply keep mum sometimes.
Yeah. 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 No, the bottom line should be that at the end of the day, we must be satisfied that the process, the interview was fine. Yeah. Yeah. Well, I want to say it didn't help that I greeted the candidates on behalf of everybody.
If and longer than the one in the Constitution. Oh. Good afternoon, Mr. Naidu.
Please switch on your mic.
Thank you. Good afternoon, Chief Justice. Good afternoon, Commissioners.
How are you this afternoon?
Very well. Thank you, Commissioner.
Thank you. I've greeted you on behalf of everybody.
Thank you.
So, yeah. We thank you for availing yourself to be considered for appointment as a judge of the Eastern Cape Division.
It's an honor and a privilege to be here. Thank you.
Thank you. I will ask you certain questions, whereafter I will allow the judge president and the premier, and thereafter other commissioners. I will appeal to commissioners that as I ask you questions and as the JP asks you questions, if they are going to have any questions, they try and formulate their questions crisply so that they are short. And when you answer, I would also appeal to you to try and give crisp answers.
Endeavor
Is
to
that
do
all
my
right?
best, Chief Justice.
Yes. Okay. Now, you hold 2 degrees and a diploma, is that correct?
That's correct, sir, Chief Justice.
It's a BA degree and an LLB degree, is that correct?
That is correct.
And the diploma is a diploma in insolvency law and practice, is that right?
Yes, Chief Justice.
And you got your BA from the University of Cape Town and your LLB at the University of Natal.
That's correct, sir.
And your diploma you got at the University of Pretoria.
Yes, Chief Justice.
And respectively, they were obtained in 94, 99, and 2005.
Yes.
And you did your articles of clerkship from 1999 to 2001, is that right?
That's correct, sir, Chief Justice.
You were admitted as an attorney in 2001.
Correct.
And you, 2001, is that correct?
That is August 2001, Chief Justice, yes.
And you worked as a professional assistant up to 2006, and thereafter as a director.
That is correct.
Yes. Have you been practicing law since then up to now?
That is correct, sir, Chief Justice. I think my calculations is almost 23 years.
Almost 20 years?
23.
Okay, yes. And your practice, do you do a lot of trials yourself in your practice?
Chief Justice, I left private practice in April 2010, and I started with Legal Aid South Africa on the 1st of April 2010. So during my period in private practice, I attended to many criminal trials. I did a few civil trials in the Magistrates Court and a few High Court matters. Since my employment with Legal Aid South Africa, I'm involved in quite a bit of civil legal work in the High Court and the Appeal Court in Grahamstown, Makanda.
So what is the answer to the question whether you do trials? Is it that you,
Correct, sir.
You only do it now that you are under Legal Aid Board, but not before? Or is it that when it was before, you did criminal trials and not civil trials, but once you were under legal aid, you did both?
To confirm the answer, Chief Justice, I did mostly criminal work while in private practice, but I did attend to many civil trials in the district and regional court. I did not attend to civil trials in the High Court. Once employed with Legal Aid South Africa, I attended to many trials and opposed motion matters in the High Court.
Yes. And when you do trials, did you do them yourself as such, or did you do them with counsel, having briefed counsel?
No, I did all the trials myself, Chief Justice.
And in terms of civil trials, the ones that you do, what types of cases do you get involved in? Is it civil claims against the Minister of Police and other government ministers? What types of branches of law or types of cases are involved?
No, it's mostly contractual disputes, Chief Justice. The trials that I have attended to in the High Court, mostly contractual disputes involving people that qualify for legal aid, and obviously plaintiffs And then if we're talking about opposed matters, more often than not, they lead to trials, mostly administrative law, it's contractual law, also family law disputes as well, Chief Justice.
Is all of that under the Legal Aid South Africa?
Correct, so Chief Justice.
Yes. And you have acted in the High Court as well?
That is indeed correct, Chief Justice, since 2016.
Yes. And for how long have you acted?
Chief Justice, according to my calculations, it's almost 8 months in total.
8 months?
Correct, sir, Chief Justice.
Over a certain period?
From 2016 until 3rd of December last year.
Is that at a stretch? Not at a stretch?
No, not at a stretch.
Periodically, yeah.
It's intermittent every year.
Okay, all right. And when you have had a chance to act in the High Court, have you done both motion court and trials as an acting judge?
Yes, Chief Justice, most definitely.
As an acting judge, have you done criminal trials?
Yes, Chief Justice. According to my record, I think I've handled 3 criminal trials.
Up to completion?
Up to completion, Chief Justice.
And civil trials, how many have you done, if you are able to tell us?
About 5, according to my
About 5 civil trials?
Yeah, about 5 civil trials.
Yes.
To completion, Chief Justice.
And motion court, how have you found it to be as an acting judge?
I've done motion court duty every time I've been asked to act. It is challenging at times with the volume of work, but I found it very fulfilling with the matters that one attends to and the parties that appear before you, and I enjoyed it, Chief Justice.
Yes. Have you sat in full bench appeals?
Yes, Chief Justice.
Yes. Under what circumstances can you interfere with a decision taken in the exercise of a discretion when you are sitting on appeal?
Well, you have to look at the discretion as applied by the lower court in the matter and see whether the presiding officer applied their mind to the matter, and it's only then that you can make a decision as to whether you should interfere. But it's actually as a last resort if the presiding officer really didn't apply their mind to the matter.
Mm-hmm. And under what circumstances can you upset factual findings when you are sitting on appeal, the factual findings of the trial court?
Once again, Chief Justice, if you have to look at the transcribed record of proceedings and you find that the presiding officer in the lower court had materially misdirected themselves with regards to factual findings, then you can make a decision that those factual findings were indeed incorrect and in fact, set aside those findings.
Mm-hmm. Now, in terms of the branches of law that have been covered by the types of cases you have done in the High Court when you, as an acting judge, what can you tell the commissioners? What kind of branches of law have been covered by the experience you have been exposed to as an acting judge?
From my recollection, Chief Justice, there is obviously the criminal law aspect. There have been civil trials, contractual, commercial disputes. There's also been certain matters where servitudes were involved. One matter that's been taken on appeal. Most of the time it is applications and opposed motions dealing with, for example, Rule 30 exceptions and striking out. So it covers a wide variety, commercial aspects, contractual law, administrative law, quite a range of civil aspects, Chief Justice.
About how many judgments would you say you have written as an acting judge?
Altogether, including criminal and civil?
Everything.
Close to 30, if
close to 30?
Close to 30.
Yeah, and those are written judgments?
Correct, so, Chief Justice.
Yes. Some of them come from your motion matter and others motion matters and others from trials.
Yes. It's made up of criminal trials, opposed motion applications, which then there's civil appeals, criminal appeals, all-inclusive, Chief Justice, as well as a review that, if I recall.
Yes. I will now allow the Judge President to put questions to you. Judge President.
Thank you, CJ. Good afternoon, Mr. Naidu.
Afternoon, JP.
In paragraph 6.2.1 of your application form or the questionnaire, you stated that the proportion of your litigation work in criminal law is 0%.
At the moment, yes, JP.
Yes, but then my question is very simple. Have the acting stints given you sufficient exposure in criminal work?
Chief Justice, taken collectively with my experience in private practice, where my work was to a large extent criminal work and high court criminal work, where I represented numerous accused in the High Court. One of the trials that I attended to was State versus Clifford and others, which ran for 4 years. I garnered sufficient experience during that time, as well as I utilized that experience when I attended to criminal trials as an acting judge. A case in point is because I was so au fait with a lot of the practices of accused persons, I was also well aware of the tricks that they would try to play to try and get matters sort of delayed, and I attended to it accordingly.
Yes,
JP.
Thank you. Now, in their commentary, NADEL expresses reservation regarding the current demographics in the Eastern Cape. That is the entire division. Let me postulate or give you a picture. The last statistics or the last consensus that was conducted was in 2016. And this is the picture relative to the Gqeberha High Court jurisdictional area. You have in all 1.152120 million. That is the entire population. And then you have Black African, 60%, Colored, 24%, Indian Asian, 1.1%, White, 14%, and other population groups, 0.9%. So the concern is expressed regarding the current demographics in the Eastern Cape. Do you have any comment to proffer on that?
Chief Justice, yes, Nadel's comments are somewhat a bit vague because they're not saying exactly what do they mean by the demographics. Are they saying that there's insufficient female candidates? Are they saying that there's insufficient minority candidates?
Yes.
If so, I think I would fall into
Maybe let
that
me
category.
help you. Based on the scenario that I postulated or that I referred to, I'm talking about the Gqeberha High Court jurisdictional area. Looking at the composition of the bench in Gqeberha, and having regard to the fact that if you look at the entire population in that jurisdictional area, you've got Black African 60%, Colored 24%, Indian Asian 1.1%, White 14%, and other population groups 0.9%. So the more opposite question is whether your appointment would speak to a healthy demographic picture in Gqeberha, given the facts that I've narrated or set out.
Most certainly, Chief Justice. There is no Indian or Asian judges at the Gqeberha High Court. My appointment would most certainly represent the 1%
Yes.
that you mentioned.
Compare the colored population and the Indian population. What would you say?
Yes, there's certainly a greater colored representation. But and if we're talking specifically about colored and Indian populations, growing up in Gqeberha, I can almost say one can assimilate the both race groups as one because we all grew up together like that. But I understand your question to mean that because there's a greater colored population,
Yes.
that necessarily one would want to appoint a colored candidate, so to speak. And my response to that would be as follows. I've dedicated myself to my hometown of Gqeberha. Whilst I had many opportunities to go for more lucrative employment elsewhere, I chose to make a difference in my community, in my city, and in my province. It would be the greatest privilege and honor if this commission found in my favor to be appointed and to not just represent a 1 percentile, but be representative of the people of Gqeberha as a whole.
Yes. We've got 3 Indian judges in the Eastern Cape, 1 in Umtata, 2 in Makhanda. Would you say, given that demographic picture against the bigger picture, the appointment of an Indian judge would give rise to a healthy demographic picture?
Chief Justice, I would agree with you that I must say that it would, because I think if we have a representative person in each of the high courts, then that would represent the city. I mean, I'm from Gqeberha, born and raised. The message that it'll be sending out to my city is that one of their own has been appointed, and I'd be representing their best interests.
Yes. Thank you, CJ.
Thank you very much, Premier.
Thank you very much, CJ, and good afternoon, Mr. Naidu. I think I'm covered a lot. Just one question. What do you believe are the challenges facing transformation in the Eastern Cape courts, if any?
Premier, where do I begin? I've attended, like I said, I grew up in Gqeberha in the East, and I've practiced in many of the courts in the Eastern Cape. There is still a great disparity between previously disadvantaged members of the legal fraternity, and it's slowly but surely getting right. But the biggest challenge is that there is insufficient representation. If one had regard to the letter from Nadal, which basically said that they acknowledged that I was a member of Nadal, but they were not sure as to why I left Nadal. And commissioners would have noted that I'm a huge proponent of social justice and equality. As much as I was honored to have been part of Nadal and what they stood for, and the purpose of furthering previously disadvantaged attorneys and advocates, I grew frustrated because one of the main issues that I was a proponent for was that I felt that the local municipality briefing patterns were very skewed. They had attended to only briefing mainly white firms, and very little, if no, briefing went to non-white firms. And year in, year out, I would stand on my soapbox and tell Nadal, we need to engage with the municipality. We need to sort out the skewed briefing patterns. This is not right. And this was way back in 2013. Another issue which I was frustrated about is that I wanted Nadal to engage meaningfully with the banks. Their briefing patterns with regards to briefing firms and advocates and junior counsel mostly went to white firms and white counsel. And that frustrated me and angered me in a way. And I felt that I'm not getting anywhere. I may as well just stick to where I can make a change. And that is mentoring the candidate attorneys at Legal Aid South Africa and lecturing at the practical law school where I could have an influence on up-and-coming attorneys and advocates and make a meaningful change. So those are still the issues that are prevalent now, Premier. Thank you.
Ngozi CJ, thank you.
Thank you, Premier. Commissioner Nyambi.
Afternoon, Mr. Naidu.
Afternoon, Commissioner.
I have just one question. If you can share with us two attributes of a good judge, mainly focus on those that you think you possess.
Passion for justice and time management. The reason I say time management is because the workload of a judge is time consuming. And if you don't manage your time adequately and properly, it will soon snowball. And once it snowballs, then you're not giving effect to the norms and standards, the 3 E's I like to call it: efficiency, effectiveness, and expedience. If you can manage that, then you're on a good footing to be a judge to handle most workloads.
Thank you. Thank you, CJ.
Thank you. I encourage the one-question approach, which is done voluntarily. Commissioner Singh.
Thank you very much, Chief Justice. I'll make my question part A and part B. I know in law you'll have a number of parts. We politicians, Chief Justice. Good afternoon, Mr. Naidu.
Good afternoon, Commissioner.
So the first question is, you involved in legal aid, and I see you do a lot of training and upskilling and teaching younger lawyers on court procedures, et cetera, et cetera. Now, have you given any thought that if you are appointed to the bench, how is that area? Isn't somebody going to be deprived of that kind of knowledge and passion that you've had to train them?
I think, Commissioner, I have encouraged many of my colleagues who are attorneys to step up. And for instance, I was lecturing alternative dispute resolution up till last year. And this year I decided to give a colleague of mine, a female, an opportunity to lecture. So I think there are sufficient people that can take up the cudgels or the reins in the fight for social justice, Commissioner.
So you'll leave a legacy.
Well, I hope so.
The second and last question relates to your view on public broadcast of trials. I read somewhere that there was a legal journalist, I think Mr. Beamish or somebody, that took exception to you not allowing the broadcasters in a particular very famous trial. What have your views changed, and what is your current view?
Well, I think we need to put it into perspective first. I think I was a little disappointed with Mr. Beamish's comments. I was entrusted by the Deputy Judge President with a very high-profile criminal case, which garnered much, media views. And Mr. Beamish found it necessary to email my clerk at the time saying that he wanted intermittent access to filming basically whenever he wanted. Now, I'm a huge proponent that justice must not only be heard to be done, but must be seen to be done as well. But judges cannot engage with members of the public. According to SANEF, the South African National Editors Forum, which I hope Mr. Beamish is a member of, they have a guideline directive saying such matters must be done by way of application to the court. Why? Because then you can afford the state as well as the accused person to provide input as to whether they oppose it or not, because you've got to balance the right of freedom of speech, which is the media, as well as the right of privacy and fair trial. So Mr. Beamish was advised on numerous occasions by the state prosecutor, Mr. Beamish, you need to file a formal substantive application to court because we intend as the state witnesses have objected to being formed, and you need to bring a formal application. Mr. Beamish chose not to comply with that on numerous occasions. Had Mr. Beamish filed an application, I would most certainly have reconsidered my decision. The decision that I made was balancing what I had from consultations with the state prosecutor, as well as with counsel for the defense, and from the deputy judge president himself. And I look back at the premier case, which was a forerunner to the Sioni trial, which was the state versus Christopher Paniotto. And I looked at the order that that judge made, Justice Chetty made, and I drafted my order on the exact same basis that Justice Chetty did. And the order was that filming could take place at the beginning of the trial for reading out of the indictment, opening address by counsel, closing address by counsel, and then for judgment and sentence. I would most certainly have reconsidered that order had Mr. Beamish filed a substantive application, and which would have also allowed the state to file opposing papers. I would have considered everything in its entirety.
Thank you, Chief Justice. And lastly, you do have an address, I suppose, because in your questionnaire, you haven't put an address. Normally, the applicants put an address on the questionnaire. Thank you.
I apologize. I think it's in my curriculum vitae.
Okay, all right. Thank you very much. Let me go to the commissioners who are attending virtually. Commissioners attending virtually, is there anyone who wishes to put questions to the candidate?
No questions. Thank you, Chief Justice.
Thank you very much, Commissioner Bradenbath.
No question from my side, CJ.
Thank you, Commissioner Shabangu Ndawe.
No questions, Chief Justice. Thank you.
Thank you. I take there is no question from anybody attending virtually. I think we have come to the end of this interview. Thank you very much, Mr. Naidu. I just give you 3 minutes to make certain points that you want to emphasize, if there are any, to the commissioners. But if you are satisfied that you have been able to say all the important things you wanted to say, that would be fine as well.
I think I would regret not having an opportunity to say this, Chief Justice of the Commission.
Yes.
Our Constitution embraces the opportunity for social justice as well as equality. There is still now a huge disparity between the haves and the have-nots, and as long as there's this great disparity, there will not be equality, and there won't be freedom, and there won't be true justice. I endeavor to pursue social justice and equality for the rest of my life, and I hope that these are the qualities that I will bring to the bench if the commissioners so feel that I'm worthy of being appointed. And it would be the greatest honor and privilege of my life to serve the members of my community, my city, and my province in this capacity. Thank you, Chief Justice.
Thank you very much, Mr. Naidu. Once again, we thank you for availing yourself. You are now excused.
Thank you, Chief Justice.
Thank you.
CJ, I suggest that we should have incentive for the good work which has been done by the commissioners with regard to this, and perhaps the incentive should be that from now henceforth they are ones who are going to put questions to the candidates.
I think I should take a 5 minutes break because I can't take a break in between. But that doesn't necessarily mean anyone who doesn't need to go out should go out. So only those who might really need to. I just want to quickly, I'll be 3 minutes.
Chief Justice, and good afternoon to the commissioners.
How are you this afternoon?
I'm very well, Chief Justice. Thank you very much. And how are you?
I'm all right, thank you. I've greeted you on behalf of all the commissioners, and all the commissioners are fine too.
Thank you, Chief Justice.
We thank you for availing yourself to be considered for appointment to the Eastern Cape Division. But before I ask you questions, Judge President Lehodi wishes to say something.
Well, it's a declaration, Commissioners. I had the opportunity to interview this candidate for the position of a regional court president. And I also had the opportunity to prepare a memo to the Minister for Appointment. So in the event I happen to vote for her, if that is what is going to happen, I just thought I needed to disclose that. And by the way, she is blessed with a good voice.
Thank you. Ms. Nongembu, I'm going to ask you certain questions, and once I'm done, I'll ask the Judge President to put his questions to you, and the Premier, and thereafter any other commissioners who might wish to do so. I will ask you to try your best to give crisp answers to the questions. I'm confident that the commissioners who will ask you questions will also ask you crisp questions. Thank you. You hold 2 degrees, is that correct? BA Law and LLB?
That's correct, Chief Justice.
Both of which you obtained from the University of the Western Cape?
That is correct, yes.
And respectively, you got them 1996 and 2007?
That's correct, Chief Justice, yes.
You worked as a prosecutor for some time, and then you were appointed as a magistrate?
That is indeed correct.
Did you start off as a district magistrate?
That is correct, yes.
And you ended up in the regional court?
That is correct, Chief Justice, yes.
For how many years were you a district court magistrate, and how many years have you been a regional court magistrate?
I was a district court magistrate for 5 years, Chief Justice, and I was a regional court magistrate for about 5 years.
Yes.
Yes.
When you were appointed as a district court magistrate, was that in 2005?
That is correct, Chief Justice. Yes, it was in 2005.
Yes. When you were a district court magistrate, did you do civil matters?
As a matter of fact, I did, Chief Justice, yes.
So you did both civil and criminal
law, yes, as well as family law, yes.
Yes. And then as a regional court magistrate, you did mostly criminal matters, but you have done some civil matters as well?
I did civil as well, Chief Justice. I think the last 2 years as a regional magistrate, I was doing civil exclusively.
Yes. Okay. Now, you have also acted in the High Court, is that right?
That is correct, Chief Justice, yes.
For how long have you acted in terms of months, weeks, if you put them together?
Overall, I've acted for 32 weeks.
About 32 weeks.
That's correct, Chief Justice.
And when you acted as a judge, did you sit in both criminal courts and civil courts?
That is correct, Chief Justice, yes.
And of the period that you have spent as an acting judge, how much, are you able to say how much of that could have been taken up by civil work? How much of that could have been taken up by criminal work? Or are you not able to say?
Actually, I think I can say 80 to 90% was taken up by civil work, Chief Justice. And
yes.
10 to 20% was criminal work.
Yes. Of course, criminal work, you have had a lot of experience in it in regional court. Is that correct?
That is correct, indeed.
Yes. And did you sit in motion court as well when you were an acting judge in the High Court?
Yes, I did, Chief Justice.
And did both unopposed applications and opposed applications?
That is correct indeed, yes.
Yes. And are you able to indicate about maybe how many weeks you might have used to do motion court out of the 30 or so weeks?
If I may, I know...
Is it easy to say?
Yes, I think
Yeah.
it will be, Chief Justice. I know in Gauteng, I think 3 or 4 weeks I did motion court. In the Eastern Cape, I think 1 or 2 weeks. In Northwest, I cannot say in terms of weeks because
Yeah.
we basically do everything throughout.
Yes,
Yes.
yes. How did you find motion court in the High Court?
And it's in terms of the volume in particular, it's quite intense. However, I think I also had the advantage that, especially when I did a civil court, motion court outside specifically in the district court, that was at a time when the regional court did not have civil jurisdiction. And where I was working, which was in Durban at the time, the civil section was a very busy division. So at least one was able then to juggle and to manage, the huge motion court roles. So yes, but then now, because especially in the High Court, it's not only the volume, also the complexity of the matters that you deal with. But with the, I think I was able to manage it eventually. At first, it was a bit tricky, I won't lie. But then with time and also, guidance from colleagues, I think I managed it quite effectively in the end, Chief Justice, yes.
Well, you have been within the judiciary for about, 15 years?
That is correct, yes. That is correct, Chief Justice, yes.
At different levels.
That is correct indeed.
Yes. About how many written judgments do you have? How many judgments have you written that you have handed down?
During my acting period.
Yeah, your acting period as an acting judge.
As an acting judge, I think about 38. If I'm
About
not-
38.
That is correct, yes.
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 Do you remember about many have gone on appeal?
I am aware of one where I granted leave to appeal. Yes, there is one that has gone on appeal. A second one, which is a very recent one, that I also granted leave to appeal. Those are the only 2 that I'm aware of. The others,
Yes.
leave to appeal was refused, yes.
Yes. And have you sat in full bench appeals in the High Court?
Yes, I have, Chief Justice.
And how have you found sitting in full bench appeals with other colleagues?
It's I'm not sure how to put it, but the aspect of it's different from what I'm used to, if I were to put it that way, but good, because sometimes you might find that, especially during the conferences and the deliberations, that some other thing that you may have missed, you are able to see.
Hang on 1 second. Okay, please continue. Just start your answer afresh.
Oh, thank you, Justice. I was saying it's different from what I'm used to, coming from the lower courts. But the good thing about it is that there's, more eyes to every matter. At times, something that you may have, missed. So during the deliberations and the conferences, you are able to engage with colleagues. And so with those discussions, and it also helps you to grow. And yes, you are able to see things. And also the aspect of, sometimes being persuaded, where you were seeing things on a different view. If I were to make a quick example, Chief Justice, recently I was sitting in a full bench appeal. So there was an issue in as far as the costs were concerned, and we were on, opposite ends. But after the discussions and all of that, I was able to be persuaded by a colleague to see the view at the end as to which direction to go in as far as concerns, and at the end we're able to agree on what order to make. So those kinds of things, I think they're quite crucial and important in as far as, the advantages of being in a full bench, which you do not ordinarily get, when you're sitting alone or when you're sitting with only just one judge. Yes.
Yes. And when you have been sitting on appeal and you had to deal with a decision that had been taken by lower court exercising a discretion, what would be your approach in terms of under what circumstances you can set aside a decision taken in the exercise of a discretion sitting on appeal?
Thank you, Chief Justice. The only time you can interfere with such a decision is where the discretion was, where either the judicial officer in the lower court did not exercise their discretion to start off with, or where it was not exercised properly to such an extent that it led to a vitiation of the proceedings. So those would be, otherwise you do not have a leeway to simply set aside a matter where the lower court judicial officer was exercising their discretion. It must be such that their discretion was not properly exercised, or they misdirected themselves, or it was exercised in such a manner that it led to, a failure of justice. And only under those circumstances then can you interfere with such a decision.
And under what circumstances may you, sitting on appeal, set aside factual findings of the lower court, trial court?
Sorry, can you repeat the question, Chief Justice?
When you are sitting on appeal,
yes,
in a matter, and you are called upon to set aside factual findings made by a trial court, under what circumstances may you do that?
Okay. The starting point, the Chief Justice, is that the trial court obviously is in a best position when it comes to factual findings in the matter, because they are sitting there, they see the witnesses, they're able to make, for example, issues of credibility and also issues of demeanor, which you as the appeal court are not in a position to see and to be able to determine. So the only time, therefore, you can set aside factual findings of a trial court is where it is clear that the trial court seriously misdirected itself in coming to that conclusion. So those would be the circumstances then under which you would set aside those factual findings.
Thank you. I will now give the Judge President the opportunity to put questions to you. Judge President.
Thank you, Chief Justice. Good afternoon, Ms. Nongcembo.
Good afternoon, JV.
The world out there may be interested to know how you got to be in the Eastern Cape, and I think I need to tell everyone. You were recommended by President Maya and Judge President Mlambo. That's how you got to be there. I'm just placing that on record. You have acted in other divisions more than you have in the Eastern Cape, not so?
That is correct, JP.
You've not acted at all at Gqeberha?
No, I have not, no.
It behoves me to place it on record that 2 Gqeberha-based senior judges, including the DJP, and with whom you sat in appeals at Bisho, sing your praises.
Thank you, Chief Justice. Thank you, JP.
Now, the GCB has expressed concern that you've not acted long enough to demonstrate your ability or for them to make a proper assessment of your suitability. Would you classify that as a fair comment?
I would say, JP, they base that on having looked at my acting period specifically in the Eastern Cape. But if you combine my acting period, as I already indicated earlier, I've acted overall for a period of 32 weeks.
Yes.
Yes. So, yes, the Eastern Cape Bar Council perhaps may not have had an opportunity, but I think my judgment would speak more to, my abilities as a judge. But I've acted in other divisions as I've indicated, JP, yes.
Thank you. Nadel criticizes you for remaining a member of a political organization whilst a judicial officer. Is this criticism borne out by the application form?
No, JP, it is not.
In that form, you merely said, I was a member of this particular organization in 1991.
That is correct.
I
JP,
see.
Yes, yes.
Thank you, CJ.
Thank you, Judge President. Commissioner Nojesi?
But I'm just following.
Oh,
up on-
I'm sorry.
Oh,
I'm sorry.
okay.
Premier.
Thank you very much.
I think Commissioner Nojesi, you said you wanted to follow up, Commissioner Nojesi. I'll give you a chance later. Let the Premier go ahead.
That follow-up might be serious. Thank you very much, CJ. Good afternoon, Ms. Nongembo.
Good afternoon, good afternoon.
Well,
Yeah.
again, I think I'm generally covered, but I just wanted to check, probably just overall, that do you think our constitution requires an overall in the light of changes in the country? And why, if you think so?
On the overall, Premier, I think we have a very good constitution. I do not think it needs an overall. The biggest challenge is in the implementation of what is contained there is what happens on the ground, with especially the laws that are there to give, a meat to the Constitution, and in ensuring that those are adhered to. But on its own, I think our Constitution, yes, there may be challenges here and there, but overall, I think we have, in fact, one of the best constitutions in the world. I wouldn't say it needs an overall.
Perfect. And thank you very much.
Thank you, Premier. Then I'll give Commissioner Nojesi
It's just a
the
follow-up.
chance to ask.
I was not going to ask a question, but I have to here. In respect of your membership to that political organization, did you tell when you resigned?
No, I did not. But if I may just explain, because my understanding, I was a member for 1 year, and I had joined. That was in 1991 after I had passed matric, because I was at that year not studying. So I was at home and I wanted to be involved in my community. So I was a card-carrying member because I joined as I was actively involved. That was a yearly membership. I only joined for that year, and even my involvement ended in that year because the following year I went to university. I was never involved in politics altogether since then.
The last tip was a follow-up on this. You see, the point is, would you criticize Nadel for reflecting that in terms of your answer? You say, I was in this political organization. You don't say, I stopped in this year. So if you say from 1991 you've been there, is it wrong to say you've been in that political organization? Why you can't take a responsibility?
Now, in that regard, Commissioner, I will accept that. Thank you.
Okay, I just want to understand what you accept and what you don't accept. The membership of the political organization you're talking about, do you know whether a member's membership needs to be renewed after every year or not, or once you have been a member, you don't cease to be a member until you resign? Do you know what the position is?
Thank you, Chief Justice. At least at the time, I'm not aware what's the position now. At the time, the membership was renewable annually. So to me, when the year ended, without me having renewed, then my membership terminated.
Yes, but was that your understanding and continues to be your understanding, or you are not sure what the position was?
That was my understanding at the time, Chief Justice.
Okay, all right. JP?
Thank you for indulging me. CJ, paragraph 8 of the questionnaire is very simple. It says, please furnish particulars of your membership of any political organization, past and present. Then name of organization, position held, period, and then it mentions the name of the organization, and then it also mentions that she was a member, and then period, 1991. I'm just placing that on record, because context is everything.
But sorry, it doesn't say I was a member. It says it's a member. Look, maybe it's an arguable point, but
Hang on,
no, my point is.
Commissioner Nochesi, I haven't allowed you okay, all right. But anyway, we have heard what you are saying. But from what the JP has read, it looks like the candidate's indication in the form was that she was a member during a particular year, if my understanding is correct.
After which it lapsed.
Yes. Okay, all right.
And so which that
Commissioner-
was in that form.
Commissioner Nyambi?
Thank you, CJ. Afternoon, Mr. Klebu.
Afternoon, Commissioner.
The JP, CJ, and Premier covered all the other questions. I was worried when Nochesi was jumping the Premier. I thought there's coup in front of judges. No, it's one question. It's about the objection by Mr. G.R.M. Mokaka, alleging that you are biased. Maybe if you can make us to be comfortable about these allegations so that we understand, and it's going to assist us when we are having our sessions discussing your issue.
Thank you, Commissioner. Let me start first by how the matter came to be before me. Mr. Mukoka is accused number 1 in a matter that involves 12 accused persons. Now, what happened in the matter is that when I arrived in the Northwest, the matter was already on our roll. The matter had been long outstanding on the roll. In fact, the resident magistrate, it's in Mohwase Regional Court, the resident magistrate there had recused himself because there were certain complaints that were brought against him by Mr. Mukoka. So I allocated a regional magistrate, I think about 2 regional magistrates to deal with the matter, but there were a number of problems that arose. But what was my main concern with the matter was that the matter had been very long outstanding on our roll, and this caused by the fact that, firstly, because there were 12 accused persons, at times it would be the accused persons, either one would be in court, others would not be in court, and changing attorneys from time to time. Sometimes it would be the state. So realizing what was happening, I therefore, in my capacity as the regional court president, decided, because one of the things I realized is that there seemed to be problems, and the other problem was that having different magistrates dealing with the matter, especially pre-trial at that stage, it created problems and further delays because new things come up every time the matter is on the roll. So I took it upon myself, as in my capacity as the regional court president, to case manage the matter up until the pre-trial, in fact, up until it was trial ready. And that is what even I placed on record. I said, I will case manage the matter until it is trial ready, at which point I will then allocate a magistrate to deal with the trial, because having dealt with the pre-trial conference, it would therefore, it may have, things come up in the process, so I would not be in a position to deal with the trial. And that is how then I got to be involved in dealing with the matter. There is therefore no merit whatsoever to any allegations that I am biased in the matter. I know there was an application that was made for the staying of proceedings, which I dealt with, and I dismissed the application. I understand he took the matter on review, of which, in fact, I did explain that was his right to do so. But at all stages, I knew, and he knows it because I placed it on record, that I was not going to deal with the trial. My job in the matter was to case manage the matter, as is a requirement when you are a judicial leader, in terms of the norms and standards, and seeing that the matter was not reaching any speedy finalization.
Thanks for the explanation. Thank you, CJ.
Thank you very much. Commissioner Singh?
No, thank you, Chief Justice. Commissioner Nyambi, because I think we come from the same environment, has covered the question of the Mokoka, because we've been reading about that. And I think the JP has covered the issue about the extreme mobility. Good afternoon, by the way, sorry. About your extreme mobility from Durban to Northwest and then Eastern Cape. But I have one question on reserve judgments. And I note that JP had given us an update this morning. All the judgments that are listed here have been delivered. But I do note that some of them have gone way over the 3-month period. some up to 6 months. Can you just explain why that happened in those instances?
Yeah,
Thank
yes.
you, Chief Justice.
Thank you, Commissioner. What had happened, and you would note that most of those, they come from the Northwest Division. What had happened is that at the time, after I had acted in the Northwest, I went back to my office. And the unfortunate thing that happened is that I would email my judgments to my secretary, and then he would hand them over to the DJP, who would then sign them on my behalf and have them handed down by another judge, an available judge. It appeared, in fact, I learned this much later. The secretary resigned in February, and in fact, when I'd spoken to her, she had forwarded my judgments and to the DJP. I learned, in fact, much later that some of the judgments were never forwarded. And in fact, much to my surprise, how I found out, one of the matters that I got a call from the JP in Gauteng saying my name is on the list of outstanding judgments. And that came as quite a surprise to me because at that time I did not have any judgment that was outstanding in the Northwest Province. But yes, that's how that came about. But I have to acknowledge, Commissioner, that perhaps also at first one was not quite as, in the managing, especially with the volume of the work in the High Court. So one was still finding her way. But I was able to, with time and with assistance, and I've grown such that all the judgments, for instance, that were outstanding at the time that I completed my application have since long been handed down.
So these were exceptions rather than the rule, your normal rule.
That is correct, Commissioner.
Thank you, Chief Justice. Thank you, Ms.
Thank you. Commissioner Makwanisha.
No, thank you, Chief Justice. My question was covered by Commissioner Singh.
Thank you very much. I'll go to the commissioners attending virtually. Is there any commissioner who has a question for the candidate?
Chief Justice?
Yes, Commissioner Barnett.
Thank you, Mr. Mondembu. The case I wanted to talk to you about is Jan Oosthuizen and Seuns versus Van Deventer nomine officio. It's the one with one of the points that was raised was in connection with whether a trust has the protection in terms of the National Credit Act or not. So if you would like to refer to it, it's paragraph 6 of the bundle, but I'll be very quick. The basic question is this, there was a point raised on constitutionality because it's a trust that had 3 trustees, and accordingly, you summarize it in paragraph 7 of the judgment. It just says that it's therefore a juristic person. You didn't really want to entertain the constitutionality challenge there, and you say it's because it was pleaded basically. But the question is this, isn't there an arbitrariness between a trust with 2 trustees and 3 trustees? Let's say you have a trust with 3 trustees, it's a juristic person, and 1 trustee passes away, for example. Then you have a situation where you had the protection, didn't have the protection of the Act, suddenly you do have the protection of an Act. So my question is just this, was that not a point which should have been looked at in a bit more seriousness with the court?
Thank you, Commissioner, for that question. The reason why I did not go into detail on the aspect of the constitutionality of the issue that was raised is that when a constitutional issue is raised in a matter, there has to be a notice that has to be given beforehand. It cannot only be raised in argument at that stage, and therefore it was not proper before me. But because I addressed it, because it was raised in argument, but because it was not an issue that I could adjudicate upon, because firstly, there was no notice given to say that they are raising a constitutional issue, and secondly, it was not pleaded on the papers, and therefore that is how I dealt with it in that matter. I mentioned it because it was mentioned in as far as the argument was concerned, and that was the only time that it was raised.
Thank you very much.
Thank you, Commissioner.
Thank you. I take it that the silence means there are no other commissioners who wish to put a question attending virtually.
I have no questions. Thank you, Chief Justice.
Thank you, Commissioner Breitenbach. Thank you, Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Ms. Nonsabu.
Good afternoon.
Can I just say that I really enjoyed reading your judgments. I thought they were very well structured and very well reasoned, all except obviously the one with the typographical errors, which I'm sure you recognize. There is one difficulty that I have, though, and that's in your judgment, the Molefe judgment, Molefe versus the Minister of Police. The
Yes.
judgment begins on page 77.
Okay. The bundle before me, I'm not
Yes,
sure if it's numbered.
It's paginated at the bottom of the bundle. Okay, perhaps if you go to paragraph 10 of the Molefe judgment.
No, not yet. Oh, sorry, look. Oh, that's good. Oh. Thank you. Paragraph 10.
Yes, paragraph 10 of the judgment. And so this is the claim for damages arising out of unlawful arrest and detention, right?
That is correct.
And at this point of the judgment, you're considering the various factors in order to decide what's an appropriate damages quantum, right? And I noticed in paragraph 10 of your judgment that until this point, you take into account all valid factors, and then you reach paragraph 10, and you say the following: this could not be more true, especially at a time such as this for our country, when there are so many demands on the public purse, and as such, and as correctly contended by counsel for the defense, most of which have been added by the COVID-19 pandemic. Now, I just wanted to understand from you, do you believe that this is a valid factor to be taken into account? Increased demands on the public purse brought on by the COVID pandemic?
I think, Commissioner, if I were to say in looking at the judgment, not so much, but that I was mentioning because at the end of the day, when you're considering damages, the main factor is that the award you make is meant to be a solace. So nothing much, nothing less. It's not about, so that was just, in a way, if I were to say, so I'm looking for the correct English word for that.
I think I appreciate your answer. It's just a word of caution. Obviously, if you're looking for basis for appeal, this is the kind of stuff you pick up. Although I accept the answer that ultimately it really didn't feature in your assessment of the damages quantum.
Thank you, Commissioner.
Thank you, Chief Justice.
Thank you, Commissioner. I don't have any further hands. Oh, I'm sorry. Commissioner Baloyi?
If I may, as the sweeper, just
Oh.
Yes, good afternoon, ma'am.
Good afternoon, Commissioner.
Yes, among the comments that have been made, and I see that Commissioner Pillay has made a comment about the typo. There's a comment from one of the commenting parties that they do commend your judgments, but express a concern that you don't pay particular care to your judgments, and so you end up with these kind of errors. Can you just perhaps, just to allay any concern, speak to your process of your editing process until you deliver the judgment?
Thank you, Commissioner. Generally, well, I type my own judgments, and obviously, time permitting, most of the time I would refer it to the researcher to go through and all of that, and it comes back to me. And I would go through it again to check any typos and all of that, and I double check before I have it handed down. I am generally quite meticulous when it comes to such issues. However, the one I know they refer to, you know, I think it was my surname that is spelled incorrectly, and it's unfortunate. I would not lie. How that could have slipped through, I am not sure. It's something that I am very cautious in looking at too. I must mention that also, perhaps for the JP as well, this one, that one other challenge, for instance, I experienced specifically in that I will mention, because I recall having sent, because, you know, with the norms and standards and the times you want to deliver your judgments expeditiously, you find that, you know, the researcher has got other duties as well that he is doing. I remember I took the matter up with the DJP because I sent a judgment and I'm told the researcher is not available, he will only look at, so it creates, you know, a certain problems. I had to raise it to say that, but, you know, because you have time within which to deliver a judgment, because judgment delayed justice delayed is justice denied. So that also at times could have played a part, but I am generally quite attentive to make sure. In fact, it's noteworthy that it would be my surname. The one thing I'm very particular about being spelled correctly, that would be, you know, spelled incorrectly in my own judgment.
Okay, thank you for that. And then lastly, this is an issue that was canvassed with you, but I think in fairness to you, we should also put this so that you clarify it. This was about your membership of any political party, and there was that earlier conversation about 1991, right?
Yes.
Now, in the comments, the comment is why you did not indicate that you were a member of a political party during 2005 onwards, when she became a judicial officer. Maybe just clear that once you were appointed, were you a member of a political party? Did you continue?
Thank you, Commissioner. I was not a member of any political party from the time I started working as a prosecutor in 1999. I was only a member of a political party in 1991, and that was it. Beyond that, I was never a member of any political party.
Thank you, ma'am. Thank you. Thank you, CJ.
Thank you, Commissioner.
Thank you. Commissioner Slim.
Thank you, CJ. Good afternoon, ma'am.
Good afternoon, Commissioner.
I would just like you to allay my concern linked to what Commissioner, now I forgot her name, the Commissioner that just spoke before me, Baloy.
Commissioner Baloy.
Commissioner Baloy, what she asked you concerning some of the comments that was made, that you're not a stickler for detail, and your response to that. Earlier on during the interviews, when Commissioner Singh asked you about the fact that some of your judgments have taken long to be delivered, you indicated that you were not aware that a secretary to whom you sent the judgment was, well, resigned. Which kind of shows to me that you are not very attentive to such issues. Why didn't you follow up when you didn't get any recognition of receipt of that email or acknowledgement of receipt of that email? Are there other things that you may also not be too attentive about? Can you please just address me on that, or the Commission rather?
Thank you, Commissioner. Let me clarify that. I was aware that the secretary had resigned, and I did indicate that. I had forwarded my judgments to her, and she advised me that she had forwarded them to the DJP to be handed down on my behalf, and that is why I then relaxed. So I was under that impression. It only came as a surprise that they never went through.
Thank you very much.
Thank you.
Thank you, Commissioners. I think we have come to the end of this interview. I take this opportunity to thank you, Ms. Nonqembu, for availing yourself, but I wish to give you 3 minutes to emphasize whatever points you wish the commissioners to particularly bear in mind as they consider your candidature, if there are any points you want to emphasize, but if you feel you have dealt with issues adequately, that would be fine.
Thank you, Chief Justice. I think I've dealt with everything, and I do believe the commissioners are in possession of my judgments and everything else that needs consideration. Perhaps I can just thank this commission for inviting me and giving me the opportunity to be here and to be considered for appointment in Gqeberha.
Thank you very much. You are now excused.
Thank you, Chief Justice.
Thank you. I want to applaud the commissioners. Yeah, no. At least now there is hope we are going to finish. Yeah, yeah. Yeah. Good afternoon, Mr. Ngumse.
Good afternoon, Chief Justice.
May I find out whether I pronounced your surname correctly?
Yes, Chief Justice.
Okay, all right. How are you this afternoon?
I am fine, Chief Justice.
Thank you. We thank you for availing yourself for consideration for appointment as a judge of the Eastern Cape Division. I will ask you some questions, and after that, I will allow the judge president to ask you questions and the premier, and thereafter, any other commissioner who may wish to ask you questions. I would ask you to do your best to give crisp answers. I know that's sometimes not easy, but I would like you to do your best to try and give crisp answers. The commissioners will do their best to ask crisp questions too. I see that in terms of academic qualifications, you hold a BProc degree and 2 diplomas. Is that correct?
Correct, Chief Justice.
And the one diploma is an advanced diploma in labor law, and the other one is a postgraduate diploma in criminal justice.
Correct,
Is that right?
Correct, Chief Justice.
And you obtained the BProc from the University of Fort Hare, and the advanced diploma in labor law you got at the University of Johannesburg, and the postgraduate diploma you got from the Nelson Mandela University. Is that right?
Correct, Chief Justice.
You started work as an admin clerk in the Department of Social Welfare Department, but later on you were appointed as a magistrate in 1994, is that right?
Correct, Chief Justice.
After working as a prosecutor for about, 4 years?
Around about 3 years, Chief Justice.
About 3 years. And when you were appointed as a magistrate in 94, that was a district court magistrate, is that right?
Correct, Chief Justice.
And later on, you were appointed to the regional court? Or not really?
No, Chief Justice.
Yes. As a magistrate, did you do both criminal and civil matters or only criminal matters?
I did both civil and criminal, Chief Justice.
Is that right from the beginning, or you only started doing civil after you had been a magistrate for some time?
I started to do civil work mostly from 1998, and then 2000 onward.
Yes. And the types of civil matters that you dealt with as a magistrate, what kinds of branches of law did they cover?
They covered a range of areas, Chief Justice, your applications, your delict, your liquidation, which I dealt with as well, summary judgments, urgent applications. It varied. It
Yes.
varied. The debtors court, which is Section 65 court. So it covered those vast areas, and of course, any other matter which was quasi-judicial.
Yes. And the rank that you are currently on, is it that of senior magistrate?
Correct, Chief Justice.
I see that you became a senior magistrate in 2000, is that correct?
Correct, Chief Justice.
It's quite a long time to remain on the same rank, isn't it? From 2000, that makes it 22 years, or does it not?
Yes, it's about 2000.
Yes.
It's 22 now.
Is there a reason why you haven't risen above that, or is the position that you haven't been applying for promotion, or what is the position? Or there are too few higher positions?
Well, that is also one reason. I had also acted in the regional court, but I think I dedicated most of my time in the work in the district court, which was a variety of work and giving me the opportunity to also deal with a number of areas outside my court where I was heading, which were your sub-offices, and which gave me an opportunity to really work with, I would say, Chief Justice, with those who are not so privileged to get the best quality of our court experience. So I think that has kept me content for most of my time.
So you say there are two reasons why you have stayed on the same rank for 22 years. One is there are not many positions that you could be promoted to above that of senior magistrate, and that you liked the work you were doing in the district court. Are those the two reasons?
Mainly, those are the two reasons, Chief Justice.
Yes. When you acted in the regional court, did you not like the work?
I did, Chief Justice.
Uh-huh.
I did like the work.
Uh-huh. But you chose not to apply for any positions in the regional court?
What happened soon after I've acted in the regional court, that is when I started acting stints in the High Court.
Yes.
And since then, which was 2018, I was more in the High Court with acting stints in the High Court.
Yes. About how many months have you acted in the High Court if you put all the time together? More or less.
It would be not less than...
Or weeks, whichever is easy for you to work with, weeks or months.
In 2018, I acted 3 terms.
Okay, terms is fine. 3 terms, you acted 3 terms.
In 2018. And then in 2019, I think I acted a term. In 2020, I acted a term in the Gauteng division.
So you have acted a number of terms?
Yes.
Yes.
Yes, Chief Justice, yes.
And when you were acting, you did both civil matters and criminal matters in the High Court?
Correct, Chief Justice.
Yes. And did you also do motion court in the High Court?
Correct, Chief Justice.
And how did you find the motion court in the High Court?
It's quite challenging, Chief Justice. But for someone who has at least the background in civil work, it was manageable. Because since my first stint and exposed to motion court in the High Court, I was able to manage it quite successfully. And since then, I never had a problem in the motion court.
How many written judgments have you produced out of your acting stints in the High Court? More or less, you don't need to be exact.
They should be about, if I include the latest, they should reach the number about 60.
About 16 or 60?
60.
Oh, 60, okay. Yes. And that includes criminal and civil?
Correct, Chief Justice.
Have you sat on full bench appeals in the High Court as well?
Yes, I have a number of times.
Yes. And how have you found the full bench appeals?
Very interesting, because there you have, it's either you are 2 on the bench or you are 3 on the bench, so you have different views on a matter, and that you must persuade each other, and especially where I have to scribe the judgment, wherein one has to persuade his or her colleagues to agree with your view. It's been quite interesting, and I have had that experience not once,
Yes.
where I had to convince my colleagues whom I'm sitting with on a
Yes.
full bench.
When you are sitting on appeal and you are considering an appeal against a decision of the lower court, which was taken in the exercise of a discretion, under what circumstances can you set aside the decision on appeal?
If the discretion that the presiding officer had applied is such that it is not a rational discretion, or it is a discretion which that is totally a application of that discretion, then the appeal court would set aside that discretion.
If it is a misapplication of that discretion?
Yes.
Under what circumstances can you, sitting on appeal, interfere with factual findings made by a trial court?
The appeal court would, if it is clearly evident that the lower court had not applied or had not evaluated the facts correctly, and much as the appeal court would always find difficulty in doing so because it did not have the advantage of the witnesses, their demeanor, and how they were coming across. But if the court looks at the findings and find that, look, there's been completely a misdirection in the way the evaluation was made on the findings of the witnesses, be they credible or incredible, then the appeal court would set aside those findings. As I say, Chief Justice, it's something that the appeal court would do very sparingly if we take into account even the latest judgment of Vodacom from the Constitutional Court, that the fact that the appeal court is not in the best position to have listened to the evidence and listened to the facts that were presented, the court would certainly have to find that even if it was not in that better advantage, but the trial court has not looked into these facts correctly.
Thank you very much. I will now give the Judge President the opportunity to put questions to you. Judge President.
Thank you, Chief Justice. Good afternoon, Mr. Numse.
Good afternoon, JP.
Purely for the sake of completeness, you acted for the whole of the first term in 2018 in the Eastern Cape.
Okay. Thank you. Thank you, JP. I confirm that.
And then you thereafter acted from November to December 2018 in the Eastern Cape.
Correct, JP.
And then in 2019, you acted for the first, second, third, and fourth terms, even though from 6 to 17 September 2021, you also acted in the Eastern Cape. So it's 2019, the whole of 2019, right?
Correct.
And then in 2021, you acted from the 6th to the 17th of September.
That's correct, JP.
You've also acted in the Gauteng division.
Yes, correct, JP.
And may I place it on record that when first you did, Judge President Mlambo sang your praises. I'm just placing that on record.
Thank you, JP.
And then Has your recent acting stint in Gauteng served to hone your skills as a judicial officer?
Yes, JP, they have. When I was there in the North Gauteng High Court for the first time, it was during the peak of COVID, and the workload was reduced tremendously that time. But this time around, because things are at least normal, it was quite a huge load of work. It has honed my skill. I can say it in this house that in my last week in the North Gauteng High Court, I was doing the opposed motion of about 11 matters, which all proceeded. And I certainly had to pick up all those judgments, which I have already delivered close to 10 of those judgments. And that was only from the 18th of February up to now. Before I went to the Eastern Cape, and when I go to the Eastern Cape, I had to sit on appeals, and where I was also scribe in those matters, some of which I had to deliver extempore. So it did hone my skill, JP.
Yes.
It did.
Yes. If you were to be appointed and had to preside over 6 opposed applications in the Eastern Cape, in light of the fact that you've presided over 11 applications on one day, would you be had to be complaining?
Not at all, JP. In fact, I have said that, look, one in the Eastern Cape is in much more a better, I would say, position in terms of time, as opposed to what I experienced in the North Gauteng High Court. So certainly 6 applications as opposed to 11 all opposed applications is for me a ride on a cloud.
Yes. More on the technical side. Is there a statutory basis for implementing case flow management in appeals?
Not that I'm aware of on appeals that there's a statutory injunction, JP, to be implementing a case flow management.
Rule 37, capital letter A,
Yes.
gives the judge president or head of a court the discretion to extend case flow management to other proceedings beyond civil proceedings. Would that not be a statutory basis for implementing case flow management in appeals?
Yes, JP, I agree. Were that section to be that rule to be extended, surely I think it would cover the issue of case law management on appeal. Certainly,
Yes.
I do.
Yes, in fact, in so many words, it reads
Yes.
as such. It
Yes.
gives the judge president of a particular division the power to issue directives that may culminate in the extension of the application of case flow management, even in appeal proceedings.
Yes, I agree.
Now, which of the judgments you penned demonstrates that you've had exposure in commercial work?
Unfortunately, the judgment that I would use is still a judgment that is in progress or process, which I picked up in the North Gauteng High Court, where it relates to commercial work, where companies are involved. I haven't, in the Eastern Cape Division, dealt with a judgment which would require me to deal with commercial work.
Thank you, Chief Justice.
Thank you. Premier.
Thank you very much, CJ. Good afternoon, Mr. Mumsa.
Good afternoon, Premier.
Just a quick one from my side, assuming that you have a clue of the current status of that Gqeberha bench, would you or would your appointment give expression to a balanced demographic picture in Gqeberha from where you are?
Well, if I look at Gqeberha bench at the moment, it is consisting or composed of whites and blacks. It has more males than females. Those are my observations. And certainly, it may therefore be seen as not reflective of the real demographics.
Thank you very much, CJ Gosport.
Thank you, Premier. I don't see any hand. Let me go to the commissioners attending virtually. Commissioners attending virtually. Is there any commissioner who has a question, who wishes to put a question?
Chief Justice, if I may.
Yes, Commissioner Barnett.
Thank you, Mr. Tumza. I want to take you to the order in the BDVM trading 4CC versus King's Terrace, where you grant an order, and it's on page 201 of the bundle. So just quickly, the question is that order not too vague to execute? It refers to fascinating stuff, the installation of or the restoration of possession of an internet network, related equipment and related structures. So if one just takes those concepts on the enforceability of that, how would one enforce that? The question is which network and which related equipment and which structures?
Just trying to get to the page.
So 201. So the question is, should the possessions that should be restored, the items not be more clearly defined in the order?
The items that I remember that we were dealing with in the BDVM are the network cables that had been dispossessed. And the restoration that was ordered was to restore those network cables that had been dispossessed or that had been removed.
Thanks. Yeah, it just doesn't say network cables, it says network equipment and related structures. So the question is it not too, it's a bit of a vague order. That's the actual question I want to put to you. Thank you, Chief Justice.
Thank you. On the side of commissioners attending virtually, is there anyone else who has a question?
No questions. Thank you, Chief Justice.
Thank you, Commissioner Breitenbach.
No questions, CJ.
Thank you, Commissioner Shabangu Mdawe. I take it that there's no other question. I think we have come to the end.
No question from me, CJ.
Oh, thank you. Oh, you have joined us online. Yes. Yes, thank you. We have come to the end of this interview, Mr. Ngumse. I thank you for availing yourself. Do you wish to emphasize 2 or 3 points in 2 or 3 minutes that you particularly wish the commissioners to bear in mind as they consider your candidature, or you feel that all issues have been adequately dealt with?
Not much, CJ, that I can say, except to say that I appreciate the opportunity and the privilege to once again come before this body and for me to share my contribution that I can make to the High Court bench.
Yes. No, thank you very much, then, Mr. Ngumse. You are now excused.
Thank you very much, Chief
Thank
Justice.
you. Well, I must congratulate you, the commissioners. It's the October spirit. It's the October spirit. Yeah, October was excellent. Excellent. Mm. Good afternoon, Mr. Potgieter.
Good afternoon, Chief Justice.
How are you this afternoon?
I can't really complain, Chief Justice.
Good. Welcome, and thank you for availing yourself for consideration for appointment to the bench. I understand that in the past, certain people had made attempts to persuade you to make yourself available, but did not succeed. It looks like somebody has succeeded this time.
JP is a very persuasive man. CJ, he told me the first time when I went down there that the understanding is that cattle always graze towards the homestead.
Yeah. No, thank you very much. I'm going to ask you certain questions, and after that, I will allow the Judge President to put questions to you, and after that, the Premier, and after that, any commissioners who might wish to ask you questions. I have known you for a very long time. I think you acted in the labor court at some stage when I was JP, did you not?
That was my second acting term.
Yeah.
The first one was in the CPD, and then immediately after that, when you were JP, I was in the labor court, mostly in Johannesburg.
Yes.
Yes, and then again in 2007.
Yes, and also I can say that I had also asked you to join the Commission's legal team at some stage, but certain circumstances didn't allow you to stay for too long.
Indeed.
Yes, but you had agreed to come to the Commission and contribute.
Yes, Chair, the pandemic unfortunately played havoc with us there.
Yes.
But it was a good sojourn, I must say.
Yeah. Okay, no, that's fine. I see that you, in terms of academic qualifications, you hold a BA Law degree, a BA Honours in Philosophy, an LLB degree, an LLM in Constitutional and International Trade Law, and a diploma in International Trade Law. Is that correct?
That is correct, Chief Justice.
And you got the first three degrees, that is BA, BA Honours, and LLB, at the University of the Western Cape. Is that right?
That is correct, Chief Justice.
And the years respectively were 1978, 1980, and 1981.
That is correct.
Is that correct? And then you obtained your LLM from the University of South Africa.
That is correct.
And the diploma in International Trade Law you obtained from the University of California in 1998.
That is also correct, Chief Justice.
Yes. You have been at the bar for quite a long time. How many years have you been at the bar?
Chief Justice, I opened chambers in June of 1985.
1985.
That's right.
And that makes it how many years? Close to 30?
Yes, Chief Justice, my mathematics is now right.
Yes.
About 37.
Or is it more?
Yes.
It's actually more than 30.
Yes.
Yeah, it's close to 40.
37 actually.
Yeah.
Chief Justice.
That's quite a long time.
Well, it doesn't feel like it though.
Is that reflective of your energy?
Indeed, I sincerely hope.
Well, I hope the JP has heard that in case you are appointed, he can give you a lot of work. You have a lot of energy.
No, he hasn't spared me, Chief Justice. He's a very good man, but he hasn't spared me.
Well, that might not help you. He might give you a lot of work, nevertheless. Now, during all these years being in practice, obviously you would have been exposed to cases from various branches of law. Is that correct?
Yes.
Do you want to just share with the commissioners some of the branches of law that your practice got you involved in?
Yes, Chief Justice, it has taken the normal trajectory of a practice at the bar. Of course, I was an attorney between 1980 and 1985 when I started at the bar.
Mm.
So I started off, I did articles in Cape Town.
Mm.
I couldn't get articles in my hometown back here after I studied, finished off my qualification. So I did articles and I qualified as an attorney and a conveyancer initially, and then practiced as an attorney and then qualified as a notary. As an attorney, I've had a very varied practice. I was very busy in litigation, so I've done the stuff that young attorneys do. I cut my teeth in the magistrates' court, criminal court, running around, learning how to cross-examine. And as I increased in seniority, I had a more office-based practice as an attorney, but still very varied, until I've decided to focus on litigation, which I did for the last 2 years or so as an attorney. And that is what prompted me to go to the bar. And I got there in the beginning of 1985. And as I've said, I finished the pupillage. In those years, it was only 3 months. And I started practicing. And then about a month or so after I had opened my chambers, there was the first initial state of emergency in what was then known as the PWV. And then, of course, it was subsequently extended across the country. And I was drawn into all of the litigation that flowed from the state of emergency. So I've done criminal matters that emanated from that. I've done detainee released applications. I've done a whole host of things.
Yes, you would have done applications for the release of detainees, and during those years, did you also do political trials? A lot of those.
Yes, perhaps too many.
Yes.
Chief Justice, I was doing matters all over.
Yes. And when did you take silk?
I eventually took silk, Chief Justice, if my memory serves me now well. It was Friday the 13th.
Which month, which year?
Of 1996.
1996.
Yes.
Yes. So you have been practicing as a senior counsel for the past, 24 years or so?
Yes. Thereabouts, Chief Justice.
Yes. And have you acted numerous times in different courts?
Yes, Chief Justice. In
the Western Cape, you have acted quite a lot there.
Initially, in fact, Chief Justice, in 1995, I got appointed to the Truth and Reconciliation Commission as a commissioner, and then appointed to the Amnesty Committee. In order to adjudicate amnesty applications, I was appointed acting judge in the CPD, and then seconded to the Amnesty Committee in 1998. So I've acted in that capacity, doing the work of the Amnesty Committee until 2001. And then after I left, the work of the commission was concluded. I had my first acting stint then in 2002, if I remember correctly, in the CPD. And then there were a few that followed on that. And then I also, at the same time, had the stints in the labor court.
Yes. I take it over the years, during your various acting stints, you have reached numerous judgments in the High Court.
I have, Chief Justice, one at, the initial appointments, I've done a host of things. Who's not available.
Yeah.
But I can confirm that I've done
Numerous.
Virtually all of the work that judges do in a division such as the CPD.
Yes. And you have sat in full bench appeals and so on.
I have, Chief Justice.
And of course, motion court as counsel is something you would have a lot of times, as well as trials and so on. But also when you were acting, you would have done all of those.
Oh yes. When you start off as Chief Justice is obviously aware, when you start off at the bar, then motion court is your bread and butter.
Yes.
Yeah. So.
Well, I've been asking other candidates these two questions that I'm going to ask you, but somebody like you who has been in practice for so long, it just feels that one should not. But because I've asked other candidates, I will ask you. When you sit on appeal and have to consider an appeal against a decision that is taken in the exercise of a discretion, under what circumstances can you interfere with such a decision?
Yes, Chief Justice. The underlying issue is whether or not there would be a gross irregularity. It is termed in the judgments, the precedents, as having to exercise a judicial discretion. So if you haven't exercised a judicial discretion, then that would constitute a basis for interfering. Of course, they have unpacked that concept. There are various ways in which they've unpacked it. They say you shouldn't have acted capriciously, on a wrong principle, not for substantial reasons, etc., etc. But basically, it is where there has been a gross irregularity in the exercise of that discretion.
And when you are sitting on appeal over judgment of a trial court, and you are invited to interfere with factual findings made by the trial court, under what circumstances may you interfere with such findings?
Yes, they also, Chief Justice, of course, the judgments use a shorthand. They refer to gross misdirection. Gross misdirection on the facts. Of course, that is a bit more nuanced in the sense that where the factual findings of the court a quo is based on credibility findings, then of course the Court of Appeal is slow to interfere unless there's an obvious ground for doing so. So the Court of Appeal wouldn't readily interfere in factual findings that are based on credibility. But as I say, the shorthand is really if there is a gross misdirection.
Yes. I will now give the Judge President an opportunity to ask questions. Judge President.
Thank you, CJ. Good afternoon, Mr. Potgieter.
Good afternoon, JP.
With your vast experience as a lawyer and your exposure in various branches of the law, let me take this opportunity to thank you for availing yourself in my division in an acting capacity from time to time and availing yourself for this interview today. That having been said, how will your appointment advance the transformation agenda?
Yes. Chief Justice, I know that is what the law says. I'm not particularly keen on the old classification things, but in any case, be that as it may, so far as I know, I have been the only member of this group that I am supposed to represent that has been working in that division, in Kaberga particularly. So my addition to that compliment on the bench there would certainly not detract from complying or promoting proper reflection of the demographics and that requirement that is set in the Constitution.
Yes, finally, you've been in private practice now for something like 42 years, including the period during which you were an attorney.
Yes, somebody helped me write. They said about 37.
37 in all.
37 JP. Yeah.
Thank you. Now, if you were to be appointed, you would serve for approximately 10 years.
Yes.
Does that count in your favor or not?
Well, JP, it's about a decade. I believe that I would be able to make a valuable contribution in that time. I'm well able to deal with the physical and the mental demands of this role. I have, in fact, throughout, even in my practice, JP, been able to maintain quite a strenuous work rate, as it were. So I believe that I'm well able to deal with the demands of this. In fact, it's important for a puny judge, I believe, JP, that you've got to get through your workload. I suppose for any judge, but for a judge in the divisions, you've got to get through the workload. That's your first priority. So you've got to have some methodology, as it were, because it is a very demanding position in terms of time that you've got to invest, etc., etc. So I've been able over the years, and in fact, having had the privilege of working with many senior judges, very, very wise people, been able to work out a methodology of dealing with the workload of a judge. So I've had absolutely no difficulty in doing that. In fact, I have made a point, JP, that once a matter that I've heard is ready to be decided, I would deliver a judgment, give and take, within 2 weeks. I've hardly ever sat on a case that is ready to be decided, and for a judgment to be written for longer than that period.
Yes. If you could indulge me, Chief Justice?
Yes.
One last aspect. I see that you've acted in my division on 3 occasions. The first one being 14 November to 13 December 2019. The second one, 18 January to 26 March 2021. And the last one being 16 August to 18 September 2021.
That's right.
Besides that, I take it that throughout the 35 or 36 years period that you've been an advocate or a practitioner, you have from time to time been acting as a judge, and that therefore the bench has benefited from your skills in the past.
Oh yes, JP, I have acted for over the years, I would say, if you put everything together, for about 4+ terms. So I've spent time acting, and I've made time in otherwise busy practice to make myself available to act.
Thank you, CJ.
Thank you, JP. Premier?
Thank you very much, CJ. Good evening, Advocate Potgieter.
Evening, Premier.
Thank you very much. Just furthering the question on transformation asked by JP, what do you believe are the challenges facing the transformation in the Eastern Cape courts, if any?
Premier, I've had the benefit of doing work, appearing in many of the courts around the country. And I must say that the Eastern Cape division is right up there in terms of smooth running, in terms of good logistics, necessary support for judges. So I'm just dealing with it from that perspective. So it is really a very, very well-run division. And that's why I was particularly happy to be able to work there. It is my hometown, but apart from that, it was a pleasure to work there. So I, in terms of the court and the way that the court is run and the way that the court is functioning, I can't really identify any negatives, as it were.
Through you, CJ, does that mean from where you are, there is an attempt to really address the, I'm just trying to get into a point of the transformative part of it. I hear the efficiency and proper running of the division and all that, but addressing the imbalances of the past, it's where I'm interested at, but also looking at your very rich and very vast experience. To what extent that experience has impacted positively in nurturing young talent, new skills into the division? Do you have probably other young people who have gone through you? Not necessarily young people, also female judges, so to speak.
Colleagues, yes. I have, although I have been based in the Western Cape, I have never really lost contact with the Eastern Cape. In fact, I'm the only member of my family who had landed up there because of the laws in those years. My wife is in the same position. So I've maintained my contact with the province. So professionally, I've been doing a lot of work there. I mean, I've been appearing. Just recently done a big matter in Mthatha, for example, with 2 black juniors. So I've maintained that contact, and I have always been meticulous in terms of empowerment, etc. So from that perspective, I've always been keen to be involved in the Eastern Cape and in the Eastern Cape courts.
Thank you very much, CJ.
Thank you, Premier. Commissioner Singh.
Thank you, Chief Justice, and good evening, Advocate Podgita.
Good evening, Commissioner Singh.
Thank you. Chief Justice, I don't know, and JP, if there's something about disclosure of addresses from candidates who come from...
I noticed it too.
You noticed it?
Yeah, on this one.
This is the third one who doesn't have an address.
Sorry, CJ, if I may.
Sorry?
I think, I suppose that the Secretariat is blocking it out due to the Protection of Personal Information Act. So it's not a case of candidates not disclosing it. It's because we're not allowed to disclose their private information to the public, which we are basically.
Well, maybe that's an issue that would come after. The first question would be whether the candidate did put it in, but the Secretariat decided not to include it.
Yes, no,
maybe...
I do, sorry, Chief Justice. No, I do have it on the, on the form.
Oh, you had included it?
Yes, the Commissioner might be right.
But you had included it?
I have my form, yes, with that,
okay.
with that disclosed.
Well, maybe let me ask, Secretariat, is that what you have done? But in respect of everybody or on the son? Oh, okay. Well, at least if you had told us, we would not be asking.
I thought there was something...
Well, I know that in February, I had not included mine, but I had given a reason why I had not included my address. So here I was also wondering, but now we know. Okay, all right, thank you.
Thank you for that explanation. Premier, I thought the Eastern Cape was somehow special, you know, because the others have disclosed their addresses. But having said that, Chief Justice Advocate Podgita, I take it that you mentioned hometown.
Yes.
So you were born in the Eastern Cape. Are you currently residing in Quebec?
No, Commissioner is born and bred in the down there. I only came to the Western Cape when I had to come study. So as I said, my entire family is down there. I've got property down there. I've got property in Cape Town, of course, where my wife and sons are. So I've maintained the link to.
So it would be a move for you. If you are appointed, it'd be a move.
Yes, indeed. I mean,
to live in Quebec.
It's just the two of us, my wife and I. I've got adult sons, practicing lawyers, so they out of the house. Wife and I will go.
No,
she'll
great.
be very happy because she'll be back home as well.
Oh, lovely. Thank you. Yeah, and just a comment, Chief Justice. I see JP Mbenenga has mastered the art of persuasion. Because
yes.
it's deja vu when one considers how he got here. And I think some of us who've been here long enough know how he got here, through persuasion, through being persuaded. No, thank you very much, and good luck.
Thank you, Commissioner.
Thank you. Let me check commissioners attending virtually. Are there any commissioners who have a question? Those attending virtually?
Nothing from me, Chief Justice.
Nothing from you. Thank you. Commissioner Barnett? Nothing from...
Nothing from me, CJ.
Thank you. Nothing from Commissioner Breitenbach as well?
Nothing
also
from me, nothing from me, JP, CJ.
Oh, yes, thank you, Commissioner Lepu. And I see Commissioner Lucas is online as well.
I'm also fine, thank you.
Okay, all right. Thank you. Commissioner Nyambi.
Thank you, CJ. It's one question. Actually, it's since we have been here, CJ was struggling when he's asking people, candidates, about some significant dates. And you made myself to be jealous when they ask you about dates, and remember even the day. That was great. But there's one issue, the LSSA regard you as a person of moral character and integrity, and it's part of the criteria that we seriously consider when looking at candidates. And they also touch your history when it comes to human rights activism and your involvement in the struggle for democracy and your commitment in the protection of human rights. They say it's beyond reproach. We know that Eastern Cape is vast and rural. Maybe something that you think stand out that you'll immediately address as you have acted for some time in the Eastern Cape when it comes to those rural people, when it comes to access to justice with your appointment as a judge. Because the issue of access to justice, you know very well, is still a challenge in our country, and especially in a vast and rural province like Eastern Cape.
Yes. Yes, no, that is important, very important. From the perspective of a judge, of course, you are somewhat restricted in what you are able to do, but I believe that one of the positive spin-offs of the pandemic is that we have accepted that there are different ways of doing things. I believe that dealing with matters even over a distance in such a way as not to inconvenience, cause people to be out of pocket is the way to go. That to my mind should be the something of the future. In fact, of course, this type of thing has been happening a long time ago overseas. Canada is a very good example of creating access through technology, through innovation, etc., etc. So I believe we must continue down that road, and that is a sure way of bringing the court to the people, or at least closer to the people. So that is one thing that I can think of, Commissioner, in terms of what, as a judge, you can facilitate.
Thank you, Advocate Potgieter SC. Thank you, CJ.
Thank you, Commissioner. There are no further, oh, there is one more. Oh, are there two? Okay, let me just, it's Commissioner Schlemmer.
Thank you, CJ. Good evening, Advocate. Could you tell us what your judicial philosophy is, please?
Commissioner, that a question one must, I believe, necessarily answer in a bit of a roundabout way. I don't approach matters or the work in a preconceived stance or having decided beforehand on a particular philosophy. I know there are various tags that are given to this, but perhaps I can just explain how I go about doing the work. I approach every matter that I've got with an open mind, firstly. I'm sorely aware that you've got to be meticulously impartial. I determine the facts, establish and determine the facts and the law, including as the beacon, the provisions of the Constitution, any statutory text that is applicable, and any legal precedent that applies. And then, having gone through that, I strive as best to dispense justice in the matter. Now, I know there are various sort of tags. You get instances where it is said that some judges are activists, judicial activism. Others with a judicial restraint. There are judges that are said to be judicially minimalist, etc., etc. I'm not quite sure. It's probably for analysts that look at the judgments that I write to put a label on that. But I believe that if you adopt that attitude and you are constantly aware of the values and the principles that underpin the Constitution, and you strive to promote that, then your judgments will probably be automatically transformative, and they could even in some respects be activist. But as to setting out with a particular pre-decided philosophy, that's not really the way that I approach the job. That's the best that I can do, Commissioner.
That was good enough. Thank you very much.
Thank you.
Minister, I'm sorry, Minister. Commissioner Klaba, I'll come later.
Thank you very much, CJ, and good afternoon, Advocate Porgetin.
Good afternoon, Commissioner.
CJ, my first question has been covered by Commissioner Singh.
Yes.
And I'm satisfied that the candidate has plans to relocate back to the Eastern Cape.
Yes.
And I also note that the candidate has an impressive CV, and his contribution to the development of our legal jurisprudence and his commitment to the protection of human rights has been acknowledged by the various professional bodies.
Yes.
And I wanted just to say that, CJ, thank you so much.
Thank you. Thank you.
Thank you, Commissioner.
Commissioner Moimang.
Thank you, Chief Justice. Good evening, Advocate.
Evening, Commissioner.
One aspect from my side, in line with one of the criteria, your experience in regard to the values and needs of the community. There has been a clarion call against the need to prosecute those people that were not granted amnesty during the TRC hearing. I see that you were the deputy chairperson of the Amnesty Committee at the TRC. How can you assist both the law enforcement agencies to ensure that that chapter is closed? Because it is beginning to rear its head, particularly given the fact that if you are successful, very soon you'll be on the bench. So it means your time is a bit limited, or if you have had any interaction with either the Hawks or the NP with regard to this chapter. Thank you, Advocate. Thank you, Chief Justice.
Thank you, Commissioner. That's a sore point for those of us who have done that work. I don't want to blow our bugle, but we have invested a lot of effort and resources. The country has invested a lot of resources in that exercise. So we were meticulous to make sure that when we close the commission, that whatever we had in our possession, that in our judgment would facilitate dealing with those cases where amnesty was refused, was in fact provided to the prosecuting authorities. And we had offered our assistance if it was needed to clarify anything in order to facilitate that process going forward. As the Commissioner would know, there has been various arguments as to why that hasn't happened. Unfortunately, I'm not qualified to enter that arena. But I can say that there's absolutely no, and there's never been any reason why that exercise was not proceeded with. Those perpetrators have passed on in the meantime, which was inevitable. I mean, it's, with a delay. So some of them are just not there anymore, but there are others that there's more than enough to proceed with. And I think I can speak for the rest of my colleagues on is that the offer of assistance still stands, and it's for the prosecuting authority to take up that offer. It will stand for so long as it is needed. So that's where we are, Commissioner. It is one of the things that makes me unhappy about that process.
Thank you, Advocate Potgieter. Thank you, Chief Justice.
Thank you, Commissioner. I believe there is only one further hand now, that is the Minister. Minister?
Thank you, CJ. I think my question was taken by Commissioner Moimang. I can just note that I see Advocate Potgieter, we are matching with ties today. I hope I won't be accused of having influence and acting judge.
No, you've got good taste, Minister.
We have come to the end of this interview. It remains for me to once again thank you, Mr. Potgieter, for availing yourself for consideration. If you have 2 or 3 points that you wish to emphasize for special consideration by the commissioners when they consider your candidature, I give you about 2 or 3 minutes to articulate those points, but if you feel that all issues that needed to be addressed have been addressed adequately, that is fine as well.
Chief Justice, perhaps I can just say that when I acted for the first time, I realized that you actually you must be ready to fulfill this role. And some of the more senior judges that I interacted with told me, look here, you would know when you are ready to do this. Well, I believe that I've reached that point, Chief Justice. I'm ready. If I'm called upon to make this contribution, I'll be delighted to do it in Port Elizabeth, in Gqeberha. It would be an honor to be appointed in that court. Thank you.
Thank you very much, Mr. Potgieter. Once again, thank you for availing yourself. You are now excused.
Thank you, Chief Justice.
Thank you
and
very
Commissioners.
Much. Thank you.
Good luck, Denzel.
Oh, I see. Thank you.
The media will be going out. Should we take a 5 minutes break and come back? Okay, let's take a 5 minutes break and then come back. Okay.